ಓಕೆ ಸಿದ್ಧಿಯೋಕೆ ಭೂತದ ನಂಬಿಕೆ ಭಾಳ.
ಭೂತದಂತೆ ಭಾಳ ನಂಬಿಕೆ ಇದ್ರೆ ಅವರಿಗೆ
ಟ್ರೈಬಲ್ ಕಲ್ಚರ್
ಒಂದು ಹಂತದಲ್ಲಿ ಒಂಥರ ಮುಗಿದ್ರು ನಂಬುತ್ತಾರೆ ಏನು ನಮ್ಮ ಪಾಠಕ್ಕೆ ಹುಷಾರಿಲ್ಲ ಅವ್ರು ಒಂದೊಂಥರ ಇದು ಮಾಡಿ ತೀರ್ಚು ಮಾಡಿ ಅವರು ತಲೆ ಎಲ್ಲ ತೀರ್ಚು ಆ ಥರ ಇದು ಮಾಡಿ CPM.
ನಿನ್ನೆ ಎರಡೂವರೆಗೆ ಯಾವುದೋ ಒಂದು ಡೆಮಾಲಿಷನ್ ಮ್ಯಾಟ್ರ್ ತಗೊಂಡ್ರು. ನಿನ್ನೆ ನಮ್ಮದು ಎರಡು ದಿವಸ ಮಾಡಿಲ್ಲ ಅದು 230 ತಗೊಂಡ್ರೆ ಏನೋ ಒಂದು ಆರ್ಡರ್ ತಗೊಂಡ್ರು ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ಮಾಡಲಾಗ್ತಿತ್ತು. ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಚಾರ್ಜ್ ಮಾಡಿ ಅದು ವಾಟ್ ಈಸ್ ದ ಅಪ್ಲೈನ್ಸ್ ಅಂತ ಹೇಳ್ತು ಇನ್ನೂ ಮಾಡ್ತಿದೆ ಅವಕ್ಕೆ ಮೇಲೆ ಬರ್ತು. ಓಕೆ ಕ್ಯಾಶುವಲ್ ಅನಿಸ್ತು ಅಥವಾ ನಮ್ಮದು ವಿನಾಕಾರಣ ಆತಂಕ ಅನಿಸ್ತು ಅಥವಾ ನಾವು ಎಕ್ಸಾಜರೇಟ್ ಮಾಡ್ತು ಅನಿಸ್ತು. ನೋಡಿ ಆಲ್ವೇಸ್ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ಅವರು
ನಾವು ಹಳೆ ಕೇಸನ್ನು ಹಾಕಿದ್ದು ರೀಸನ್ಸ್ ಹೇಳಿ ವಿಡ್ರಾ ಮಾಡ್ತಿದ್ದೆ. ಅದಕ್ಕೆ ಹೊಸ ಆರ್ಡರ್ ಬಂದಿದೆ ಅಡ್ಮಿಟೆಡ್ ಅಪಾಯಿಂಟ್ ಹೊಸ ರಿಪಿಟಿಷನ್ ಹಾಕಿದ್ದ ಅದೇ ಇದು ಮಾಡ್ತಿಲ್ಲ. ಹೌದು ಡೇಟ್ ಒಂದು ಸಣ್ಣ ಇದು ನೋಡ್ತಾ ಇದ್ದೆ. ಒಂದು ಡೇಟ್ ಇದು ಒಂದು ಟೈಪು ಇತ್ತು ಒಂದು ಕಡೆ ಮಾಡಿ ಕಿರಣಿಗೆ ಹೇಳಿದ್ದೆ ಕರೆಕ್ಷನ್
18 ಫೈಲ್ ಮಾಡಿ 17 ಅವತ್ತು ಎರಡೂವರೆ ಮೂವ್ ಮಾಡಿ ಆಯ್ತು.
ಹೌದು ಹೌದು
ಈ ಕೋರ್ಟ್ ತಗೊಂಡ್ವಿ ಹಂಗಿಲ್ಲ ಇದು.
ಹೌದು 2026 ಅಪ್ಪ ಬದಲೇನೋ ಟೈಪ್ ಆಗಿದ್ದಾರೆ 22-26 ಅಂತ
ತಪ್ಪಾಯ್ತು
22-26
ಮತ್ತೆ ನಾವು ಪ್ರೂಫ್ ರೀಡಿಂಗ್ ಮಾಡ್ಕೊಳ್ಳೋಣ.
ಹೌದು
ಪೇಪರೆಲ್ಲ ಪ್ರೂಫ್ ರೀಡಿಂಗ್ ಮಾಡ್ತಾರೆ ಅದು ಮಿಸ್ಟೇಕ್
ಸಹಜ. ಬಟ್ ಅದೆಲ್ಲ
ನಮ್ಗೆ
ಇದು ಮಾಡ್ತಾರೆ
ಸಣ್ಣ ಸಣ್ಣ ವಿಷಯ
ನೋಡ್ತೀವಿ
ನಾವು ಆದಷ್ಟು ಮಾಡಿ.
ಹೌದು ಆದಷ್ಟು ಮಾಡಿ
ಇಲ್ಲೇ ಫಿಲ್ಟರ್ ಮಾಡ್ಬೋದು ಫಿಲ್ಟರ್.
ಹೌದು ನಮ್ಮದು ಒಂದು ಸಿಸ್ಟಮ್ ಇದ್ದು ಲ್ಯಾಪ್ಟಾಪೇ ಆಗಲದೇ ಇತ್ತು ಸ್ವಲ್ಪ ಹಳೇದು. ಅದು ಪ್ರೂಫ್ ರೀಡಿಂಗ್ ಮಾಡಿ ಇದು ಮಾಡಲೆಲ್ಲ ತೊಂದರೆ ವರ್ಕ್ ಮಾಡಲಿಲ್ಲ ಮಾಡ್ಕೊಂಡು ನೆಕ್ಸ್ಟ್ ಡೇ.
ಮತ್ತು ಇವರು ಅವಾಯ್ಡ್ ಮಾಡ್ಲಾಗ್ತಾರೆ ಇದು ಫೇಸ್ ಮಾಡಿ ಗೌರ್ಮೆಂಟ್ ಎಲ್ಲ ಇಂಥ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ MLA ನಿಂತು ಮಾಡಿಸ್ತಾ ಇದ್ದಾಗ
ಹೌದು
ನ್ಯಾಯ ಸಿಕ್ಕಲಿ ಪೊಲೀಸ್ನವರು ಎಲ್ಲ ಒಂದು ಕೈಲಿ ನನ್ನ ಕಿಶಲ್ಲೇ ಇಡೀ ಸ್ಟೇಟ್ ಮಿಷನರಿ ಒಂದು ಕೈಲಿ
ಹೌದು
ಏನು ಬೇಕಾದ
ಹೌದು
ದರ್ಪ ಇಷ್ಟು ತಿರುಗಾಟ ಹಾಕೊಂಡಿದ್ದೀವಿ ಭಾಳ ತಿರುಗಾಟ ಮತ್ತು ಟೆನ್ಷನ್ ಆಗುತ್ತೆ. ಮನೆಗಳು ಮಲಗಿದ್ದೆ ಅಂತ ಮಾಡಿದೆ.
adjudicate the matter, my lords. Retrospective application,
Adjudicate.
my lords, before your lordships, my lords.
It has to go before that court. You can move the court.
My lords, but
Really,
my lords, Monday, my lords,
list Monday, Ali cards.
please, my lords.
One matter for 230. One of an order under section 55 of the police
It'll be more than happy.
Hmm.
Out of 8 times,
You have been heard?
You couldn't mention,
No. Monday. third.
mention, not remove. But now mention.
Go to the cyber command.
Matter was registered yesterday at serial number 101. Now it's adjourned to 11th of September. We got this urgency, my lord.
Go to the cyber command. They'll try and help you
Part
out.
of the cybercrime, and despite that, I've visited the headquarters and made my representation.
Mr. Counsel, we can't do anything in these matters.
My lord, it's not been considered, my lord. That's why, my lord.
You want us to dismiss it, we'll dismiss it, allowing you to go before the concerned court where the criminal proceedings are there.
My lord, I've gone before the cyber.
Cody.
headquarters. Monday, my lord.
Next week, Yavatar.
Fresh matter.
With respect to insolvency, my lord, the proceedings have been stalled. There's an interim order. my lord.
Insolvency.
NCLT order, my lord. NCLT order. Interim order.
NCLT order has been stayed by this court.
Yes, my lord. CM does. CM RE.
Third, next week, third.
My lord, I have also filed my this early hearing application, my lord. There's a IFO.
It'll come in seniority, madam, that's all. But
My lord,
My lords, we have challenged LOC in this case, my lords. My lords, the coordinate bench has granted anticipatory bail with the direction for us to appear within 15 days.
is a fresh matter or pending matter?
Well, a fresh matter, my lords.
Kodi, Bharat.
Lordship, my grocery shop is closed for the reason that there is no 40-feet road, my lord. All my
No?
grocery, there is no 40-feet road.
What?
Grocery shop is closed for the reason that there is no 40-feet road, my lord.
40 feet road, yes, it'll get closed.
All my groceries are inside. It's been 20 days.
You want to remove it,
I want to remove the grocery. Kindly have to
Sorry,
do
next.
that, my lord, please. It's 20 days, my lord, since.
but you want to cook something at 2:30 or?
What
Next.
slats of groceries inside, my lord. Kindly, my lord.
I have appealed for the.
We
And
can
they
take
have
it up
2:30.
in the afternoon?
Yes.
We can take it up in the afternoon?
Let it be taken on Monday, my lord, but I will make my
Monday.
objections.
Would it be, my lord, 2:30 minutes?
He is also asking for Monday, we are also telling.
Some
him
emergency, my lord, Tahsildar breaks open the
ಕೊಡಿ,
lock and
ಅದನ್ನ
takes
ಅವ್ರಿಗೆ
possession.
ಮಂಡೇ ಇಷ್ಟ ಇಲ್ವಂತೆ ಅವ್ರಿಗೆ 12th ಅಕ್ಟೋಬರ್ ಕೊಡಿ. ಎಸ್ ನೆಕ್ಸ್ಟ್.
Monday, my lord.
BWSSP ಅವರು ನಮ್ಮ ಪ್ಲೇಸ್ ಅಲ್ಲಿ ಬೋರ್ಡ್ ಹಾಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಮೈಲಾಡ್ ರಿಮೂವ್ ಮಾಡಿ ಅಂತ ಆದ್ರೆ ಕೋರ್ಟ್ ಕಡೆಯಿಂದ ಆರ್ಡರ್ ಮಾಡಿಸ್ಕೊಂಡ್ ಬನ್ನಿ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ. ರೆಸ್ಪಾಂಡೆಂಟ್ ಗೆ ಆಲ್ರೆಡಿ ನೋಟಿಸ್ ಕೂಡ ಸರ್ವ್ ಆಗಿದೆ.
ಏನ್ ಮಾಡಿದಾರಮ್ಮ?
BWSSP ಮೈಲಾಡ್
ಏನ್ ಮಾಡಿದಾರೆ BWSSB?
ನಮ್ ಪ್ಲೇಸ್ ಅಲ್ಲಿ ಅವರು ಬೋರ್ಡ್ ಹಾಕೊಂಡಿದ್ದಾರೆ ಮೈಲಾಡ್.
ನಿಮ್ ಪ್ಲೇಸ್ ಬೋರ್ಡ್ ಹಾಕೊಂಡಿದ್ದಾರೆ?
ಎಸ್ ಮೈಲಾಡ್.
ಅಕ್ವೈರ್ ಮಾಡಿದಾರಾ?
ಅಕ್ವೈರ್ ಮಾಡಿದ್ದಾರೆ ಮೈಲಾಡ್. ಕೈಂಡ್ಲಿ
ಅಕ್ವೈರ್ ಮಾಡಿದಾರಾ ಮಾಡಿಲ್ವಾ?
ಮೈಲಾಡ್.
ಮತ್ತೆ ಹಾಕೊಂಡ್ಬೋದಲ್ಲ ಅವ್ರು ಮಂಡೇ
Kindly
ಟ್ಯೂಸ್ಡೇ.
Order passed by MSL Council, my lord.
ಹ್ಮ್
Violation of section 18 is covered by
ಕೊಡಿ. ಎಸ್.
ಸ್ವಾಮಿ ಇದ್ರಲ್ಲಿ ಪಿಟಿಷನರ್ ಸ್ವಾಮಿ ನಾವು ಇದ್ರಲ್ಲಿ ಅಕೌಂಟ್ ಡಿಪ್ರೀಸ್ ಆಗಿದೆ ಅದಕ್ಕಾಗಿ ಮಂಡೆಗೆ ಹಾಕ್ಬೇಕು ಅಂತ.
ಏನ್ ಅಕೌಂಟ್
ಡಿಪ್ರೀಸ್ ಮಾಡೋದಕ್ಕಾಗಿ
ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್?
ಪೆಂಡಿಂಗ್.
ಸೈಬರ್ ಕಮಾಂಡ್ ಹೋಗಿ ಆಮೇಲೆ ಅಲ್ಲಿಂದ ನಿಮ್ಗೆ ಹೆಲ್ಪ್ ಮಾಡ್ತಾರೆ ಅವರು.
My lord, it's a
Yes.
pending tender matter, my lord. I filed my including application.
Pending matter will come in seniority, madam.
My lord, this is a
My lord.
Matter for hearing an IF for vacating the interim order.
It will come in seniority.
My lord.
Urgency, my lord, sir.
Everybody has urgency.
Vacated the interim orders granted by this honorable.
We
court.
can't spend time, unfortunately, to consider which is more urgent than the other. So it will come in seniority.
My lordship, it's a fresh matter, my lordship. There is a government order regarding to the fire and safety complaints, my lordship. Putting the danger to the.
Kodi for Bharat, every third day it
Fresh
comes.
matter, Monday.
Kodi, Bharat.
fresh
My lord,
Well,
the petitioner working in the respondent bank in the initially 15 days, my lord.
The wrongly mentioned the service data and the
Fresh matter.
fresh matter, my lord.
Kodi
Kindly
ipa.
hang on Monday, my lord.
It will come. Yes.
My lord, I'm appearing as a party in person.
Huh.
The notice is already served. I need this crucial information. This is requested via RTI information.
It
My
will
lord.
come in
Can this
seniority.
be-
If it's a pending matter, it will come in seniority.
Can this be listed on Monday, my lord, please?
It will come in seniority. If a date is given, it will come on that date.
Pending matter under
Thank you, my lord.
Citizenship Act.
Again, pending matters.
Seniority Act, it has been.
Mr. Counsel, we don't have patience to do this. Or if you want,
Date may be fixed.
if you want us to be hearing each of you, we'll do this till 1 o'clock.
Any date may be fixed.
We won't take up the regular matters. We'll be doing this.
Apologize.
We have told all of you, all pending matters will come in seniority. It will come in seniority. How much ever time you mention it. Don't waste the time of everybody.
EM police matter, my lord. 650 rupees fraud and transfer, entire account has been freezed. Balance is 15,000.
Fresh matter up
Fresh
pending.
matter.
Kodi. What is the urgency for 650 rupees?
But entire account is freezed. Gas store repair shops, I mean, every day earn more than 500 rupees.
All matters are going to come in 3 days' time.
Please.
They are coming in 3 days' time. Any doubt? Yargo doubt illa tane. Emergency in dispossession, no, demolition. Some of those you move it. We'll take it up at 2:30. Otherwise, they'll come in 3 days' time.
My lord, GM police matter, the court had directed account to maintain 10 crores. However, due to we are unable to pay the salaries, therefore we have filed an application for reduction of the lien amount. It may be posted on Monday for you.
Lien amount we cannot reduce. It has to be by that court.
My lord, it has to be heard before the roster bench before it can be moved before the appropriate bench. It has to be heard first here before the roster bench before, and only once your order records it will be.
Any order on the lien will have to be passed by the criminal court seized of the matter, not by this court.
My lord, this court has directed the lien amount.
Right. Kodi. Yes.
Lord, one submission, my lord. KPSC chairman's matter, my lord, will also surpass the judgment. Would the operative portion be uploaded online, my lord, because we have the.
It will be uploaded in the lunchtime.
By lunchtime.
We have a little more pages to sign.
Please,
We'll just sign it and afternoon it will be uploaded.
Please, Lord. Grateful.
Yes, Mr. Jogra. Pertains to? Oh, one more. Tuesday 3rd.
Malad 45, Malad. Next week, Malad.
45. Inform ಮಾಡಿದ್ದೀರಾ?
On Swami.
At the request of counsel for the petitioner, released on 16th September.
Lord, serial number 48, my lords. Inform the others, the government.
Year for?
For the petitioner, my lords.
At the request of counsel for the petitioner, released on 16th September.
Serial number 55, my lords. I'm for the petitioner. Serial number 55. 55. I'm for the petitioner, my lord, seeking for a short accommodation.
Karnataka State Medical Supplies Corporation, Sumana Baliga. Ms. Sumana Baliga is directed to accept notice for respondent number 2, counsel for the petitioner to serve 2 sets of the petition along with annexures on the said counsel, released on 16th September. Interim order earlier granted is extended till next date.
Wait.
Hmm. 85 memo for withdrawal, dismissed as withdrawal, IA 1 of 24 allowed.
87.
87.
87 and 87.1.
I
filed the memo for withdrawal.
87 memo for withdrawal, 87.1 memo for withdrawal, pending IA stand disposed.
89 memo for withdrawal. I filed memo.
89 memo for withdrawal, dismissed as withdrawn.
Serial number 80, my lords. It's a fresh matter file, my lords, but as been listed again in the B group, my lords. In the previous date, I made my submission, my lords. It's a fresh matter, my lords. This court has directed that it has to be listed a fresh matter, my lords, but again listed in the
80 relist in preliminary hearing
my lords, let the
on
matter be
Tuesday.
listed today, my lords. taken up today, my lords. The urgency in this matter.
If
my
it reaches, we'll take it up, otherwise we'll give you a date. So you want a date or you want to wait?
At least direction shall be given. It will be listed in the. fresh
Please
matter,
wait,
my lords.
then bada.
Please.
Yes.
This number two, serial number 2. There is a substantial development in the mediation. Can it be taken up next Thursday, Miller? I have informed. That's right.
Oh, this one.
Yes, Miller. There is a substantial development in the mediation.
You appear. So when will it close?
Next Thursday, Miller.
Next Thursday. Both the councils submit that the mediation has gone on effectively. Next week you will report settlement.
It's likely to be settled.
And there's a likelihood of a settlement being reported if it is taken up on 27th, relist on 27th. PM.
Memo for posting. In this matter, the petition, the proceedings before the ED was, before the special court in ED's matter was stayed on the basis that the predicate of
Pending matter.
Pending matter, but my lord, my lord, one submission. My lord, those petitions have been dismissed. Now by virtue of that, my lord,
It will come in seniority, Mr. Unikrishnan. Everybody wants their matter to be, whatever we can take up, we'll take.
Please, after next week, some one date, any.
In seniority.
Yes, madam.
Yes.
So, my lord, the respondent number 3, Subramania Police have registered a opened a rowdy sheet against the petitioners. Petition 1 and 2 are the brothers. We need to harass the petitioner. I produce the annexure A and 3. There are 10 cases, several cases. They are involved in several cases, but they have registered. So almost
all cases are disposed.
But 8 matters have been disposed.
How many are pending?
Please, my lord.
How many are pending?
2 cases are pending.
AG accepts notice for respond number 1 to 3. Seeks for and is granted 10 days time to obtain instruction, make a submission, relist on 16th September.
Parole matter.
Parole. And AGA for response 27th.
Wait for
In this matter, petitioners approached the 5th respondent, who is the ASI, explaining their problems. After hearing the grievances, Your Lordship, the 5th respondent has advised that he will be registering an FIR. Thereafter, Your Lordship, he made them to go to their office for continuously for 3-4 days, Your Lordship. Then he told, ಬರೀ ಕೈಯಲ್ಲಿ ಅಲ್ಲಾಡ್ಸ್ಕೊಂಡು ಬಂದ್ರೆ ಆಗಲ್ಲ, ನಮ್ ಕೈ ತುಂಬಿಸ್ಬೇಕು ಅಂತ. ಅವಾಗ
ಯಾರು ಹೇಳಿದ್ದು?
Please, Your Lordship. ASI, the 5th respondent. We have paid him 3 lakhs, Your Lordship, at the initial stage.
You paid him?
Yes, Your Lordship. In fact, we have a proof also.
Good. You also will get prosecuted for that.
No. Thereafter, Your Lordship, he is saying we have no jurisdiction to lodge an FIR. In fact, he has collected 5 lakhs from us.
Investigate the petitioner also. Bribe taker and bribe giver both. 3 lakhs ಕೊಟ್ಟು ಕೆಲಸ ಆಗಿದ್ರೆ ಸುಮ್ಮನೆ ಇರೋರು. ಕೆಲಸ ಆಗಿಲ್ಲ ಅಂತ ಬಂದಿದ್ದೀರಾ?
No. Since they have demanded, Your Lordship, we had no.
They have demanded, you have paid. If the work had happened as you wanted it, then you would not have come before us. You have paid, now work has not happened, that is why you are before us. So good that you have come, you have brought these details to us.
See, Your Lordship.
And AGA accepts notice for respond number 1 to 5. The submission of Learned Counsel for the, who have you paid 3 lakh of rupees?
Your Lordship, it has paid through, in cash, Your Lordship, we have paid directly to the respond number 5.
Respond number 5.
Yes, Your Lordship. Some payment has gone through PhonePe also to one advocate. Through him, it has been
Cash by 3 lakhs to respond number 5. Phone pay list pay madidira?
4.5 lakhs it has gone through.
4.5 lakhs to?
Respond number 5.
Respond number 5.
Yes, Your Lordship.
Yes.
And 50,000 has gone through PhonePe.
50,000 to?
To one Mr. Babu Abel.
Babu?
And then from him it has gone to the respondent.
Please give the full name, Babu?
Babu Abel, ABEL.
ABEL.
Yes.
Who is Babu Abel?
He claims to be an advocate, Your Lordship, through whom only we have approached. The petitioners have approached.
He is the middleman.
Yes, Your Lordship. Page number 22.
Land AGA accepts notice for respondent 1 to 5. Submission of learned counsel for the petitioner is that the petitioner had paid a sum of rupees 3,00,000,000 by cash to respondent number 5 and a further sum of rupees 4,50,000,000 by way of phone pay to respondent number 5.
4,50,000 by way of cash, 50,000 through phone pay.
3 lakhs and
Total 5 lakh. Initially, we had paid 3 lakhs in cash. Subsequently, 1.
3 lakhs in cash and then 1,50,000 by phone pay.
No, again in cash. Subsequently, then
Total amount of 4,50,000 in cash to respondent number 5. Amele?
then 50,000 to one Mr. Babu Abel.
And a further amount of rupees 50,000 to one Mr. Babu Abel. You have his details?
Yes, I have produced it also.
Page?
Page number 22 and 23. Your Lordship.
22.
22 is the amount paid to Babu Abel. From him, it has gone to the Shafi, that CCB office.
They're saying Shafi CCB office.
Yes, Your Lordship. Who is the fifth respondent?
The previous page, my lord.
Babu Abel with his phone number +917411 593 547, who claims to be an advocate, which is transferred by him to Mr. Mohammad Shafiullah Samiullah. The mobile number +91 968 6613 The submission of learned counsel for the petitioner is that the said amounts had been paid by the petitioners to respondent number 5 for the purpose of registering a complaint against certain landowners who had allegedly
Cheated.
defrauded the petitioners. Despite the said payment, respondent has not registered the respondent number 5 has not registered the complaint, and in that background that the petitioner is before this court. There being serious allegations which have been made, the same would be required to be investigated. The sub-inspector police would come under Upalokaayukta. Upalokaayukta. The Upalokaayukta, the Honorable Upalokaayukta, the Registrar Judicial is direct forward a copy of the above petition to the Honorable Upalokaayukta. The Honorable Upalokaayukta is requested to look into the matter and carry out necessary inquiry, investigation or the like at his discretion and submit a report in regard thereto within a period of 4 weeks from today. Released on 28th September. Carry out investigation both as regard the petitioners and the respondents.
My lord, petitioner was into a family business of supply of plastic materials, plastic packaging materials and food packaging materials, my lord, since 1993-94. But later on, my lord, in 2011, those plastic materials came to be banned by the government, my lord, because of obvious reasons.
Plastic rules.
Please, my lord. And then I was asked by the Mahanagarpalika officials to join hands with them to inculcate awareness in the public and also the people who were dealing with these plastic materials, my lord, against the banned materials. I switched over to the safer plastic materials and paper materials for the same. But there were others also who were in the same business, but they became vested interests who continued to do the same business with the banned plastic material because it was lucrative, my lord, because it was also unaccounted for. And then they started harassing me. And between 2015 and 2025, they have filed so many frivolous criminal complaints against me, my lord. The design is such, my lord.
One of the complaint, what is the allegation made?
Lord, usually they are under section 504 and 504 of IPC, Lord. And when BNS was introduced, it is under section 79 and section 315 and 318, 115 and 118, my lord. In one such case, my lord, only one criminal case has after trial come to fruition. And in that case, my lord, I am exonerated because one of the complainants was fictional and the honorable court has taken notice of that, my lord. My lord, now 7 more cases are still pending, but they have opened a rowdy sheet in my name, my lord, clandestinely in the year 2020, which came to light only in 2023 when I was campaigning for one candidate in the Legislative Assembly elections, my lord. I was summoned to the police station and then I was warned that I would be immediately arrested if I continued campaigning in the elections.
You are a busy person.
Please, my lord, that is true.
Let AG accepts notice for respond number 1 to 4. Seeks fund is granted 10 days time to obtain instruction. Make a
My
submission.
instructions are that nearly 8 cases are pending.
Well, it in,
7 are pending.
there seems to be more than what is being
But
said.
I pray for an interim order also.
Released on 9th September.
Grateful, my lord.
Yes, Vijay.
Lord, sought for quashing of annexure A. Lord, the order of the deputy registrar, district registrar of stamps and registration, whereby is imposed
5E2. And AGA accepts notice for respond number 1 and 2. Issue notice to respond number 3, returnable by 28th September.
Lord, interim order, my lord, because 10 times is very arbitrary. Lordship's rich experience. And he has to record a reason, my lord, before imposing such penalties. It's settled position of law. He doesn't even 4 lines order, my lord.
Now the judgment is there that there is no discretion.
My lord, there is subsequently also some judgments which
Show
I
the judgment.
Till next
There's
hearing.
no discretion. So if there's no discretion, there's no reasoning required.
No, there are judgments that say that there has to be a deliberate, evasion
Earlier.
was there.
That was 2011 and 12 judgment. After that, the latest judgment
I'll
is
also look into it.
no discretion. So if discretion is there, they have to give reasons.
Yes.
There's no discretion, why reasons?
That of course, my lord, but I'll also look into the latest case. There can be, if an interim order is there, they'll respond faster is my
We don't have the judgment with us.
Very
right
well.
now, otherwise.
No, but no interim order is required because, my lord, unless he pays, they will not act on it. The document
That's
is
all.
imported anyways.
It
If
can't
he has
be
to lead
used.
the evidence, then he'll have to get it.
It can't be used. Mr. Pavan?
Minutes, I appear for petitioner minutes. Minutes, start for defreezing of account minutes. Lien amount is only 5. Please.
Lien account, defreezing a lien?
No, defreeze minutes. Please.
Canara Bank? PP Mutharna for 1 and 2, notice to respond number 3 is dispensed with. Petitioner is directed to appear before the Cyber Command on 20. Ivatte ಹೋಗ್ತೀರಾ?
Minutes, tomorrow.
Tomorrow, it's only on Thursday. Today or 27th?
27th.
27th. Relist on 15/9.
Deeply obliged.
We are for seeking for a mandamus, my lord. Lord, it's a land acquired which is dropped, my lord, in the final notification itself. My land is not acquired. Lord, now they want to pass an award, my lord, as per.
How will this come up before us?
I had filed it as land acquisition, my lord. The registry has classified it as GM. So I don't have any grievance anywhere.
The peril of the papers indicates that the matter relates to land acquisition. Registry is directed to reclassify the matter properly and place it before the appropriate bench.
I had filed it as LA only. I don't- But registry, we can't.
ADB ನಮ್ಮ ಹತ್ರ ಇದೆ. LA KDB is not before us.
Oblige.
The present petition is covered by order of this honorable court. In a batch of connected matters, my lords, the petitioners are in rental premises of the respondents. And during the period of COVID, there are certain rebate given to them.
That batch is being considered still.
No, my lords. Through the impugned notification, they sought for repayment of the rebate amount that they had provided during the COVID period. There are batch of connected matters, my lords, where the interim order is also subsisting. They are
The
pending
interim
consideration.
order is there, yes.
Yes, ma'am. They're pending in consideration.
When you say covered, it is disposed.
Sorry.
Who had appeared in that? Mr. Surana has appeared?
For respondent 192 BL Sanjeev.
See, BL Sanjeev, ಎಲ್ಲ ನಮ್ಮ ಮುಂದೆ ಕೋವಿಡ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಸುರಾಣ ಅಲ್ಲ ಅಪಿಯರ್ ಆಗಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ. Shri BL Sanjeev is directed to accept notice for respondent number 1 to 3. The respondents are restrained from taking any coercive steps to recover the amount till sought for from the hands of the petitioner till the next date of hearing. Connect with WP number 20426 of 2022.
Great.
Seeking for mandamus, my lord. Directing the
Directing the
fourth respondent, my lord, implement the order passed by direction issued by the fifth respondent, my lord, Anaksharya K, my lord.
What is the direction issued?
Please, my lord, given the police protection to the petitioners, my lord, for cultivating their land. He have obtained the TA also.
Which is the direction? Where the direction? Page number?
41, my lord. Page number 41.
Yes.
Akshat K, my lord. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿತ ಉಲ್ಲೇಖ ಒಂದರಂತೆ ಸೊರಬ ತಾಲೂಕು ಉಪ್ಪಗಡ್ಡೆ ಹೋಳಿ ಚಿಕ್ಕಬೂರು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 86 ರಕ್ಷಣೆ ಕೋರಿ ಪ್ರಭಾಕರ್ ಮಾದೇವಪ್ಪ ಅವರು ಮನವಿ ಮಾಡಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಈ ಕುರಿತು ವರದಿ ಸಲ್ಲಿಸುವಂತೆ ರಾಜೇಶ್ವರ ನಿರೀಕ್ಷಕರು ಉಪ್ಪಗಡ್ಡೆ ಬಳಿಗೆ ಹೋಗಿ ಸ್ಥಳ ತನಿಖೆ ನಡೆಸಿ ವರದಿ ಸಲ್ಲಿಸಲು ಸೂಚಿಸಲಾಗಿದ್ದು, ಉಲ್ಲೇಖ 2 ರೀತ್ಯ ಕುಪ್ಪಡ್ಡೆ ಹೋಬಳಿ ಚಿಕ್ಕಬೂರು ಗ್ರಾಮದ ವಾಸಿಯಾದ ಶ್ರೀ ಪ್ರಭಾಕರ್ ಮಾದೇವಪ್ಪ ಅವರಿಗೆ ಚಿಕ್ಕಬೂರು ಗ್ರಾಮದ 80ರಲ್ಲಿ 4 ಎಕರೆ 38 ಗುಂಟೆ ಜಮೀನು MHR 2016-17 ಅಂತೆ ದಿನಾಂಕ 4/3/2017 ಅಕ್ರಮ ಸಕ್ರಮದಡಿ ಖಾತೆ ಪರವಾನಗಿರುತ್ತೆ. ಅರ್ಜಿದಾರರು ಸಾಗುವಳಿ ಮಾಡುತ್ತಿರುವ ಜಮೀನಿನ ಪಕ್ಕದ ಖಾತೆದಾರರು ಸಾಗುವಳಿ ಮಾಡಲು ತೊಂದರೆ ಮಾಡುತ್ತಾರೆಂದು ಅರ್ಜಿದಾರರು ಹೇಳಿಕೆಯಲ್ಲಿ ತಿಳಿಸಿರುತ್ತಾರೆ. ಕಾರಣ, ಅರ್ಜಿದಾರರಿಗೆ ಸದರಿ ಜಮೀನು ಸಾಗುವಳಿ ಮಾಡಲು ತೊಂದರೆ ಮಾಡುತ್ತಿರುವವರ ಬಗ್ಗೆ ಕಾನೂನು ರೀತಿಯ ಕ್ರಮ ಕೈಗೊಂಡು ಸದರ ರಕ್ಷಣೆ ನೀಡುವ ಕುರಿತು ರಾಜೇಶ್ವರ ನಿರೀಕ್ಷಕರು ಕುಪ್ಪಡ್ಡಿ ಹೋಬಳಿ ವರದಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ರಾಜೇಶ್ವರ ನಿರೀಕ್ಷಕರು ಕುಪ್ಪಡ್ಡಿ ಹೋಬಳಿಯವರ ವರದಿಯಂತೆ ಹಾಗೂ ಉಲ್ಲೇಖ 3ರ ಜಿಲ್ಲಾಧಿಕಾರಿ ಕಾನೂನು ಸಲಹೆಗಾರರು ಜಿಲ್ಲಾಧಿಕಾರಿ ಕಚೇರಿ ಶಿವಮೊಗ್ಗ ಜಿಲ್ಲಾ ಅಭಿಪ್ರಾಯದಂತೆ ಅರ್ಜಿದಾರ ಪ್ರಭಾಕರ ಬಿನ್ ಮಹದೇವಪ್ಪ ಚಿಕ್ಕಬೂರು ಇವರಿಗೆ ಸೂಕ್ತ ರಕ್ಷಣೆ ನೀಡುವ ಕುರಿತು ನಿಯಮಾನುಸಾರ ಕ್ರಮ ಜರುಗಿಸುವಂತೆ ಕೋರಿದೆ.
ಕ್ರಮ ಜರುಗಿಸುವುದು. Where is the protection?
Please, my lord, they have not implemented this order, my lord.
How will the police do any krama? What will they do?
As per the law, my lord, I have obtained the TA also against them.
Is there a direction by the court to give police protection?
Please, my lord. The TA is granted, my lord, as per the Anaksharya, my lord.
TA is only an interim order, Mr. Khan.
Please, my lord.
So you'll have to get permission from the court or direction from the court for grant of police protection.
But here, my lord,
Interim injunction kodalla.
the taluk Tahsildar is the taluka magistrate, my lord. They have given.
There is nobody for these kind of matters.
Please, my lord.
He is not supposed to be interfering in civil disputes.
Because of, my lord, they have disturbed the.
Find out, madam, how he is interfering.
My instructions are that, my lord, orally they have warned the defendants not to interfere. My lords may kindly see page 31. This is the temporary injunction, my lord. Only defendants are restrained from causing interference.
Ad interim order.
Please.
Ad interim order, you go back to the court.
But, my lord, what is our situation, my lord?
Your situation is to go to the court and ask for police protection, not to go to the Tahsildar for that.
Please, my lord, he is the taluka magistrate, my lord.
Good.
On the basis of that only, my lord.
Accepts notice for respondent number 1 to 5. The petitioner is before this court. contending that the jurisdiction police have not implemented the directions issued by the Tahsildar Executive Magistrate. The petitioner had filed a suit in OS number
236 of 23.
236 of 2023, seeking for injunction against the defendants therein. A ex parte ad interim order was granted from causing interference with the obstruction and the possession of the suit-secured property. Thereafter, the petitioner contending that the defendant was interfering with the possession had approached the Tahsildar and Taluk magistrate for taking action. It is rather strange that once the petitioner had approached the civil court, he has also approached the Tahsildar for necessary direction. When the matter is seized off by the civil court, the Tahsildar has issued a instruction to the police to take necessary action without indicating what that necessary action is. When the matter is seized off by a court, the Tahsildar could not have issued such a direction. If at all there is an interference by the defendant, it is for the petitioner to file necessary application for and avail necessary ought to have filed necessary applications for either for contempt or for police help before the said court, which seized of the matter could have passed necessary orders. The Tahsildar, in the opinion of this court, could not have issued such a omnibus vague directions, and those vague directions cannot be directed to be implemented by way of a mandamus. No grounds being made out, petition stands dismissed.
Serial number 10, C.N. Nanja Reddy.
Yes, Mr. Nanja Reddy.
Not appear for the petitioner. So, that the third respondent has abandoned the
41
project.
41.
41.
Where is the
amount they have also stated.
Where is the award passed by RERA?
Innu madilla. It's still pending.
ಮತ್ತೆ ಹೆಂಗೆ ಮಾಡಕ್ಕಾಗತ್ತೆ ಇದು?
What I am told, one second. What I am told now, the special deputy commissioner was directed by the RERA authority to pay the amount. I think entire amount is with the RERA.
Your adjudication,
in respect of other persons, it has been paid.
Correct. Your adjudication is still pending.
It's pending.
So without your adjudication,
admitted it is in annexure FL ಅವರೇ ಹೇಳಿದ್ದಾರೆ abandoned and amount ಎಷ್ಟು ಕೊಡಬೇಕು ಅಂತ ಹೇಳಿದ್ದಾರೆ. I am not saying that.
Assume they are the respondent. Jafar ಅವರು ಕೇಳ್ತಾರೆ admitted ಇಲ್ಲ ಅಂತ.
ಅಲ್ಲ ಅವರಲ್ಲ. Third respondent.
Third respondent. Third respondent ಇಲ್ಲೇ Shetty is there. If Vignesh Shetty, he will appear for him. He will say not. Your adjudication is pending. First get it adjudicated. Shri Gautam Devolal for respond number 1 and AJ for respond number 2, Shri JP Darshan for respond number 3. Petitioner is before this court seeking for the following reliefs. A mandamus is being sought for to recover an amount of rupees 32,87,616 from respond number 3 by respond number 1 and 2 and hand over the same to the petitioner. The petitioner has filed a complaint in complaint number 00585 of 2026, which is still pending consideration before the Real Estate Regulatory Authority. Until adjudication thereof and issuance of a recovery certificate under section 41 of the RERA, the respond number 2 cannot initiate any recovery proceedings, reserving liberty to the petitioner to approach the respond number 2 after such adjudication and obtaining a recovery certificate. Petition stands disposed.
11, Girish P. Baldare.
Girish? Yes.
Appearing for the petitioner, my lord. One minute, my lord. May I request your lordship, direct the RERA that it dispose of the at least appeal.
Appearing for the petitioner, my lord, challenging the so-cause notice issued by the respondent 3, my lords, in the nature of final order, my lords. Lords, mere pendency of the criminal cases
You have to approach on 1726 and you should have filed. You have not gone there.
Please.
You come after 1.5 months to this court.
My lord,
And any orders have been passed or pending?
pending.
I'll just verify, my lord, kindly.
Pass over.
Serial number 12, Chetan B.
Yes, Mr. Raghavan.
Proceedings initiated by the enforcement director and the PMLA is what is questioned before your lordships, my lord. In respect to the predicate offence, as your lordships are aware, my lord, a proceedings under the PMLA has to be on the basis of a proceeding under any other law. And that is called the predicate offence. Now, my lord, the predicate offence in this case, my lord, is subject matter of proceeding before this court. And in WP, my lord, file, even the charge sheet in the predicate offence has been stayed.
ECIR has been challenged.
Yes.
Then they should go before that court.
That's what we thought, my lord, but then office says no,
There's-
ECIR and we have no.
There's a judicial order passed on that.
That's what we thought, my lord, that it should go before the,
What is the writ petition number?
that is, my lord, the writ petition number is 15770 of 2024.
15770 of 24. That an inquiry and senior counsel submits that the ECIR has been challenged and pending in WP number 157.
No, my lord. ECIR is not challenging that. In WP number 15770, the charge sheet filed in the predicate offence has been challenged.
Have you challenged the ECIR?
No, ECIR is here.
Sorry, predicate offence is there.
Yes,
So
yes,
this
predicate-
ECIR will also have to go there.
No, I just wanted to.
We don't have jurisdiction in this matter, madam. We are sending it there. Let that court consider. The on inquiry learned senior counsel for the petitioner submit that the predicate offence has been challenged in WP 15770 of
2024.
2024. In that view of the matter, the above matter would also have to be considered by the said court. Connect with WP number 15770 of 2024.
Can I request Monday?
We cannot give date. You'll have to move there. We cannot make that mistake of giving a date for another court, please.
We have right. The court is.
Ivagle move ಮಾಡಿ.
Court is so overcrowded, my lord.
All courts are like that. What?
Enter the court and get out of the court is becoming.
ನಮ್ದು ಆರಾಮಾಗಿದೆ. Yes.
13, Alesha Ardaviman.
Mr. Alesha.
We provide canteen facilities to the BMRC Medical College. Tender has been invited, he participated. He submitted all the eligibility criteria along with the issuance certificate, each and every EMD, EMID, everything. But my lord, application has submitted on 2nd July 2026. My lord, till today, who has completed the technical bid and who has selected for the financial bid, all this, there is no any information about this tender. My lord.
No information.
Petition is one of the participated. My lord. He made an representation to the second respondent, Annexure B. My lord.
You'll appear for the BMC also?
Yes, my lord, I am the panel advocate for BMC.
Government advocate bere, panel bere na?
Yes, my lord, they have panel advocate, man. All the medical colleges have panel advocate.
Who is the counsel for Bangalore Medical College?
Sumana Baliga.
Basuraj Patel, man.
And AGA for respond number 1, Sumana Baliga for respond number 2. Yaru Sumana Baliga. Yeah, one day straight.
Well, Basuraj Patel or Mohammad Ayub. Sumana Baliga is not in the panel now.
Sumana Baliga is not in the
No,
panel.
my lord.
Basaraj Patil.
Basuraj Patel.
Basaraj Patil for respond number 2. Counsel for the petitioner to serve 2 sets of the petition along with annexures on the said counsel. Released on 1st September.
That if it is work order is issued, my lord.
You want to know the information only, so we'll to serve it on them, they'll get in.
13 of the my lord, even I am ready to, if opportunity provided, that is a second prayer.
My lord, my information is
Alesha,
that
you only want to know what is your prayer is that. Don't go beyond the prayer.
Serial number 14, LM Chidanandaya.
Lords, I appear for the petitioner.
Yes.
Lords, the writ petition is filed seeking implementation of the revenue recovery certificate issued by the RERA at Annexure A, my lords.
And AGA accepts notice for respond number 1, 2, 3. Notice to respond number 4 is dispensed with since respond number 4 is not required to be heard in the matter. Petitioner is before this court seeking for the following reliefs. A dispute having arisen between the petitioner and respond number 4, the petitioner had approached the Real Estate Regulatory Authority who had where is the award?
My lords, Annexure J, my lords.
Who had award dated 7th August 2024 and complaint number 01371 of 2023 directed payment of a sum of rupees 10,71,107 along with interest. Pursuant thereto, the recovery certificate under section 41 had also been issued on 31/12/24. The said recovery certificate not being acted upon by respond number 2, the petitioner is before this court seeking for the opposite relief. And AGA submit that the Office of Special Deputy Commissioner has been created for the purpose of implementing the recovery certificates under section 41 of the RERA. His submission is that given 4 weeks time, necessary 6 weeks time, necessary action would be taken by the second respondent. His further submission is that if the petitioner were to provide the details of the properties of respondent number 4, which have not been sold, and which stand in the name of respondent number 4 with appropriate documents, the same would hasten the procedure to be undertaken by respondent number 2, reserving liberty to the petitioner to provide such information and directing and placing submission of the learned AG on record, the petition stands disposed.
Please, grateful, my lords.
15. Sridharanjaya.
For the petitioner, your lordship, I have challenged the order of externment. Externment.
Externment. Were you heard?
Yes, your
Notice ಆಗಿತ್ತಾ ನಿಮ್ಗೆ ಹಿಯರಿಂಗ್ ಆಯ್ತು?
have filed a reply also, your lordship.
ಮತ್ತೆ ಅಪೀಲ್ ಹಾಕ್ಬೇಕಲ್ಲಪ್ಪ.
Your lordship, the grievance of the petitioner is that his wife is now pregnant about 4 months, and also he have kid aged about 4 years, your lordship. So, and also he is making to sit a full day, whole day in the police station, where he is going to the same station.
You have been heard, it's been rejected, there's an appeal remedy available. You have to go under the appeal remedy.
Kindly, your lordship.
Lordships kindly appreciate. 58 notice was given, allegations were made known to him. Kindly see the offences, my lord. 302 and all is there.
We are not deciding any of those.
Please.
And AGA for respond number 1 to 3. Petitioner is before this court seeking for the following reliefs. What has been challenged is a order of externment passed under section 55 of the Karnataka Police Act 1963. Before the said order was passed, the petitioner had been issued notice and was heard. Hence, the principles of national justice have been followed by the jurisdictional authority. The petitioner has a statutory remedy under section 59 of the Karnataka Police Act 1963, reserving liberty to petitioner to avail the statutory appellate remedy. Petition stands disposed until the appeal is heard, taken up for consideration. Respondents are restrained from implementing the impugned order dated 24/7/2026 at Annexure A.
Much obliged.
16. Ramesh Sharma.
Lord, seal number 16, seek for a short passover, my lord.
Same matter as yesterday.
Same matter, but
How much
regarding-
deposit?
No, but regarding the question here is slightly different, my lords.
Passover.
17. Rajesh Kumar.
Yes, madam.
Appearing on behalf of the petitioner, my lords.
Yes.
My lords, this is the matter with regard to the declaration of willful defaulter and paper publication, my lords.
Same
My
as
lords-
yesterday.
Yes, my lords. So
This is-
yesterday in the,
This is the son.
yes, my lords, this is the son, my lords.
IDBI,
TP Muttanna.
TP Muttanna, Pradeep Savkar for respond number 2. Who had we ordered for Union of India yesterday?
Union of India, the
What is that number? Yesterday's number?
25855 of 2026, my lords.
Same order. Connect with.
My lords, I maybe.
Serial number 18.
My lords, one submission. There's also one more WP that is pending, which I have put down the number.
Has it been listed?
No, it's not listed, my lords.
Once it gets listed, you can do
My lord, I'm appearing for the petitioner in
madam.
this case. Similar matter has been ordered by this honorable court uh, for non-executing the recovery amount from the RERA, my lord.
Section
Respondent number
41.
2 and 3. Kindly, I'm forwarding the memo, Your Honor. Sir. To recover the amount with interest calculated from the date of.
This we cannot direct. They are under CIRP proceedings. Infinite is in the sorry. That AGA for respond number 1, 2, 3. Notice to respond number 4 is dispensed since respond number 4 is not required to be heard. The petitioners had filed various proceedings before the RERA as detailed in para 1 of the petition, where the amounts as indicated there had been awarded by RERA in respect of each of the petitioners. Recovery certificates had also been issued on various dates as indicated in para 1. Despite the award having been passed and the recovery certificate having been issued, the respondents had not taken any action, and it is in that background that the petitioner is before this court. Learned AGA submit that the Office of Special Deputy Commissioner has been created for the purpose of implementing the recovery certificates under Section 41 of the Real Estate Regulatory Authority Act. His submission is that if the petitioners were also able to furnish details of any properties owned by respondent number 4 with adequate document, the same would hasten the proceedings of implementing the recovery certificate. His submission is that endeavor would be made to implement the said recovery certificate within 60 days from today. The said submission of the learned AGA answers the grievance of the petitioner, permitting petitioner to furnish such documents as the petitioner may have, identifying the properties belonging to respondent number 4 which are unencumbered. The petition stands disposed.
My lord, on submission, interest has to be calculated.
We can't be calculating.
Added.
Recovery certificate is given everything. Award is given the amount plus the interest. So until that, they will recover it. Unlikely that they are able to recover anything from this company. If you are able to get the property details.
No, my lord, in the RERA, they have mentioned clearly plus MCLR plus 2% interest.
They have mentioned
Till
it.
rate of realization.
But all the 4 projects are under joint venture.
Yes, my lord.
They don't even own the land. At least the 4 projects which have come up before us. They're all joint venture. They don't own the land.
I'll leave it to the court.
So if you have any property that belongs to them, give them the details.
19, MD Raghunath.
Yes, Raghunath, ನಿನ್ನೆ ಏನೋ ಮಾಡ್ಕೊಂಡ್ರಂತೆ?
In fact, I was driving, my lords.
So you are the culprit.
Unfortunately, not. Thankfully, nothing happened, my lords.
Thankfully, nothing has happened. That's the way to look at it.
Yes, my lords.
Yes.
In fact, my lords, due to the act of the respondent number 2, there's a subsequent second round of litigation, my lords. In fact, at Annexure D, at ink page number 45, the respondent number 2 on 15/7/2026 issues a notice, my lords, stating that all the education institutions must upload their student details for the academic year of 2026 to 2027 on or before 8th of August, my lords. Subsequently, my lords, at Annexure F, at internal page number 52, my lords, they issue a show cause notice to the petitioner, my lords. That has been
Did you
replied.
upload by 8th?
Pardon, my lords?
Did you upload by 8th?
Yes, my lords.
All the students?
Yes, my lords.
Yes.
And that has been replied, my lords, at Annexure G, at ink page number 55.
Now, what was the show cause notice for?
My lords, they say that certain facilities are not there in the premises,
Yes.
wherein there is no connectivity of electricity, they don't have technical equipments. And that is the reason that they've issued a show cause notice.
Without electricity, you're running a college.
If I may request my lords to kindly peruse this subsequent annexure G, I think page number 55.
Yes.
In that reply, my lords, the petitioner have clearly mentioned that there was a short circuit that occurred in the premises, because of which there are certain damage to the equipments.
When did the short circuit happen?
Subsequently, my lords.
Datedly.
Unfortunately, they've not mentioned the date, my lords.
And from when to when is the power not there?
That has not been mentioned, but they have sought for permission to abide by the same, my lords. But unfortunately, my lords, may kindly peruse Annexure K, my lords.
Yes.
Prior to Annexure K, there was this upload, my lords, as per Annexure D, which the petitioner could not follow at Annexure H, my lords, in internal page number 59 and 60, my lords.
So this uploading which we asked you did, you haven't done that also.
We couldn't do, my lords. They have blocked the petitioner from uploading the details of the students. Unfortunately, there was a...
8th August.
Please, my lords. Unfortunately, my lords may kindly peruse at Annexure K at internal page number 64. The petitioner filed a writ petition, my lords.
Yes.
And that was disposed of with a direction, which is at internal page number 66, my lords, that it has to be adjudicated within 2 days' time, my lords. They do not adjudicate within 2 days, and belatedly at internal page number 81 on 12/8/2026, they pass an order, my lords.
Now all the facilities are up to date. Electricity is
It is, my lords. It is, my lords.
Direct inspection, inventory.
It could be so.
Carry out
But until then, my lords, may I make a humble submission?
till then. First we will get
21st is the period, the last day to upload the details, my lord. That should not jeopardize all the students, which are 40 in number, my lords, as per Annexure E.
jeopardize. If your equipment is not there, we'll direct you to pay 10 lakh of rupees to each of the students, as we have done in other matters. You are running a college.
I understand,
so
I
don't
understand,
lick the life of students. Don't do that.
Definitely, my lords.
If we find something like that, we'll immediately take action.
But until then, my lords, an interim order may be passed.
No interim order.
My lords, tomorrow is the last date to upload the documents.
So come day after tomorrow.
My lords, yesterday, in fact, the matter was listed. Unfortunately, because of unforeseen circumstances, my lords, I couldn't appear before this honorable court.
Allow them to upload, but they will be subject to this.
Please, my lords.
The issue in the matter is as regards whether the facilities. It never gets rectified. They'll say they'll rectify it, upload it, exams will happen, next year another writ petition comes. And then you will say last year also they had come. The issue in the matter is as regards whether the facilities required for running of the industrial training institute is being made available by the petitioner or not, since as per the show cause notice issued, there are various inadequacies which have been pointed out, including that electricity is not available. However, considering that 21st is the last date for uploading the names of the students with their details, the respondents are directed to unblock the website to enable the petitioner to upload the names of the students and the details. The said uploading will, however, be subject to verification as regards the facilities available at the petitioner institute. Respondent number 2 is directed to cause an inspection of the facilities of the petitioner to ascertain if all the facilities are available and submit a report relating thereto. The inspection shall be carried out at the convenience of respondent number 2 without requirement of issuance of any prior notice to the petitioner. The report to be submitted on or before 9th September, released on 17th September. You won't be entitled for any notice. It will be a surprise check.
Please, my lords, at least let them provide me the details, my lord, at that point of time.
No, after the report, they'll give it to you.
Please, the report may be given, my lords. And also, in the meantime, let them allow me to upload the details, my lord.
We have directed.
Please.
Much obliged.
Serial number 20.
Yes, Mr. Order.
ROC, that prayer was not there in respect of that registrar of companies. 24.
This
Sorry,
is
my apologies for not in this.
not.
Suddenly you left my class.
Please, my lord. I am appearing for the petitioner, my lordship. And so
Yes.
I am seeking a writ of mandamus to defreeze the account of the petitioner, my lordship.
Defreeze the account.
Lordship, already some matters are referred to appear before KID, my lordship.
Lord AGA for respond number 1, 2, 3. ICICI Bank,
Francis Xavier.
Francis Xavier. Cyber Command on 27th, relist on 15th.
Please, my lordship.
21. Shrikant Enmi.
21.
That's next year, my lord, is the second show cause notice, my lord, issued by the third respondent. The opening of rowdy shutter, my lord. I have filed the objections, my lords, at per annexure L, my lord. That has not been considered. Page number 43 is the objection.
43.
43, my lord, the objection. Only 2 days time, my lords, was given to reply the my lords annexure A. That's annexure A, my lords, is at page number 12.
Now, are there any proceedings pending?
My lord, only one case is pending, my lord.
Only one case.
One case, my lord. And I have opened bail, my lords, in that case.
ಮುಂಚೆ ಎಷ್ಟು ಕೇಸ್ ಇತ್ತು?
ಮುಂಚೆ ಒಂದು ಕೇಸ್ ಇತ್ತು. That is in the year 2008. That has been, my lords.
ಯಾವಾಗಲೂ ಒಂದೇ ಕೇಸ್ ಆಯ್ತಿತ್ತು.
2008 ಅಲ್ಲಿ, sir. My lord, I have produced document annexure M, I can be same, my lord. Page number 46. Dated 9/1/2023. In fact, my lord, the Superintendent of Police has issued, my lords, the proceedings. Column number 4, my lords, 04/2023. Last portion, my lord. So and so, so and so. The next page, my lord, 47. The operative portion, my lord. ಮೇಲ್ಕಂಡ ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ಅಂಶಗಳನ್ನು ಪರಿಶೀಲಿಸಿ ಶ್ರೀ ಸೋ ಅಂಡ್ ಸೋ ಅದು ನಾನು ನಿಮಗೆ ಆದೇಶಿಸಿದರೆ ದೊಡ್ಡಬಳ್ಳಾಪುರ ಉಪವಿಭಾಗದ ಪೊಲೀಸ್ ಠಾಣೆಗಳ ರೌಡಿ ಆಸಾಮಿಗಳು ಯಾವುದೇ ಕಾನೂನು ಬಾಹಿರ ಚಟುವಟಿಕೆಗಳಲ್ಲಿ ಭಾಗಿಯಾಗದೆ ಒಳ್ಳೆಯ ನಡತೆ ಇರುವುದರಿಂದ ಸದರಿಯವರ ರೌಡಿ ಹಾಳೆಯನ್ನು ಮತ್ತು ಆದೇಶಕ್ಕೆ ಸಂಬಂಧ ಕಾಗದ ಪತ್ರಗಳನ್ನು
What are the criminal proceedings pending against the petitioner?
Plus one proceedings, my lord, as per annexure F, my lord, is the FIR. Page number 26, my lord. In crime number, my lord,
proceeding.
Annexure A, my lord.
Hmm.
It appears that, my lord, two crime number 96 and 263.
Crime number 96.
Please, my lord, in the reference ಉಲ್ಲೇಖದಲ್ಲಿ they have.
ಮೂರು ಇಲ್ವಲ್ಲ? There are no 3 crimes.
that, my lord, crime
Your
number
lordships
96.
kindly appreciate this is only a notice.
Even you don't have jurisdiction to do it.
They say, my lord, if my lords may kindly see page 13. ಈ ನೋಟಿಸ್ ಜಾರಿ ಮಾಡಿದ್ದು ಈ ನೋಟಿಸ್ ಜಾರಿ ಆದ ದಿನಾಂಕದಿಂದ 2 ದಿನಗಳ ಒಳಗಾಗಿ ಉತ್ತರ just asked to give
That is
reply.
another problem.
In fact, my lords,
Give proper
31
response. There are
7
only
they have
2 matters which are pending. And AGA for respond number 1 to 4. The petitioner, he is before this court, agreed by the order dated 37/26, passed by third respondent at annexure A, opening a rowdy sheet in respect of the petitioner. A pair of the papers indicates, firstly, that even according to the respondent, there are only 2 cases which are pending, namely crime number 96 of 2008 for offences under section 143, 147, 148, 323, 324, 448, page 12, 504, 307, 149 of the IPC, and crime number 263 or 2026 in crime number for offences under section 117, 118, bracket 1, bracket 2, 126 of the BNS, read with section 25, 27, and 30 of the Arms Act. Insofar as the proceedings in crime number 96 of 2008 are concerned, they have been disposed.
Yes, my lord.
On?
As per the proceedings, my lords, of the Superintendent of Police.
Where is the acquittal order or discharge? ಏನಾಗಿದೆ ಅದರಲ್ಲಿ?
Lordships,
My
these
instructions
are
are
all
that, my
under Arms Act, my lord.
Only one is on the Arms Act. The earlier 96 of 2008.
Earlier, my lords, as per instructions, my lord, that has been acquitted, my lord.
Where is that order?
That order has not been produced, my lord. But I have got the instruction that, my lord, that case has been closed.
Produce the order. After arguing for some time, learned counsel for the petitioner seeks for and is granted a week's time to place on record the order of acquittal in crime number 96 of 2008, released on 28th August.
Till then, my lords, no precipitation. Till then,
ನೀವು ಆರ್ಡರ್ ಕಾಪಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಬೇಕಪ್ಪ.
please.
They say that, my lord, ಆತ್ಮರಕ್ಷಣೆಗಾಗಿ ಬಳಸದೆ ಅದನ್ನು ದುರುಪಯೋಗಿಸಿಕೊಂಡಿದ್ದಾರೆ, arms, my lord.
That is not rowdy sheet. You should have 3 matters. He has to give us the copy.
Please.
22, Prakash MS.
Yes, Mr. Prakash.
The freezing of the account of the petitioner.
Defreezing.
Please. In fact, it is covered by Lordship judgment. Not just my lord, that even the fixed deposit.
Pradeep Saukar for respond number 1, IDFC.
Suresh V.
Suresh B. Ms. Swamini Mohanambal for respond number 3, 4, 5, 6, 7. The Ministry of Home Affairs is party.
ಇವ್ರದ್ದು particulars ಆ ತರ ಕೊಟ್ಟಿದ್ದಾರೆ ಬ್ಯಾಂಕ್ ಇಂದ. Will not may kindly turn to page 20. Annexure F. ಅದರಲ್ಲಿ 5 ಲಕ್ಷದನ್ನ ಮತ್ತೆ ಇವರೇ they have permitted the petitioner to withdraw it. So far as the petition is disputing 1,20,000. And in fact, she has communicated to the respondent bank way back in July 2024 to send that amount back.
Direction is for debit freezing.
Please.
The concerned, this one is not Home Affairs. It is Christian Ganj Police Station, Ajmer, Rajasthan. You wrong party ಮಾಡಿದ್ದೀರಾ. Cyber Crime Police Station, SOG, Jaipur.
ಇಲ್ಲ ಕಾಶ್ಮೀರ್, ಮಹಾರಾಷ್ಟ್ರ, ತಮಿಳ್ನಾಡು ಇದಾವೆ.
ಇದಕ್ಕೆ ಹೋಮ್ ಅಫೇರ್ಸ್ ಮಾಡಿದ್ರೆ ಹಿಂಗೆ.
ರಾಜಸ್ಥಾನ್ ಇದೆಯಲ್ಲ ಸೊ ಇದು ಸೈಬರ್ ಕ್ರೈಮ್ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್.
Prakash, police is a state subject.
Yeah.
Ministry of Home Affairs cannot represent these.
ಇಲ್ಲ ಸ್ವಲ್ಪ ತಪ್ಪಾಗಿದೆ.
Police station.
I will correct it.
Counsel for the petitioner seeks fund is granted a week's time to carry out necessary corrections in the cost title as regard the array of parties. Released on 27th August.
23, P. Sheshgiri Rao.
For the petitioners, my lords. My lords, in this, my lords, we are before this honorable court seeking for a direction to the jurisdictional police to give protection as per the order of the additional senior civil judge in JMFC Bangalore in OS number 785.
The direction. Page 17.
My lord, my instruction is, my lord, we have given the notice for them to maintain the status quo, my lord, respondents, and 2 times we have stopped the construction, my lord, interference. Whenever they have noticed, even on Sunday also we have.
File your report.
Yes, my lord.
And AGA for respond number 1 to 5.
My lords, small submission, my lords. Now, my lords, the respondent are presently coming and trying to alienate the property.
Alienate the property is not covered by this order.
My lords, they are trying.
You have to file separate application for that.
Okay. Kindly, my lords, direction to the jurisdictional police.
You have to file that application in the pending suit seeking for injunction.
My lords,
we
we have
advise
filed
you.
it. My lords, we have the additional senior civil judge has ordered, my lords, in annexure A, my lords, A and A1, they have ordered for police protection, my lords.
This is as regard the construction, not
Regarding
as
the
regards
construction.
alienation.
It's regarding the constructions, my lords.
Alienation you are asking now.
Question, my lords.
That is not part of the order.
Regarding construction.
File an application.
Please.
And AGA accepts notice for respond number 1 to 5. He submits that the police have acted upon the order dated. What is the order date? (12/6/26), passed by 7th Additional Senior Civil Judge, Bengaluru Rural District in OS number 785 of 2026, and have taken necessary action to maintain status quo as regard the construction. He is granted a week's time to place on record all the necessary documents supporting the action taken by, indicating the action taken by the respondents. Released on 27th August. I-1 of 26 is allowed.
Much obliged, my lords.
24, Maitreyi Vikanu.
Yesterday's matter. Yes, madam. 527.
Annexed to JJ, of which they want a stay now.
Hmm. Yes.
My lords, kindly see, this is an inquiry in the matter of so-and-so under 206 subclause 4 of Companies Act.
Hmm.
The first para, Ministry of Corporate Affairs has ordered inquiry into affairs of the company so-and-so under order dated so-and-so 21/1/2026.
Hmm.
Then they've asked them a series of questions. Then kindly see, my lords, your lordships will find the next document at page 547, where they've replied to this notice.
They have replied.
Yes, they've replied at 547. There's an acknowledgement also, inquiry in the matter of so-and-so under 2064. They've provided all the documents at 550. They say remains committed to extending full cooperation, etc.
Hmm.
So, my lords, my first submission to your lordships is that the notice issued by the ROC is in pursuance of an order by the MCA, which has been passed based on an independent complaint.
And not the earlier one.
It is not on the basis of a reference by the pharmaceutical department in pursuance of Annexure A. That is my first submission. Second, my lords, they have replied to it. Therefore, the notice has spent itself out today. Thirdly, my lords, now what is to follow from this? Based on the reply given by them, if the department, if the ROC is satisfied, there ends the matter. If not, they issue a preliminary findings letter where they make an assessment of the reply and call for further clarification. At that point, the petitioner is given an opportunity to answer. Thereafter, my lords, if they are not satisfied, and in fact, any violations of company law are made out based on the explanation given, necessary action will be taken. So therefore, my lords, today, they're virtually interdicting the preliminary letter itself from being issued based on their own reply. And there is no threat. They cannot even prevent that PFL from being issued. They have to answer it, especially when it is an inquiry that is initiated.
No,
on
that
an
has not been
independent-
initiated at all. This is a separate proceedings, what you say.
Yes, that is what I'm saying. It's not in pursuance of Annexure A.
Hmm.
And they have answered it. Therefore, seeking a stay of the notice does not arise.
Mr. Ola, they'll have to produce it. This is not in pursuance of Annexure A.
In fact,
separate independent proceedings.
I'll tell you, Lordship, we had appeared and the person said, my lord, it is pursuant to that order of Annexure A. At any rate, my lord, can I submit this? I'll not even, my lord, ask for anything else.
Let them file their
No,
objection.
1 minute. I'll tell you, Lordship. I'll tell you, Lordship. I'm not asking for anything else. Let them produce the, on what basis, my lord, this has been filed. Let them, my lord,
Well, no,
indicate
for
that.
that, my difficulty is
In fact,
the identity
if
of
my-
the
if your
complainant
lordship
cannot be
Can I,
disclosed.
can I? 528, please come to 528.
Yes.
0.9. It is found that an order has been passed by the Apex Committee of the Pharma Marketing dated 23/12/2024 in the matter of so-and-so, so-and-so. It is on this basis. In fact, internal noting will not clearly bear that out also.
Well, it's two submissions that was
In
just
this regard,
one of
company
the-
shall give a narration of the events leading up to the above order with the supporting documents as complaints made, notice received, submissions made by the company regarding the above mentioned order, etc., etc. Then, my lord, para 10. From the above mentioned order dated so-and-so by the Apex Committee of Pharma so-and-so, it is observed that the company has spent so-and-so, so-and-so 1.91 crores for providing air ticket hotel so-and-so, so-and-so. Same, my lord, allegation,
They have answered at page 548. They narrate.
whatever it is. Further things, my lord, they may not.
What's two other
There are
submissions?
only two things. There's only one thing, madam. Is this issued in pursuance of Annexure A
No,
or not?
it is not. Your
If it is
lordship may
not
record
issued in
my
pursuance of
submission.
Annexure, we'll be recording your submission.
Please, my lord, your lordships may record.
Because from para 9 and 10 and 11, it appears otherwise.
No, kindly see, my lords, just because I asked them information about an order, it doesn't mean I'm implementing that order. They have very well answered it. They've given an entire summary of the events leading up to it at page
They've
548.
answered it.
They've come and answered.
Delhi High Court has stated, Gujarat High Court has stated, so
My
many
lords,
courts have
kindly see
stated.
what Delhi High Court has stated. My other submission, my lords, is whether Annexure A survives itself. Today is a question. The first relief, the first direction against them in Annexure A was a reprimand. which they had to publish on their website. It was passed in 2024.
Hmm.
Kindly see, Manoj, page 65.
So you're not taking any action pursuant thereto.
No, Manoj, this ROC notice is on the basis of a complaint that has received to the Ministry of Corporate Affairs, which order they have not challenged. The 12/1/26 order they have not challenged. They have not made Ministry of Corporate Affairs a party. Through challenging Annexure A, they're trying to seek a stay of ROC. That's not permissible. Now, can you see 65, Manoj? There were only 3 things in the order. One was a reprimand which they had to publish on their website. If they have done that, there ends the matter. CBDT, Manoj, I'm not answering. CBDT notices a standing council will have to answer. 3, Manoj, National Medical Council has jurisdiction over only those professionals. They have gotten a stay. That's a separate matter. That does not concern ROC, Manoj, nor does it concern the petitioner here, nor are those doctors petitioners here. And Delhi High Court has only stayed in so far as NMC action. There,
That
Manoj,
is item number 2.
that's
Item number 3.
3 is not the subject matter here.
Hmm.
2 is the subject matter here, but my learned friend has to answer that. Then 1, my lords, is the only thing. If they've complied with that, if they've published it on the website, then if there anything remains at all on Annexure A. And my categorical submission is JJ is based on an independent inquiry, not on the basis of. And I have, just because I've sought information regarding this proceeding, that does not mean I'm implementing it. Or neither am I
Why
investigating
would you
only
ask for
this.
something which is not relevant?
I've asked for 15 things.
ROC is all measured in what they use.
Well, if that is their contention, they should have taken it prior to answering. They've answered it today. They've given an answer at 48.
Your
548.
categorical submission is that this is not in pursuance of that order.
Please, Manoj, and regarding the, kindly also see, Manoj, 2 other grounds. They amended the interim relief, but there are no grounds in support of this interim prayer. All the grounds of Annexure A stay. This they have not amended. Secondly, Ministry of Corporate Affairs
You
is
file
not
your
arrayed.
objection, we are not going to interfere now.
Thirdly,
File
Manoj,
your objection,
the
you wanted
order
it on
dated
29th, we'll have it on 29th. Place all this on record and file the affidavit also, we'll record your
I
statement
may
today.
require some more time to file the
But
objection.
it's not fair.
Manoj,
It's not fair.
I'll explain.
My lord, they are
Yesterday-
ready now. They'll argue, and thereafter, my lord, oppose the stay,
interim
and then, my
prayer,
lord,
my
they
lord.
say that they want. My
I've
lord, it's not
argued
fair.
on interim prayer. I was seeking till 29th only.
Then, my
for
lord,
the
please
interim
state, my lord, page 67.
Because
Anonymous
you are arguing
complaint.
you're not granting the interim order. If you have to consider it, you'll have to file your objection, we'll consider the matter. That you can't ask for a longer time.
My lord, if your lordships are considering the interim order now, my lord, your lordships may record my submissions and consider it today, my lord. For the
Then-
main matter, 29th may be too short. I need to file against Annexure A also.
Annexure A, my lord, is on the basis of an anonymous complaint. Based on, my lord,
That's a separate
code
thing.
of 2024, which says, my lord, anonymous complaint can't be entertained. Therefore, my lord, Annexure A
We'll
has to
stay
go.
Annexure A then, on
Correct.
the interim order.
That's right.
We won't stay the others.
Very well.
But
Very well.
my lords, in respect
And
of
since they have said that they are not doing it under Annexure A,
Alright.
it doesn't matter.
All right.
My lords,
If the separate one, you'll have to challenge it
Please, my lord.
separately.
if your lordships were to stay Annexure A, my lords, then your lordships are also in fact staying the actions of the CBDT and the reprimand.
Yes,
If-
because that is why we asked you yesterday, when the pseudonymous and anonymous complaint cannot be accepted, this order could not have been passed.
So this order, that may be on jurisdiction and merits, my lords. Now the question is, what is their apprehension to take a stay of Annexure A? Point 3 has been stayed by different high court.
If Annexure A is an order which has been issued without jurisdiction, it will have to be stayed.
My lords, it was issued in 2024.
But anyway, you are not taking action under Annexure A.
Then-
It's only a reprimand. How are you? There's nothing
And
which
they were
affects
to
you.
display it on their website. If they've already displayed it, nothing remains in
So
Annexure
don't
A.
take any further action, that's all.
Manoj, that in my humble submission may not be, Manoj. Kindly see what is the action contemplated under Annexure A.
They can't have the cake and eat it too, my lord.
They
That's
are
all that I
saying
would say.
ROC has initiated action, CBDT has initiated action. CBDT action, Manoj, I'm not answering.
We are not staying either of them. We are staying only Annexure A.
Manoj, even for that,
On the
Manoj,
ground of jurisdictional error of anonymous, pseudonymous complaint could not be entertained by, who is this respondent?
Apex Committee of Pharmacy Practice, Pharmacy.
That will stay. And since you are not taking any action in terms of that, and they are independent, you can proceed on that.
Submission to stay that, my lords, one component has already been stayed by a different high court.
So
The
what?
reprimand, my lords, if your lordships are going to stay the reprimand, then nothing remains in that order if they've already published it. Let them say whether they've published it.
It's a jurisdictional error when you tell us how a pseudonymous and anonymous complaint could be entertained. When your rules itself say
That is their
you are appearing
contention.
for respond number 1,
Please, that is
then show us how you could have entertained that.
that is their contention. I have to answer that since they've come after 1.5 years and they have not been able to make out any apprehension on the basis of this order, then my lords, if your lordships were to consider it at the time of considering the main matter, nothing is going to be.
So then we'll have it on. See, that is what we said. We'll give you time, but that time has to be reasonable. 29th we'll take it up. 28, 27, 28 you had a problem. 29th we'll take it up. We'll take it up on 29. Either of these two can't be both.
Lords, but 29th
And if my
maybe-
learned friend is appearing for R1, then my lord, how is she representing R4, R3?
They're all
ROC.
central government bodies.
I don't know.
Central
What she
government.
says.
They're
Anyway,
all
it doesn't
cent-
matter.
I mean-
I'm
Central
not,
government.
my lord, trying to say that, but
It's
then.
not an issue.
Very well, my lords. I'll ask another central government council to represent pharmacy if
No, no,
they say
it's not
there's a
needed.
conflict.
Whatever.
That we are not getting into. So when will you file your objection and you address your arguments on that day?
My lords, your lordships may have it on 29th, my lords.
Learned counsel for.
My lords, for consideration of interim prayer.
Now you want to file your objection, it could be for final.
For ROC, I have opposed. For Annexure A, my lords, they themselves gave it up yesterday. That's why they made this
I didn't give it up, my
amendment.
lord. I'm sorry. I didn't give it up. I wanted, my lord, that stay. Then, my lord, she started saying, my lord, ROC, this, that, and all that. Then I pointed to ROC. It can't be, my lord, without jurisdiction, my lord. I asked myself, how? Absolutely without jurisdiction.
You are now appearing for whom, madam?
Lords, I appear for R1,
1, 2,
2 and 4.
Dilip is for R3. Where is Dilip?
Lord has some inconvenience. He'll require some time, my lord, to get in.
He has told you that. So sometime is 29 for him also. Then the respective counsels for the respondent seek for and are granted 10 days time to file their respective statement of objections. Relist on 29th August.
In fresh list, my lord. Fresh list.
In preliminary hearing it will come.
My lord, only one thing. Their statement that, my lord, the ROC, my lord, has not initiated steps, my lord, on the basis of Annexure A may be.
Please, my lords, your lordships may.
That may be recorded.
The submission.
Because they have not even given us a copy of whatever they.
Respond number 1 to 4, that annexure JJ being the notice dated 12/5/2026 has not been issued on the basis of annexure A being the order of respond number 1 is placed on it.
Please. Great.
ಇಲ್ಲ 2-3 ನಿಮಿಷ. Next matter 25. ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಹೆಸರು ಕೇಳ್ತಿದ್ದಲ್ಲ ನೋಡಿ ಇಲ್ಲಿ ಬರುತ್ತೆ ನೋಡಿ ಈ ಕೇಸ್ ಇಲ್ಲಿ ನೋಡಿ ಒಂದ್ ನಿಮಿಷ ನೋಡಿ ಇಲ್ಲಿ ನೋಡಿ ನೋಡಿ ಇಲ್ಲಿ ನೋಡಿ ಕೇಸ್ ನಂಬರ್ ನೋಡಿ ಸರಿ ಸರಿ ನಾ ಇಂಥವು ಚೆಕ್ ಮಾಡಿನೇ ಹೇಳೋದು ಹೌದಾ KMF ಅಲ್ಲೂ ಇಲ್ವಾ ಅವರು ಇನ್ನೊಬ್ರು KMF ಸುಮಂತ್ ಇಲ್ವಾ
ನಮ್ಮ ಹುಡುಗ ನೋಡ್ತಾ ಇದ್ದ
ಭಾರದ್ವಾಜ್ ನಿನ್ನೆ ಬಂದು ಕೇಳಿದ್ರೆ ನಿನ್ನೆ 3 ಸತಿ ಕೇಳಿದ್ದೀನಿ.
ನಿನ್ನೆ 4:15 ಕೊಟ್ಟೆ ಸರ್.
ಹೆಸರೇ ಹೇಳ್ಬಾರ್ದಷ್ಟು
5:15 ಹೋದ.
ನೆಕ್ಸ್ಟ್ 25
KMF R3 ತಗೋತಾ ಇದ್ದೀನಿ. ಸುಮಂತ್ ಇಲ್ಲಿ ಬರುತ್ತೆ.
ಯಾರು?
ಸುಮಂತ್ ಇಲ್ಲಿ ಬರುತ್ತೆ. ಹಾ. ಇಲ್ಲ ಇದೆ ಬಿಡಿ ಸರ್. ಇದನ್ನ ಸೈನ್ ಮಾಡ್ಬಿಡೋಣ.
ಇದೆ
ಇಲ್ಲ
ಇದೆ ಸೈನ್ ಮಾಡಿ ತಗೊಂಡಿರ್ತಾರೆ ಇಟ್ಕೊಂಡಿರ್ತಾರೆ ಅಷ್ಟೇ ಯಾರ್ಯಾರೋ ಕೇಸ್ ವರ್ಕ್ ಕೊಟ್ಟಿರ್ತಾರೆ ನಾವ್ ಅದ್ರ ಬುಕ್ಕಲ್ಲಿ ಬರ್ಕೊಂಡಿರ್ತೀವಿ ಅವ್ರು ಏನು ಬರ್ಕೊಂಡಿರಲ್ಲ ಅದಕ್ಕೆ ಮತ್ತೆ ಇಲ್ಲಿದ್ಯಾ ಅವ್ರ ಹತ್ರನೇ ಇದೆಲ್ಲ ಮೆಮೊ ಕೊಡಿ ನಾಗರಾಜ್ ಅವ್ರಿಗೆ, ತುಂಬಾ ಅರ್ಜೆಂಟ್ ಇರುತ್ತೆ. ಇದೊಂದೇ ತಗೊಳ್ಳಿ. ಅಲ್ಲ, ಏನು ಹೇಳಲಿಲ್ಲ ಅಂದ್ರೆ ಏನು ಬರಿಬೇಡಿ, ಹೇಳಿದ್ರ ಹೆಸರು ಬೇಡ, ಬಿಟ್ಬಿಡಿ, ಬೇಡ, ಏನು ಇಲ್ಲ ಅಂದ್ರೆ ಏನು ಇಲ್ಲ. ಹಾ, ಅಷ್ಟೇ 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 ಸಾಕು. ಮೆಮೊ ಬುಕ್ ಅಂತೆ ಕೊಟ್ಬಿಡಪ್ಪ ಅವ್ರಿಗೆ. ಮೆಮೊ ಹಾ, ಅವ್ರ ಬುಕ್ ಅಂತೆ ಕೊಡಿ, ಹೋಗಿಲ್ವಂತೆ. ಸುಮ್ ತಪ್ಪೋ ಸರಿನೋ ಹೆಂಗಾದ್ರೂ ಕೊಟ್ಬಿಡ್ಬೇಕಷ್ಟೇ.
ಅದೇ
Sumant, you are appearing for respond number 3.
Please, minutes.
Yes, ಹೇಳಿ.
Just now I got the copy.
Time for tender is fixed below 15 days, 15 days, my lord. 8/8 is the publication.
8/8.
Is the issuance date. Issuance of public, page number 20, my lord. And next page 21, ಟೆಂಡರ್ ಕಾರ್ಡ್ಗಳನ್ನು ಸ್ವೀಕರಿಸಲು ಕೊನೆಯ ದಿನಾಂಕ ಮತ್ತು ವೇಳೆ 25th 8.
25th August 2026. The tender is for 2 years, long-term tender, and also cost more than 2 crores. And,
Yes, Sumant, why is it less than 30 days?
There are several stringent conditions in the
ಅದು ಅವ್ರ conditions.
ಅಲ್ಲ FSCCI ಲೈಸೆನ್ಸ್ ಎಲ್ಲ ಕೇಳಿದ್ದಾರೆ. ಇಟ್ಸ್ ಓನ್ಲಿ ಫಾರ್ ಸ್ಟೋರೇಜ್ ಯೂನಿಟ್ಗಳಿಗೆ ಬರುತ್ತೆ. FSCCI ಲೈಸೆನ್ಸ್ ಪೇಜ್ ನಂಬರ್ 23, my lord.
Conditions we cannot interfere as to what they impose.
Please, my lord. And also EMD fixed is also more than the tender value.
ಏನು?
EMD. In addition to EMD, they have also asked for fixed deposit of 80,000, page number 28. Compared to the adjacent Asan Milk Unionalli ಅಷ್ಟೊಂದಿಲ್ಲ. They have also given 45 days time for tender time. So, but in the present case, they have given only.
Yes, Sumant, why less than 15 days is there? It's contrary to
Just now they served the copy, my lords. Matter may kindly be on Wednesday, my lords. I will get back, my lords. Just now they served the copy.
ಪಾಸ್ ಇವಾಗ ಕೊಟ್ರ ನೀವು ನಿನ್ನೆ ಕೊಡ್ಲಿಲ್ವಾ?
ಇಲ್ಲ,
5 minutes ago I received.
So the main issue is that you have issued a tender with less than 15 days for submission.
You have it on Monday at least, my lords.
30 days minimum ಬೇಕು. Short term 15 days. 15
Monday,
days.
my lords, I will get back.
15 days ko no record because the reasons are recorded. 15 days can there is no
It doesn't even fit short term. Also,
Kindly have it on Monday, my lords. I will get back, my lords.
Monday.
Take instructions.
25th days. Last date.
24th, Monday is 24th, alva?
Yes.
24th. Please, my lords.
Yes.
Serial number 26, Aditya SK, General Bureau.
And AGA for respond released on 27th. Out of state. Where is Aditya? On 27th.
27, Rajeshwara PM.
Yes, I appear for the petition. This is status matter, my lord, regarding permission
Want to do some renovation of a particular temple which has been notified. That notification has been challenged in another writ petition, and there's a stay. Thereafter, my lord, they've asked for permissions to renovate that temple. They've scheduled it for renovation. It's not an event. They've made it into an event, and
The
thereafter,
renovation is stayed.
the
Not renovation,
notification of, my lord, they've put it into the Mujrai now. Notified it for the Mujrai, saying there's mismanagement. That, my lord, is challenged by the petitioners in another writ petition which has been stayed. Subsequently, they've also filed this writ petition now asking for renovation of that particular temple, which is notified. Temple is notified.
What is stayed there?
The notification of the temple, my lord. It's notified, they've challenged it, it's stayed in another writ petition. Now they want permission to renovate.
While the list is pending
Yes,
consideration.
we've rejected it.
Yes, Mr. Patel.
I'm sorry, I've just received it on my WhatsApp now, my lord.
Yes.
It's a rejection.
You rejected your.
We've rejected it. Tahsildar has rejected it. Initially, my lord, forwarded a
What is
report
the
saying.
other writ petition WP number?
My lord,
We have produced, my lord.
they've
in the
produced it.
petition. D1, my lord.
5566 of 2020.
Connect with
5566 of 2020.
66 of 2020. Submission of learned AGA is that the application stroke representation submitted by the petitioner on 27/2026 at annexure A and 17/7/26 at annexure A1 and A2 has been rejected by the order dated
My lord, 17/8/2026.
17/8/2026 on the ground that that in the earlier writ petition in WP number so and so, the notification of the concerned temple as a Muzrai temple has been stayed by this court. And pending consideration of the said writ petition, permission for renovation cannot be granted. Released on 9th September.
Serial number 28. Kiran
But may
SS.
just note that it's rejected by the Tahsildar itself.
Rejected by the Tahsildar.
Kiran SS, General Payrolls.
28 learned AGA for respond released on 27th.
29. DC Venkatesh.
Seeking mandamus execution, my lord, the conviction warrant. Conviction warrant, my lord, issued to the accused, and in fact gave a representation. In fact, the warrant has been reached to the third respondent 24th November 2025. The trial court avoid warrant ಅಂತಾನೆ ಹೋಗ್ತದೆ, conviction warrant ಅಂತ ಹೇಳಿ.
ಇದಕ್ಕೆ mandamus ಬೇರೆ ಬರುತ್ತಾ ಇದೆ.
My lord, we have no option. In fact, multiple times we have given my lord, the trial court sent my lord the issue execution of conviction warrant. In fact, ಅದು ನಾನು ಅಕ್ಲಾಯ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದೇನೆ 24th November my lord they have received it.
This is a big problem, madam. Matters are pending because this particular warrant not being and AGA accepts notice for respondent number 1 to 3. She seeks for and is granted a week's time to obtain instruction, make a submission as regard the status of execution of the non-bailable warrant, conviction warrant issued against the accused in CC number 3340 of 2020 by the Chief Metropolitan Magistrate Bengaluru, SCCH 9, bracket SCCH 9. Especially all these are in this negotiable instruments matters. Everything is pending there. We list on 24th.
Please.
Serial number 30.
My lords, may appear for petitioner, my lords.
Yes.
My lords may have it on Monday, my lords. My lord, this is the matter where, my lords, government started firing at me. I am the educational institution, society.
I 1 out 26 is allowed relist on 24th.
Please.
31.
Notice, one nimsha kodi adu. Who are the respondents?
For the petitioner, my lords.
Just a moment. Now, and AGA for respond number 1 and 2. 1, 2, 4, 5. Notice to respond number 4, 6 and 7 is deferred for now. Counsel for the petitioner to furnish 2 sets of the petition along with annexures on learned AGA. 5. ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಾರೆ by society 5 ನು ಇಲ್ಲ 5 deferred.
31.
For the petitioner, my lord.
Yes, madam.
My lord, I am the petitioner. I am educator and author and social reformer since over 30 years. For my work, I have been given recognition in the Canadian Legislative Assemblies also, which is shown at Annexure D. However, whenever I use my right to fairly criticize Vastu consultants who say that a toilet placement can cause cancer, the respondent number 3 removes my ID. There are 80-90 copyright strikes to such content, and everything that is legally wrong is on the Meta platform, Instagram.
For Meta. Standing counsel, any standing counsel, any. They appear for Google. This is Facebook. ಮೊನ್ನೆ ಯಾರು ಅಪಿಯರ್ ಆದ್ರಲ್ಲ ನಂಬಿಯಾರ್ and AGA for respond number 1 sorry Sri Keshav that respond number 1 and 2. Ms. So and so is directed to accept notice for respond number 3. Counsel for the petitioner to furnish 2 sets of the petition along with annexures on the said counsels. Relist on 27th August.
32.
I am afraid for petitioner, my lord. The petitioner are seeking general parole for marriage purpose, my lord.
AGA for response
Annexure
27th.
Annexure A, my lord.
27th. Let them get instructions.
My lord, ಇದರಲ್ಲಿ 2 ವರ್ಷ 5 ತಿಂಗಳು ಅಂತ ಇದೆ. ಸೊ ಮ್ಯಾರೇಜ್ ಪರ್ಪಸ್ಗೋಸ್ಕರ 26ಗೆ ಮ್ಯಾರೇಜ್ ಇದೆ ಸ್ವಾಮಿ. ಪಿಟಿಷನ್ ಆಲ್ಸೋ ಪ್ರೆಸೆಂಟ್, my lord.
ಯಾರ್ದು ಮ್ಯಾರೇಜ್ ಇದೆ?
The daughter, convicted prisoner daughter, my lord. The petition also present, my lord.
ಮ್ಯಾರೇಜ್ ಇದೆಯಾ?
Next week 26 ಇದೆ ಸ್ವಾಮಿ. Annexure C is invitation card, my lord.
The imprisonment certificate number, page number 9, my lord, annexure A. The only 15 days, my lord, for the purpose of only marriage, my lord.
He has done only 2 years, 5 months.
Yes, my lord. The only, ಯಾಕಂದ್ರೆ ಅವ್ರಿಗೆ ವಯಸ್ಸು ಆಗ್ತಿದೆ ಸ್ವಾಮಿ, only marriage purpose ಅಷ್ಟೇ ಬರುತ್ತೆ, ಏನಿಲ್ಲ ಸ್ವಾಮಿ.
Life imprisonment.
Only for 1 day with police bandobast.
Please, please.
For the marriage.
Please.
At least 1 week ಅದು ಸ್ವಾಮಿ.
What, we can't give police, you will pay for 7 days.
No, my lord, at least.
Better. 1 day let him attend the function.
My lord, in prison manual, my lord, 638 class B class 1 ಅಲ್ಲಿ not less than 2 years ಅಂತ ಇದೆ, but ಇಲ್ಲಿ 2 years 5 months ಅಂತ ಇದೆ, so at least 1 week, my lord.
We are not granting you no parole for less than 5 years. You want us to reject or 1 day in beg?
No, my lord, at least on 3 days, 3 days, 5 days, my lord.
Petitioner, daughter is before this court seeking for parole of her father, CTP number 14309, Shivappa, who had been convicted for offences under section 302, 143, 147, 148, 149 and 120B of the
Yes, ma'am.
at 4:30.
Yes.
On 26/8/26 at 4:30 p.m., 4:30 a.m. It would be required for the father to participate in the said wedding, since it is the wish of the daughter that her father participates in the said wedding. In that view of the matter, parole for 2 days is granted from 25/8/26 to 26/8/26. The détenu shall report back to the, shall surrender to the jail authorities by 9 a.m. on 27/8/2026, subject to so and so condition.
Much of it.
This order may be available, my lord. They'll have to.
ಬೇಗ ಕೊಟ್ಬಿಡಿ.
33.
For the petitioner, my lords.
Yes.
My lords, the notice issued by my lords, respondent number 1, police, my lords, is impugned. My lords, the petitioner, my lords, purchased, my lords, land piece, my lords, under a registered sale deed. My lords, subsequent to my lords sale, a complaint, my lords, is registered as against the vendor of the petitioners and the petitioners also. My lords, crime is registered. My lords, we are arraigned as accused number 3 to 5, my lords, in the FIR, which your lordship, my lords, will find at page number 17, my lords. Thereafter, my lords, report is filed. My lords, in the report, my lords, we are left out from the array of accused. We are made witnesses. My lords, charge sheet is filed into court. My lords, court takes cognizance. Now, subsequent to taking of cognizance, my lords, these notices are issued. My lords, my respectful submission is, my lords, pursuant to, my lords, cognizance being taken. My lords, without the leave of the court, my lords, there cannot be any further investigation. Notice, my lords, on the face of it is without jurisdiction.
Yes, madam.
Lord, charge sheet is filed, my lord, but whether any application was made, that I'll have to assert.
No application is made, my lords. I have produced the order sheet, page 93.
We'll stay it for now. You place it on record. If that is so, we'll vacate it. And AG accepts notice for respondent number 1, issue notice to respondent number 2, written by 29 September. The submission of learned counsel for the petitioner is that in crime number 708 of 2024, a charge sheet has already been laid and has been accepted by the jurisdictional court. Thereafter, notice has been issued under section 35(3) of the BNSS 2023 on 13/8/2026 without any particular direction by a set
Yes,
court
ma'am.
for reinvestigation or further investigation. In that view of the matter, the operation of annexure notices at annexure A, A1 and A2 are stayed till the next date of hearing, and AGA is directed to place on record if any orders have been passed for further investigation or reinvestigation. If such orders are passed, the interim order would be, the vacation of the interim order would be considered
Deeply obliged.
on that basis.
34.
This is a case wherein this honorable court had passed a direction to the passport authorities to consider my application and issue passport SVP. Application was considered, passport was issued, dispatched on February, taken back telling that one of the order is missing. I have produced that order before them. All the
Certain cases pending in Hyderabad were suppressed. Later we came-
Suppressed.
No, Your Lordship, we have filed an affidavit before this honorable court. The affidavit is on record before this honorable court in the connected matter, which is already disposed of.
So on accepts notice for respond number 1 and 2. Put up the file, registry is direct, put up the file in WP number 28315 or 25.
Much of.
But have you disclosed it in the application?
We have given an affidavit along with court orders. This court has considered. For a moment, let annexure B be looked into. Annexure B, this honorable court, by Your Lordship, has passed an order at ink page number 25. The petitioner is permitted to file necessary applications for reissuance of the passport accompanied by all orders passed in the pending proceedings where the petitioner has been permitted to travel abroad.
So
Though
it
the
has-
said permissions, this honorable court has looked into these permissions to be granted in respect of the old passport number. All the permissions were given. Now they are telling that one case was not informed. But let the annexure C be looked into, Your Lordship. That is not the reason. They are telling that it was unclaimed. Show cause notice against returned undelivered passport. They are telling that it is unclaimed, but the subsequent mail communication tells that I have suppressed something, wherein I have passed the acquittal order of the honorable court in Hyderabad at annexure H, Your Lordship, ink page number 42. I have been already acquitted.
Been recalled or unclaimed?
Which was unclaimed. Later on, we received 2 legal notices from the complainants in the cases pending in Hyderabad. And those cases we have sent for verification.
My Lords, I am passing.
File it.
I'm passing the judgment of the Honorable High Court wherein
You've suppressed it, you have
I have not suppressed it. There is an acquittal order.
Just see what you have filed.
My Lords, I have my travel dates. Last time also they have done the same thing. It is a SVP valid only for 1 year. They have already issued in the month of December.
There is a serious allegation made against you that you have suppressed. Just by using a
Lords,
loud
there is-
voice, it won't make any
My
change.
Lords, that is the submission made before this Honorable Court. There is no mail communication to
Not
that.
been what has been considered in that matter.
It was considered.
Where is it? Show us.
With regards to the,
If it is not there, we'll dismiss your petition.
My Lords, I have filed an affidavit to that extent before this Honorable Court in the
We
connected
have only
matter.
asked you to furnish details of all pending cases.
Yes, Your Lordship. I have furnished it before this Honorable Court, considered by this Honorable Court on the old passport number.
Mr. Counsel, you are now making a false statement which is not recorded in the order sheet.
My Lords, it's not recorded in the order sheet, but I have already produced it before this Honorable Court.
We'll only go by what is there in the order.
Much obliged. Let that be
This order
connected.
is only to say that furnish all the details.
Truly, Your Lordship. I have furnished it.
If you have furnished it, well and good.
I have furnished
If you have not furnished it, then you will never ever be issued the passport.
it. My Lords, I agree with that. My Lords, the only reason
Yes,
why
sir.
they, my Lords, let
We
it
list
be.
on 25th August.
My Lord, 24th if the court is convenient.
Next.
Much obliged.
Archana KM.
Yes, madam.
My lords, respondent number 3 files a complaint alleging a medical negligence before respondent number 4, my lords, files a complaint alleging a medical negligence before respondent number 3 police. The respondent police issue notices summoning the doctors and nurses to the police station under section 94. Your lordship may kindly see section 94 only. It is exercisable only within some
What
jurisdiction.
is that?
Jacob Matthew,
Jacob
my lords, they
Matthew.
have not followed.
How do you?
Lordships may kindly perish. The child is in vegetative state and moreover complaint is also not produced along with this.
complaint is not produced to me either, my
If the
lords.
medical board were to opine, you can't take any action. You refer it to the medical board. If a complaint has been received, it has to be referred to.
May I
That's what
take your
the
lordships
Supreme Court
through?
has said in Jacob Matthew.
My lords, at Martin D'Souza, the Supreme Court has laid down, my lords, ee tara complaint bandre yen madbek. Your lordship may kindly have a look at 116 in Martin F. D'Souza, my lords. That judgment ali, may I- 116, my lords. Page 22. May I read, my lords?
Yes.
Yes. We therefore direct that whenever a complaint is received against a doctor or a hospital by the consumer for a so-and-so or by the criminal court, then before issuing notice to the doctor or hospital against whom the complaint was made, the consumer forum was made, the Consumer Forum Criminal Court should first refer the matter to the competent doctor or a committee of doctors specialized in the field relating to which the medical negligence is attributed. And only after that, the doctor or committee reports that there is any prima facie case of medical negligence, should notice be then issued to the concerned doctor or hospital. This is necessary to avoid harassment to doctors who may not be ultimately found to be negligent. We further warn the police officials not to arrest or harass the doctors unless the facts clearly come within the parameters laid down in Jacob Matthews' case. Otherwise, the policemen will themselves have to face the legal action. Well, the Supreme Court has laid down time and again they
facts
issue
of the
notices
case.
harassing the doctors, asking them to come to the police
And AGA
station.
accepts notice for respond number 1 to 3, notice, issue notice to respond number 4, returnable by 29 September. The grievance of the petitioner at this stage is that on a complaint filed by respond number 4, the petitioners, as also the representatives, the nurses of respond number 4 clinic have been called to the police station, which is contrary to the direction which have been laid down by the Honorable Apex Court in Jacob Matthew versus State of Punjab and others, 2005-6 SEC 1, more particularly para 51, 52, 53 thereof, which are reproduced hereunder for ease reference. Submission of learned counsel for the petitioner is that the said requirements laid down by Jacob Matthew in Jacob Matthew was followed recently by Idu Markanday Kajju was 2009 in Martin recently was also followed in civil appeal number 3541 of 2002 dated 17/2/2009, more particularly para 1 and 6 thereof, which is reproduced hereunder for ease reference. A perusal of the decision in Jacob Matthew as also Martin D'Souza would indicate that the police cannot be issuing notices calling upon the doctors to attend to the police station and or arrest a doctor against whom rash or negligent act or omission has been alleged without an independent competent medical opinion from a doctor in government service qualified in that branch of medical practice. In Martin F. D'Souza, it has been held that a doctor or committee of doctor's report is required to be obtained as to whether there was a medical negligence on part of the doctors against whom allegations of negligence have been made prior to initiating or prior to taking up any action by the police authorities. In the present matter, admittedly, there is no opinion of a doctor or a committee of doctors which has been obtained by the respondent before notice was issued. Hence, the operation of the notice dated
4/8/2026.
4/8/26 at Annexure A is stayed till the next date of hearing. It is however made clear that the stay of the said notice will not come in the way of the respondent seeking for referring the matter to a a committee of doctors or a medical board, obtain necessary report therefrom, and thereafter take necessary action.
Grateful.
Relist on so and so date.
Date, madam.
29/9.
20.
Yes.
In this case, my lord, we had filed an application before the NCLT, my lord, seeking for an under IA number 770, my lord, seek application to suspend, to remove the respondent here in, my lord, as the official OL, my lord. She was appointed on 1/6/2026, my lord, on the short ground that, my lord, the State Bank of India, which had instituted the proceeding, she is on the panel of State Bank of India, my lord. So therefore, she would not be fair, and her conduct also after appointment of 2nd June, various reasons have been given, my lord, saying that she should be removed. Whether she should be removed or not, the application has to be decided. Pending that application, my lord, the respondent had filed certain application for sale of property, various things. My application for her removal is kept pending. The rest of the applications are decided. We file a early hearing application also, my lord, that is not taken up. Then this IA which we filed comes up before the court. They said you have already filed an early hearing application, so we will not take up this IA to early hearing to hear this IA for a removal. We'll say that we'll hear it be heard.
Honestly, is not instructed. Advocate on record and I both appeared on 17th, and he is present today in court. So am I. On 17th, the NCLT has said the auction is on 5th. Since you are expressing urgency, your application will take it up on the 1st. It's coming up on the 1st. There is writ petition infrastructure. The advocate on record who is appearing today himself made that request. And in my presence, the NCLT has said we will consider your request.
Auction is on the 5th.
This application is coming up on 1st.
Your Lordship, Your Lordship, my only, as I understand, let the matter be heard on 1st and disposed of on record.
Both the submission, and we will raise record that we.
If they want it earlier, we have no problems with that.
Please, Manoj, that would be even better, Manoj. If my learned friend says, permit us to advance the matter for Monday and let the application be heard and.
Notice to respond number 1 is dispensed with.
Just one request. Since my learned friend is saying they may move for advancing, I have still to find my objection. The liquidator was granted time to
We'll fix the dates. Is dispensed with. Srinandan Kartikeya, who is filed caveat, accepts notice for respond number 2. Petitioner is before this court seeking for the following leaves. The submission of Shri Shashikin Shetty and senior counsel is that an application had been filed in IA number 770 of 26 in CPIB number 103 stroke capital BB stroke 2018 seeking for removal of the liquidator stroke resource person. Liquidator or
Liquidator. As she is empaneled with the State Bank of India.
Respond number 2. The said application has not been considered and the auction is scheduled on 5th September 2026. The Dhananjay Joshi and senior counsel would submit that when the matter had been taken up on 17/8/2026, 17/8/2026, the matter has been adjourned to 1/9/2026, which is prior to the auction, and that on 1/9/26 or any other previous day, if the matter is so advanced, the respondent number 2 would be ready to address arguments if on the NCLT taking up the matter. So when will you file your objections? His submission is that objections to IA 770 of 2026 would be filed by 25th August 2026. If that be so, reserving liberty to the petitioner to advance the matter on 27th August 2026. Then first only. 31st it won't be working because 31st is Monday. First is there. Then no need to.
Sorry to say, they want to go ahead with the sale of a property, but they don't want the application for reward to be considered. So therefore, the whole conduct.
If there are holidays and first is the date which has been fixed, will be filed by 25th after serving a copy thereof on the counsel for the petitioner. The said submission is placed on record. Since the matter is now posted on the 1st of September and the auction is scheduled on the 5th of September, it would but be required that IA number 770 of 26 be considered and disposed before the auction is held, placing the submission of both the councils that they will cooperate with the NCLT and address arguments on the 1st of September 2026 without seeking for any adjournment. The petition stands disposed, directing the NCLT to dispose IA 770 of 2026 before 5/9/2026.
4/9. Fifth is the auction.
Before
Let them-
5/9.
Only request, let them not precipitate the matter till then, because the reason is this, my lord. The auction purchasers are coming, visiting and taking a look at this property, my lord, so that till then, my lord, including there are tenants.
Let them look at it. We don't know if you fail in your application.
Well, my lord, apart from this, we have asked for a stay also of the auction, my lord. Let go.
That is for the NCLT to decide.
So your worship, along with it, the stay of auction also may be considered on,
IA number?
in the same application.
Same application. You directed it to be disposed before that day.
Great.
37. Navina Jia.
Lordship, for the petitioner, Lordship, the petitioner is before this court for the writ of certiorari and mandamus. Where he was asking for the washing of 3 endorsements from respondent number 2, 3, and 4, and also issue the writ of mandamus to issue the caste and income certificate for the category 3A, considering only the parents' income, Lordship. The last date of
Income of the petitioner has to be taken, cannot be taken into consideration.
So
The Supreme Court has held no, that in another matter it was pointed out to us. Where the decision, Mr. Counsel? In 2014-15 SEC 767.
page number 9. Page number 9, Lordship. Page number 9.
This person is already working. He's working, he already generates an income.
The case before the Supreme Court is also the similar, Lordship.
In-service candidate has to be excluded until. That's what Supreme Court has said. Read para 11, the last extracted portion. It is clarified that the creamy layer status of a candidate is determined on the basis of the status of a parent, not on the basis of his own status or income. What is the judgment that you are referring to?
Same,
Is there a
friend.
judgment by our court?
Lordship,
Yes, one
there
issue.
are judgments from our court, but it's for the spouse case. But
No, for your own individual this one.
individual case, I think the same Supreme
There's
Court
one
judgment.
issue here, whether it's been adopted in the state of Karnataka is what could be there. And same Surinder Singh only you are referring.
Yes, Lordship.
This is recruitment for which post?
This is for the KPSC Group A and Group B post.
This is DOPT for Union of India posts. So the issue would be whether that has been adopted. And if you look at para 12, they say that the above determination of the Government of India was adopted by the state of Punjab as is apparent from a letter issued by the Government of Punjab. Therefore, Punjab is bound by it
Yes, Lordship.
because it was adopted.
It was adopted, but it was challenged before the High Court. In High
No,
Court,
See, DOPT issued the regular clarification in para 11.
yes, Lordship.
That clarification was adopted by the state of Punjab.
Yes, Lordship.
And therefore, it was said if state of Punjab has accepted it, it apply to the state electricity board.
Yes, Lordship.
State electricity board was the respondent there.
Yes, Lordship.
Now, is this DOPT para 11 accepted by the state of Karnataka?
Not explicitly, Lordship. Not explicitly.
Expressly, illandre it won't apply.
But Lordship, the same judgment has been quoted by the Honorable High Court. Even though this Surinder Singh is a self case, it has made clear for him or her or spouse. It has been made clear for that reason only. Even though it's a self case,
There's a judge. Any judgment of our court?
not for the self, but for the spouse. There it's there.
Show us that judgment. What is
It's
it?
there in the page number.
Page number?
108, Lordship. In Yogeshwari was the state of Karnataka.
108.
Yes, Lordship. Lordship, sorry, page number 101. They started quoting Surinder Singh. Page number 101. Wherein in paragraph 9, 10, 11, it is held as under.
Has this judgment consider the adoption of the DOPT?
It's not about the adoption of DOPT, Lordship, but it's about they have made an observation that the state has they have not acted, even though there is a judgment from this honorable court. It's more on. I agree. Both Yogeshwari and Muthulakshmi are related to the spouse case, but both of them are referring to the Surinder Singh case because in Surinder Singh case they have made it clear.
Where are they referred to Surinder Singh in this?
Lordship,
Is the reasoning
in page number 100 in Yogeshwari. Page number 100. In the last 2-3 lines, Lordship, the dictum of the Honorable Supreme Court in the case of Surinder Singh versus State of Punjab, Electricity Board, Patiala and others, in AR number 2015, SC 537, wherein paragraph 9, 10, 11, it is held as under. Based on the aforesaid declaration of law, we are of the view that it was not open to the High Court to evaluate.
Don't read that again.
Yeah. And the same has been quoted.
What is this government order dated 33/2002? Do you have a copy of that?
Yeah, Lordship, in page number 59 to 74. Page number 59 to 74.
59.
59 to 74. The relevant portion is there in page 74, Lordship. In the table second row, Lordship. ಅಭ್ಯರ್ಥಿಯು ಮತ್ತು ಅವನ ತಂದೆ ತಾಯಿ ಪೋಷಕರು ಸರ್ಕಾರದ 1ನೇ ಅಥವಾ 2ನೇ ದರ್ಜೆ ಅಧಿಕಾರಿಗಳಾಗಿ ಸೇವೆ ಸಲ್ಲಿಸುತ್ತಿದ್ದಾರೆ ಅಥವಾ ಸಾರ್ವಜನಿಕ ಉದ್ಯಮಗಳಲ್ಲಿ ತತ್ಸಮಾನವಾದ ಹುದ್ದೆಗಳಲ್ಲಿ ಹೊಂದಿದ್ದಾರೆ ಅಥವಾ ಖಾಸಗಿ ಕೈಗಾರಿಕೆ ಸಂಸ್ಥೆಗಳ ಉದ್ಯೋಗಿಯಾಗಿದ್ದು 2ನೇ ದರ್ಜೆ ಅಧಿಕಾರಿಯು ಪಡೆಯುತ್ತಿರುವ ವೇತನ ಶ್ರೇಣಿಗಿಂತ ಕಡಿಮೆ ಇಲ್ಲದ ವೇತನ ಶ್ರೇಣಿಯ ವೇತನ ಪಡೆಯುತ್ತಿದ್ದಾರೆ ಸೊ ಮತ್ತೆ ರೋ ನಂಬರ್ 3, Lordship. ಅಭ್ಯರ್ಥಿ ಮತ್ತು ಅವರ ತಂದೆ ತಾಯಿ ಪೋಷಕರ ಒಟ್ಟು ಆದಾಯ 2 ಲಕ್ಷ ಮೀರಿದ್ದಾರೆ. Lordship,
ಅಭಿವೃದ್ಧಿ ಅಂತಿದೆಯಲ್ಲಪ್ಪ.
Lordship, this is 2002, but the Supreme Court judgment came in 2014, Lordship.
Supreme Court judgment was in connection with the adoption of the DOPT by the state of Karnataka, by the state of Punjab. It's not been adopted in the state of Karnataka,
Lordship,
unless you show us that it's adopted.
Lordship, it's not explicitly adopted, but the question is, in the Surinder Singh case, they made it clear, they quoted 1993, 2002, 2004 DOPT memorandum of the memorandum which is given by the DOPT. They quoted that, and then they claim they made the directions the income of the parent should alone be considered and not that of the.
Read para 12 of Surendra Singh and understand what it says.
Yeah, Lordship. I agree.
Because it was adopted by Punjab.
Yeah, Lordship. If I may.
Unless you show that it's adopted by Karnataka, we can't do that. Has it been adopted by Karnataka? Shamant.
Not adopted.
Because if that is not adopted in Karnataka, it's 2002 which will apply.
Lordship, the reason why we have not challenged 2006 is the very reason respondent number 2 has rejected our prayer is on the 1986 order. And the 1986 order has been told unsustainable in both Muthulakshmi and Yogeshwari's case, Lordship. Because in the original petition, page number 25, Lordship, if I see the endorsement given by the respondent number 2, Lordship, page number 25, Lordship. ದಿನಾಂಕ 18/9/2024 ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಹಾಸನ.
What is this document?
This is the endorsement given by after the meeting, Lordship.
Yes.
We went for an appeal. ಅಧ್ಯಕ್ಷತೆಯಲ್ಲಿ ನಡೆದ ಸಭೆಯಲ್ಲಿ
ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಾ ನೀವು?
Lordship, page number 25.
25. Yes.
ದಿನಾಂಕ first line, Lordship.
ಹಾ.
ದಿನಾಂಕ 18/9/2024 ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಹಾಸನ ಜಿಲ್ಲೆ ಹಾಸನರವರ ಅಧ್ಯಕ್ಷತೆಯಲ್ಲಿ ನಡೆದ ಸಭೆಯಲ್ಲಿ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಹಿಂದುಳಿದ ವರ್ಗಗಳ ಕಲ್ಯಾಣ ಇಲಾಖೆ ಹಾಸನರವರ ಅಭ್ಯರ್ಥಿಯು ಸಲ್ಲಿಸಿರುವ ಗೌರವಾನ್ವಿತ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಬೆಂಗಳೂರು ಇಲ್ಲಿಯ ರಿಟ್ ಪಿಟಿಷನ್ ಸಂಖ್ಯೆ ಸೋ ಅಂಡ್ ಸೋ ಲತಾ ವಿರುದ್ಧ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಬೆಂಗಳೂರು ನಗರ ಅಂಡ್ ರಿಟ್ ಪಿಟಿಷನ್ ಸೋ ಅಂಡ್ ಸೋ ಯೋಗೇಶ್ವರಿ ಈ ಪ್ರಕರಣಗಳಲ್ಲಿ ಸಿಂಧುತ್ವ ಪ್ರಮಾಣ ಪತ್ರವನ್ನು ನೀಡಲಾಗುತ್ತಿದೆ. ಸದರಿ ಆದೇಶಗಳನ್ನು ಪರಿಗಣಿಸಿ ಜಾತಿ ಮತ್ತು ಆದಾಯ ಪತ್ರವನ್ನು ನೀಡುವಂತೆ ಕೋರಿದ್ದಾರೆಂದು ಹಾಗೂ ಸದರಿ ಅಭ್ಯರ್ಥಿಯು ಜಾತಿ ಮತ್ತು ಆದಾಯ ಪ್ರಮಾಣ ಪತ್ರವನ್ನು ನೀಡಲು ಸರ್ಕಾರದ ಆದೇಶ ಸಂಖ್ಯೆ BCM EST 1 CR so and so 8687 which is published on 23/12/1986 ಆದೇಶದಲ್ಲಿ ಕುಟುಂಬದ ಉತ್ಪನ್ನ ಫ್ಯಾಮಿಲಿ ಇನ್ಕಮ್ ಎಷ್ಟೆಂದು ನಿಗದಿಪಡಿಸುವುದಕ್ಕೆ ಅರ್ಜಿದಾರನ ಉತ್ಪನ್ನಕ್ಕೆ ಅವನ ತಂದೆ ತಾಯಿ ಉತ್ಪನ್ನವನ್ನು ಸೇರಿಸಬೇಕು. ಅರ್ಜಿದಾರನು ತನ್ನ ತಂದೆ ತಾಯಿಗಳಿಂದ ಕಾನೂನು ಪ್ರಕಾರ ನೋಂದಾಯಿಸಿದ ದಾಖಲೆಗಳ ಮೂಲಕ ಬೇರ್ಪಟ್ಟಿದ್ದರೂ ಅವನ ಉತ್ಪನ್ನಕ್ಕೆ ಅವನ ತಂದೆ ತಾಯಿ ಉತ್ಪನ್ನವನ್ನು ಸೇರಿಸಿ ಎಂದು ಸ್ಪಷ್ಟೀಕರಣ ನೀಡಲಾಗುತ್ತದೆ ಎಂದು ಸಭೆಯಲ್ಲಿ ವಿವರಿಸಿದರು. This 1986 order has been told unsustainable both in Yogeshwari and Muthulakshmi, Lordship.
Where is that?
Lordship, if I take your attention to page number 126, Lordship.
136.
126, Lordship.
126.
Yeah.
Yes.
Yeah. They quote the Akshata Chogle case, Lordship, in the first para. It is rather surprising that the state is time and again repeating the very same mistake and driving the applicants to knock the door of this court despite the declaration of law by the apex court and that of this court by clinging to the government order dated 12/12/1986, which is on the face of it is unsustainable. Therefore, it is for the state government to direct the selecting authorities to act in tune with law and not contrary to the law. It is high time the state sets its house in order and refrain from generating unnecessary litigation. Lordship.
1986 order.
Yeah.
2002 order.
And my cancellation is based on 1986 order, Lordship.
This is 12/12/1986.
2002. That's what is placed on Lordship since the order sheet also.
Lordship. And if you look,
The order which has been mentioned is referring to 23/12/86
yes, Lordship.
at page 25. You don't have the petition. Okay.
It's your.
They have not scanned it for you. 25 is 23/12/86. Now this order that you are referring to, you are referring to 12/12/86. So this is different again.
No. 1 minute. 23/12. Lordship, 1 minute.
What is this 23/12/86?
1 minute. Lordship. 31. Lordship, sorry, it's wrongly submitted in the memo. It's Lordship, if you go to page number 31st, Lordship, in the judgment.
Page
31.
31, yes.
In the last para, heading, Sarkari Adesha Sankhya DPR, there they mention Dinanka 12 December 1986. But in the so I think in the order sheet they have mentioned wrongly as 2312.
Show the judgment. You can't be relying on one para of that judgment to make that it is wrong. Please don't make those kind of submission on judgment. Show us this 2023 SEC Online Karnataka 168. Let us verify that. And you have referred to this 231286. Is there a separate 231286? This 121286 is matching with the judgment. Sorry,
yes,
it's wrong. Allah, you heard the wrong and now uncontrolled. 121286 is what is referred to in the judgment. There's no issue about it. NIM order ಅಲ್ಲಿ there is a mentioning of 231286. Where is that 231286?
We didn't find any government order on that particular.
Yaudappa 231286. So there, this one is last date. Some KPSC last filing is when?
31st, Lordship.
31st.
We have to get
So
This for premature release, my lords.
Approved?
My lords, it's been recommended, my lords, sent to union government, my lords. It's pending for last 4 years, my lords.
Union government. Who is appearing for union government? Yes. Union government, anybody here?
Welcome.
Yes, Mr. Chanchud. CGC for R1.
Objections
On
are filed.
maintainability, it has come. It's come on maintainability.
Maintainability of WP.
Welcome, my lord.
My lords, the petitioner is presently lodged in the Belgaum prison, my lords. But this is the second round of litigation, my lords. I have already filed a similar petition earlier, my lords, in the year 2024. So, kindly see page number 111, my lords.
Mr. Counsel,
Annexure.
if we file 10 petitions like this also, it will be 10th round. Is in Belgaum, so you'll have to file it there.
Lords, kindly see page number 111, my lords, Annexure E, my lords. This honorable court, my lords, granted me parole with the same prayer I had approached, my lords. So honorable court granted me parole, my lords, pending the consideration of my premature release.
So that issue was not raised.
It was raised, my lords. Similar.
Where is it not dealt with here? How can it be said to be raised?
It was para number 2, my lords.
Yes.
The petitioner has served imprisonment for more
Where is it dealt with the maintainability?
not on maintainability.
Now the objection has been raised on maintainability because your client is in Belgavi prison.
Please, my lords.
So you'll have to file it in Dharwad.
My lords, already one round of litigation has happened, my lords, here, and this honorable court had granted, my lords.
Registry has raised the objection.
My lords, one
As
request,
regards-
my lords. My lords, it may be placed before the Dharwad bench, my lords.
You file a fresh petition before Dharwad bench.
My lords, already, my lords, had filed in February, my lord, this petition. Our union has already filed its objection also, my lords.
ಇದು Chief Justice ಮುಂದೆ place ಆಗ್ಬೇಕಾ transfer ಗೆ? Learned counsel for the petitioner seeks permission for the above petition to be transferred to the Dharwad court.
Please, my lords.
Registrar Judicial is directed to look into the matter and follow the necessary procedure
Request, my
for
lords.
such transfer.
Lords, interim prayer, my lords, have asked for pendency.
We have no jurisdiction.
Please, my lords.
That is why we are saying we have no jurisdiction.
Great.
Pending transfer.
39. Venkrappa GB.
Lordship, I am for the petitioner, Your Honor.
Yes.
Lordship, she is the daughter-in-law of that house. Her husband also died. And due to finance, without finance, she discontinued her daughter education also and married and given your honor. Son studying in, she have nothing, your honor. If this honorable court not order, she become destitute in the world, your honor. She have no any house. So, and another one, they given false report. She is government employee telling your honor. Ali is like lower,
Mr.
honorable lower
Counsel,
court also.
what is the facts? What is the legal argument? You are a lawyer. Please
About
argue
petitioner,
legally.
I am telling your honor.
ಆಯ್ತು ಪೊಸಿಷನ್ ಹೇಳಿದ್ರಿ ನೆನ್ನೆನೂ ಹೇಳಿದ್ರಿ ಆಮೇಲೆ ರೆಡಿ ಆಗಿ ಬರ್ತೀನಿ ಅಂದ್ರಿ ಅದು ರೀಚ್ ಆಗ್ಲಿಲ್ಲ ಇವಾಗ ಅದು ರೆಡಿ ಆಗಿದ್ರೆ ಕರೆಕ್ಟ್ ಆಗಿ ಲೀಗಲ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಮಾಡಿ ಎಸ್ ಲಾಯರ್
Lordship, she is the daughter-in-law for respondent number 3, your honor. And the gift deed for her honest and sincere work, she land gifted to the daughter-in-law, your honor. And husband died after her daughter, 2 daughters are there. They converted to Muslim. It is not important. They are instigated to the mother. Previous mother was with the daughter-in-law and son. When they started to contact with the mother, that time they entered the mother house and instigated to her, you do not donate this land to her, we are taking care. But today also, that petitioner is very much loving her mother-in-law and she ready to take care, and this honorable court take on record, your honor, and not allowed to her to become destitute only. My submission, your honor. Again, you will stay that operation of the order of the honorable court's next proceedings, your honor. My humble submission.
Has the matter been referred to mediation anytime? Had you gone for mediation?
No.
Briefly, what has happened is, my lords, in the year the respondent number 3 is present before this honorable court. She was living with her son and daughter-in-law. In 2010, she gave a gift deed on a condition that the daughter-in-law was taking care of her. In the same year, my lords, one day, and this is admitted in their petition, they leave the house where respondent number 3 is staying, which was a rented house. Overnight, they collect everything in the house that is there when the respondent number 3 was not in the house. They run away from the house, set up her own house of theirs, including taking all the property papers, etc. And since 2010, after the gift deed, she's been on her own. Not a single rupee they have given to take care of her. And which is why I kept the respondent number 3 present. Your lordship can verify facts. Every pleading that is submitted to this honorable court is not at all on record, neither is it.
This gift deed was executed in the year 2010.
2010, my lords, and there is a condition in that gift deed, my lords.
You filed a suit in 2011.
Please, my lords, there was a suit. Now what has happened is.
Declaration of the gift deed to be bad.
Please, my lords.
Or void.
To declare the gift deed to be null and void. The intention was to get the property back. I understand that there has been a situation in the past where the legal route that she's taken.
That suit has been dismissed.
Please, my lords.
On 1st February 2016. After dismissal of the suit, you filed this application as Senior Citizen Act.
Please. My lord, the fact of the matter, I understand where your lordship is coming from. There is no forum shopping here, my lords. She's been misguided in terms of which forum to approach.
Now you have approached that, you have to file an appeal from there.
We have approached.
By that
we have
judgment.
approached. We did approach the AC tribunal, and there was an order that went against us. We are on appeal before the DC, my lords.
Not the DC. You filed a suit in OS 114 of 2011.
We've taken that gift deed as valid, my lords. We lost that case. We didn't appeal. We've taken the validity of the gift deed, my lords.
You can't be in all the, we understand senior citizen,
My
yes.
lords, I understand, my lords.
You can't be on different forums.
I understand, my lords. The intention
After
was
your son expires, you go on.
My lords, son expiring has nothing to do with us, my lords. The son has not even been living with me since 2010. The son has always been in the care of his wife. So in fact, what I understand from what happened is the son didn't want to come back to the mother because he was so ashamed and he died on the road is what I've been told by respondent number
Don't
3.
make presumptuous arguments.
My lords, I'm not
We
making
argue on the
presumption. I'm
basis of
only
the
saying
document.
what I understand.
We
But
argue
my
on
lords,
the basis of
the
documents.
truth of the matter is since 2010, I've been left on my own after giving the property. There has been a situation where I went to civil court, but I've accepted that gift deed. And basis a condition in the gift deed, I'm presenting my case. If there was no condition in the gift deed, Your Lordship, I wouldn't have a case under senior
Is the
citizenship Act.
gift deed?
Page 22, annexure B, my lords.
Lordship, 40,000 rupees pension coming.
My lords,
That
that's
also
immaterial,
super-
my lords.
Today also telling her she is government employee. She
Age?
is not government employee. Your
My lords, the
Honor.
last 3 lines.
Yes.
ಶೀಲ ಆದ ನೀನು ನನ್ನ ಪ್ರೀತಿಯ ಸೊಸೆಯಾಗಿದ್ದು ನನ್ನ ಜೀವನ ನಿರ್ವಹಣೆಯಲ್ಲಿ ಸಹಕರಿಸಿಕೊಂಡು ಬರುತ್ತಿರುವುದರಿಂದ ಕೆಳಕಂಡ ಜಮೀನು ನಿಮಗೆ ದಾನವಾಗಿ ಕೊಟ್ಟು ಇದರ ಮೇಲೆ ನನಗಿರುವ ಪ್ರತಿಯೊಂದು ಹಕ್ಕುಗಳೊಂದಿಗೆ ಕೆಳಕಂಡ ಸಾಕ್ಷಿದಾರರ ಮುಕ್ತ ಈ ದಿವಸ ನಿಮ್ಮ ಸ್ವಾಧೀನಕ್ಕೆ ವಹಿಸಿಕೊಟ್ಟಿರುತ್ತೇನೆ.
Where is this one of taking care?
My lords, the property was given with an intention that she's been taken care and she'll continue to, my lords.
Where is continue to take care only there?
My lords, I understand. The way it has been worded is not very specific, but the intention is very clear.
Because immediately we have intervened. This is a 2010 gift deed. You filed a suit in 2011. You failed in that suit. And thereafter you go under senior citizen. That is really forum shopping.
My lords, she's been misguided in terms of legal representation. I understand.
We
I
can't
understand
get
what has
into
happened.
misguiding. If she's been misguided by somebody, she can take action against that person who was misguided.
Lordship.
Not like this.
My lord,
After
but the
having failed.
state of the matter has always been that I've not been taken care.
Lordship, who misguided that fact before this honorable court? 40,000 rupees of pension suppressor. And she is government employee telling. She is not government employee, Your Honor.
Who is not government employee?
That government 40,000 rupees pension getting, that also not stated in the petition, Your Honor.
My lord, in fact, your lordship, in your lordship's judgment has said that express recital and gift deed obligating the donee is not mandatory.
Yes.
Please,
Then please, and you have to look at the context and the facts.
Please, my lords.
That has been quoted before us, thankfully to us only. That was where the son went and got it registered, drafted it.
Right.
Here you have filed a suit also and failed. That cannot be a ground thereafter to come.
I understand, my lords, but the ground on which I filed the suit, the cause of action was different before both forums. But the truth of the matter is, my lords, the condition on which the gift was given is because she was taking care. And my lords, this fact situation is the very same year they desert me and they leave and they go away. So it's not that there is anything for them to show that they've been taking care of me.
It can't be like this.
My lord, I also have preferred an appeal before the DC, my lords.
The next operation of proceedings order.
Petitioner, daughter-in-law of respondent number 3 is before this court seeking for the following reliefs. Why have you filed an appeal before the deputy commissioner?
My lords, because in the AC's order has given me limited right, saying that I can't alienate the property. So with that regard,
Even that is going in this.
no, that's outside the jurisdiction of the AC. On that ground, we've challenged.
The petitioner is before this court, so and so. Respondent number 3, mother-in-law had filed a proceedings in MAG so and so 29 of 2526 under section 23 of the Senior Citizen Act, seeking for cancellation of the gift deed executed by her in favor of the petitioner on 9/12/2010, registered as document number BLU-1-01672-2010-11, stored in CD number BLUD 36 on 9/12/2010. Accepting the said complaint made by respondent number 3, the tribunal wide order dated 5/3/26 allowed the said application, granting third respondent limited relief of continuing with in the possession of the property during her lifetime, but restraining her from not ill and from alienating the said property. The submission of learned counsel for the petitioner is firstly that a suit had been filed by respondent number 3 in OS number 114 of 2011, seeking for a declaration that the gift deed dated 9/12/2010 is null and void and does not create any right, title, or interest over the property in favor of the petitioner who was the defendant therein. The said suit came to be dismissed while a judgment dated 1st February 2016 by holding that the gift deed was validly executed and that the claim of the plaintiff therein that she did not know what document was being executed and that fraud was played on her in obtaining the registration of the gift deed was rejected. The trial court categorically held that the gift deed having been executed, the gift deed being a registered document, the presumption of validity in respect of the said document. There is no rebuttal evidence of value which had been led by the plaintiff to rebut the presumption of such validity. And held that the plaintiff had failed to prove that the gift deed was null and void. It is much subsequently that an application had been filed under the Senior Citizens Act before the Assistant Commissioner in the year 2026, challenging the gift deed. This time contending that in terms of the gift deed, the petitioner daughter-in-law is required to look after the respondent number 3, mother-in-law. The son having already expired. When did the son expire?
2022 months.
Already expired in the year 2022.
The application came to be filed when my son was alive. The application came to be filed when my son was alive.
Sorry? Application?
The application before the AC came to be filed when my son was alive.
When did you file it? It was filed in 25/26.
My lords, now what happened is we already filed an application. An order was passed ex parte. They filed a writ petition and the matter was referred back to AC. So then.
What is that order?
They have not filed any.
Have you produced it?
Writ petition order is at Annexure D.
Annexure?
D months. There in that they didn't go into the merits of the case, but it was referred back.
Much later. Is immediately after the dismissal of the suit that respondent number 3 filed Proceedings in RA 176 of 2015-16, Senior Citizen Act, under Section 23 of the said Act. The said application had been allowed ex parte on 29/11/2018, which came to be challenged by the petitioner and her husband, the son of respondent number 3, in WP number 49898 of 2019, which came to be allowed on 23rd October 2025, remanding the matter to the first respondent by setting aside the order which had been passed. It is thereafter that the impugned order had been passed on. Thereafter that the said proceedings were re-registered as number 29 of 2526, and the impugned order was passed on 5/3/26. The submission of learned counsel for the petitioner is also that respondent number 3 is getting pension of rupees 40,000. She can take care of herself, and there is no requirement of the petitioner to take care of respondent number 3, inasmuch as petitioner's husband having expired, she is to take care of herself and her children without any income available to the petitioner. It is on that ground that it is submitted that the above petition is required to be allowed. The order passed by the Assistant Commissioner is required to be set aside. Learned counsel for the Ms. Neha Nagaraj, learned counsel for respondent number 3, would submit that from the year 2010, the son and daughter-in-law have deserted respondent number 3. There is no one to look after her. And thereafter, and it is for that reason that respondent number 3 has filed various proceedings seeking for necessary relief. Firstly, on account of the gift deed. Firstly, by challenging the gift deed on account of it being executed by fraud. And thereafter, since the gift deed was held to be valid by the civil court for maintenance and setting aside the gift deed by under Section 23 of the Senior Citizen Act. A submission is that the action taken by the third respondent is proper and valid. Insofar as the proceedings under Senior Citizen Act is concerned, the said act being a beneficial act, the benefit thereof is required to be granted to the senior citizen. On inquiry as regard the earlier suit, a submission is that the said suit was filed under wrong advice, being misguided.
I'm not aware of that.
That is
but
what you made.
I understand, my lords, but that is the submission of respondent number 3.
She submits on instruction of respondent number 3. She submits, who is present before this court, submits that the said suit had been filed under wrong advice, being misguided. The filing of the said suit, according to her, would not come in the way of a senior citizen exercising rights under Section 23 of the Senior Citizens Act. Heard, Sri Shankrappa Gurappa Banagar, learned counsel for the petitioner, Ms. Neha Nagaraj, learned counsel for respondent, the peruse papers. The question that would arise for determination in the present matter, short question that would arise for determination in the present matter, is whether on a senior citizen having challenge a gift deed or a deed of transfer under Section 20, deed of transfer by filing a civil suit, seeking for declaration that the said gift deed or a deed of transfer is null and void. On the rejection or dismissal of the said suit, could a proceedings be filed under Section 23 of the Senior Citizens So-and-so Act? The Senior Citizen Act is a beneficial enactment which has been brought about to cater to the requirements of a senior citizen, more so when the senior citizen is not being cared for by the children of the senior citizen. And it is for that reason that this court the tribunal, as also this court, would be liberal in construing any such application which is filed by a senior citizen. However, however, this court would also have to guard against the misuse or abuse of Section 23 of the Senior Citizen Act, which in this case, according to this court, is an abuse. Respondent number 3, having executed a gift deed on 9/12/2010 in favor of the petitioner, who is the daughter-in-law, had challenged the same by filing a suit in OS number 114 of 2011, alleging that the gift deed was secured by fraud. She had not been informed as to what was the document she was executing before the sub-registrar, that the document was stated to be a loan document and not a gift, that she was suffering from fever as on that day and was unable to understand the implication of executing the said document. All these contentions were negated by the judgment of the trial court dated 1st February 2016 in OS number 114 of 2011, after evidence was led in that matter. The basic ground in the said suit was that the senior citizen had never executed a gift deed. Shockingly, on the dismissal of the said suit on 1st February 2016, immediately thereafter, an application was filed under Section 23 of the Senior Citizen Act in RA 176 of 2015-16, which came to be allowed on 29/11/2016. 2018. Thus, the basic premise in an application filed under Section 23 is for the senior citizen to have admitted that a gift deed was executed by the senior citizen voluntarily. And under the said gift deed, there was an obligation imposed on the donee to to maintain and take care of the requirements of the senior citizen in the old age. Thus, the stand of the senior citizen changed diametrically from that in the suit filed in OS number 114 of 2011. In 114 of 2011, it being contended that the senior citizen not executed the gift deed. In RA 176 of 2015, it was stand taken was there was voluntary execution of a gift deed on the assumption that on the express understanding that the donee daughter-in-law would take care of the mother-in-law senior citizen. This is a diametrically opposite stand as indicated supra, which cannot be condoned even for a senior citizen. The said proceedings in RA 176 have been allowed ex parte. The daughter-in-law and the son had challenged the said order. The matter was the order was set aside and matter remitted, and subsequently the present order has been passed. The Assistant Commissioner, the Senior Citizen Tribunal, has only gone on the aspect of respondent number 3 being a senior citizen without considering the entire conspectus of the matter. Though OS number 114 of 2011 has been referred to in the order.
My Lord, one submission. The AC makes an observation in the order saying that the matter of fact is there is nothing on record to show she's been taken care of since 2000.
We're coming to that, madam. Though the suit in OS number 114 of 2011 has been mentioned and taken note of in the said order, the implication of the diametrically opposite stand has not been considered by the Senior Citizen Tribunal. The Senior Citizen Tribunal, having came to a conclusion that there was nothing on record which has been placed on record by the petitioner to show that she was taking care of respondent number 3 mother-in-law, had allowed the said application, granting limited rights to the mother-in-law to stay in the property without a right to alienate. This aspect of requirement to maintain, the daughter-in-law required to maintain the mother-in-law would have to be considered in terms of the gift deed dated 9/12/2010. The only clause which has been referred to by learned counsel for respondent is last clause at page 22, which reads as under. Perusal of the aforesaid extracted clause would only indicate that the gift deed had been executed out of love and affection. There is no particular obligation which had been imposed under the said clause on the daughter-in-law to maintain the mother-in-law. Thus, that clause would not come to the rescue of respondent number 3 to come within the purview of section 23 to contend that the gift deed had been voluntarily executed on the express understanding that the daughter-in-law will take care of the mother-in-law. There's one other aspect that would have to be considered here, inasmuch as Senior Citizen Act, that a child as defined, the children as defined under clause A of section 2 would only include a son, daughter, grandson and granddaughter, but does not include a minor. A daughter-in-law is one who is not one who is mentioned in clause A of section 2. Thus, on the expiry of the son, the continuance of the proceeding under a gift deed, the gift deed having been executed in favor of the daughter-in-law and not in favor of the children, section 23 would ex facie not be applicable unless it is shown that there was a explicit understanding that the person other than that mentioned in clause A of section 2 is required to maintain the senior citizen, in this case the daughter-in-law. On the expiry of the son, the proceedings therefore could not have also been continued against the daughter-in-law who does not come under the definition of children under clause A of section 2 of the Act of 2007. In that view of the matter, looked at from all perspectives, in the present matter, the Assistant Commissioner has not rightly considered the applicable law. As such, this court passes the following order. Writ petitions allowed. The order dated 5/3/26 passed by the Assistant Commissioner's Senior Citizen Tribunal in MAG so and so is set aside.
Serial number 40, Nandish Patil.
Sorry, counsel for the petitioner seeks for and is granted 2 weeks' time, relist on 17th September. Okay.
41.
Petitioner in this case.
What did you discuss?
Lord, there's a personal emergency for my senior. Next date may be fixed, madam.
At the request of counsel for the petitioner in 41.1, relist on 24th. You are for
41.
whom?
Injay Kumar.
For Kumar.
Yes, madam.
For the petitioner in 41, relist on 24th. Let them address argument, then you can address your argument.
Can address.
This can address later.
Directly covered by the apex court to decision, Your Lordship.
You are the last entrant in the picture.
Yes.
Of course, you are the beneficiary, but last entrant.
And we have not been
At the instance of the response 5 and 6.
We have not been paid by a rupee, my lord, since 2003.
Yes, start. You can start.
Please, ma'am.
Okay, everybody is firing on your shoulder. At least on this side.
Please, ma'am. I do understand. Yesterday only when Your Lordship was pleased to question,
Yes.
I understood what's happening around me. And now, my lord, all that I can protect is the minor's interest. In taking advantage of the interior order passed in our favor.
In fact, in the earlier occasion, my learned senior counsel lord has appeared for a petition in this writ petition. Your Lordship may kindly see the.
Numbered and you torch our course.
Petitioner our appear agide. Irli adu yen tondre illa. I just want to bring it to Your Lordship notice. Petitioner writ petition Shivprakash Mirji was the brother of the former commissioner of police commissioner. My learned friend appeared, my lord.
No, respondent, not for the petition.
Respondent. Respondent illi petition anta I am saying. The respondent number 5 in that petition.
Any conflict of interest?
No, there is now that there is no conflict of interest.
With regard to rent, your lordship.
My lord may evaluate, and if there is any conflict of interest, I will certainly retire.
We don't want to
Not that.
evaluate. It's up to you.
As of now, but yesterday
We don't even any time. That's why we tell the lawyers also, if there is any matter where there is a conflict, you should bring it to our notice. One matter langi aitu, some appearance like we recused yesterday.
Yes.
There should not appear to be any even semblance of it is for you to decide.
Yesterday, when your lordship was pleased to pose me a question as to whether you are opposed to running at the petrol pump, I said no for this reason that rents are being deposited on behalf of the petrol pump by the BPCL into the court. Though I have not yet made an application to withdraw the rent, but my client is contemplating to make an application because she has not paid anything.
You are appearing
in 41.2.
25697.
25697 is the writ petition. I am the petitioner in that case.
25697. Or we'll come back after lunch and then take it up.
Yes, sir.
Then after we finish second list.
Please, please.
It won't end in 2 minutes.
Please.
Yes.
Humble submission. Serial number 46.
46.
This is with regards to a senior citizen, your lordship.
Huh.
Your lordship directed us to pay an additional sum in that particular case. I'm ready to pay and arrange the same as well. And the brother has also told that he's ready to take care of his mother and daughter. A short date may kindly be given. Next week, any date. I've told the other side as well.
46. Released on 27th in preliminary hearing.
Please.
Serial number 69, my lord.
42. 42, my lord.
42.
It's a simple mandamus matter.
In Kodi, 42.
Jafar is appearing. We require some instant.
My lord, I'll just, on the last date of hearing, paragraph number 3 of your lordship's judgment.
Taken up at
orders on
2:30, my
previous
lord.
date.
Or
2:30.
who is appearing in that?
Jafar is appearing in that matter.
Yes.
My lord, serial number
51. Have you informed the respondent? 51, Shri Karthikeyan BS has appeared for respondent number 1 and delete Pawan Kumar as that appearing for respondent number 1 to 4. At the request of counsel for the petitioner, released on 17th September. 27th August. 40? At the request of counsel for the petitioner, released on 14th September.
Appearing for petitioner, my lord. ಅದೇ ಪೆಟ್ರೋಲ್ ಪಂಪ್ ಅದು ಡಿಸ್ಟೆನ್ಸ್ ಅಷ್ಟೇ ಅದೊಂದನೇ ಅದು.
ಏನಕ್ಕೆ ಪಕ್ಕದಲ್ಲೇ ಇದ್ದೀರಾ?
ಇಲ್ಲ ಇಲ್ಲ.
ಕೈ ಹಾಕಿದ್ರೆ ನಾಲ ಸಿಗತ್ತೆ ನಿಮ್ಗೆ. ಏನ್ ಅದ್ರಲ್ಲಿ ಏನ್ ನೋಡಿ? ಏನು? Yes. We can't pass orders in mentioning stage, please. When it reaches, you can make your submission.
Lordship, seal number 43, regarding payment of COVID death compensation, Your Lordship. Your Lordship has granted 2 weeks time on 16th July. And till date, there is no response. We are given a representation also. Mr. Prashant appears.
You are mentioning the matter for what
Please.
purpose? Yes.
Request, my lord. The exact same set of facts and petitions brothers has been allowed.
Yes.
The respondent counsel has also here.
ಮಧ್ಯಾಹ್ನ ಲಿಸ್ಟು ಆಮೇಲೆ ಪಾಸ್ಟ್ ಓವರ್ಸ್ ಕಂಟಿನ್ಯೂ ಇಲ್ಲ ಕೊಟ್ರ 74 ಇದೆ 74 ಇದೆ ಹೌದು ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಫಸ್ಟ್, ಆಮೇಲೆ ಪಾಸ್ ಓವರ್ಸ್ ಕಂಟಿನ್ಯೂ. ಪಾಸ್ ಓವರ್ಗೆ ಹಾಕೊಳ್ಳೋಣ.
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಫಸ್ಟ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್, ಆಮೇಲೆ ಪಾಸ್ ಓವರ್ಸ್, ಆಮೇಲೆ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮ್ಯಾಮ್.
ಒಂದೇ ಒಂದ್ ನಿಮಿಷ ಹೇಳ್ತೀನಿ ಮೇಡಮ್. 66 ಇದೆ ಸರ್, ಇದೆ. ಫಾಸ್ಟ್ ಓವರ್ಸ್ 2 3 7 12 ಇಲ್ಲ ಅಂದ್ರೆ ಅದು ಆ ಲಿಸ್ಟ್ 12ರಲ್ಲಿ 11 ಬಿಡಿ. ಮೇಡಮ್ ವಿಸಿಲ್ ಹೇಳಿ.
ಮ್ಯಾಮ್ ಪಾಸ್ ಓವರ್ ಮ್ಯಾಟರ್ 7 ಇದೆಯಾ ಮ್ಯಾಮ್?
ಫಸ್ಟ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್, ಆಮೇಲೆ ಪಾಸ್ಟ್ ಓವರ್ಸ್.
ಪಾಸ್ಟ್ ಓವರ್ ಎಷ್ಟಿದೆ ಮ್ಯಾಮ್ ಮ್ಯಾಟರ್ಸ್?
7 ಮ್ಯಾಟರ್ಸ್ ಇದೆ.
ಓಕೆ ಮ್ಯಾಮ್, ಥ್ಯಾಂಕ್ ಯು.
ಇದ್ರೆ
ಅಂದ್ರೆ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಆದ್ಮೇಲೆ
ಡೇಟ್ಸ್ ಎಲ್ಲ ನಿನ್ನೆ 11th ಅಲ್ವಾ? 15 ಸೆಪ್ಟೆಂಬರ್. ಇದು ಈ ಡೇಟ್ ಫಸ್ಟ್ ಇದೆಯಲ್ಲ, ಅದು ನಾವು ಅಪ್ಡೇಟ್ ಮಾಡ್ತೀವಿ. ಇಲ್ಲಿ ಸರ್ ಏನ್ ಹೇಳ್ತಾರೆ ಅದು ಕೇಳ್ಕೊಂಡು. ಇದು ಯಾವ ಡೇಟ್ ಬಂದಿತ್ತದು? ನಿಮ್ದು ಅಷ್ಟೇ, ಹಂಗೆ ಜೊತೆಲಿ ನೋಡ್ತೀನಿ. 17 ಸೀರಿಯಲ್ ನಂಬರ್ ಏನಾದ್ರು ಇಟ್ಟಿದ್ಯಾ? ಆರ್ಡ್ರಲ್ಲಿ ಇಲ್ಲ, ನೋಡಿದೆ ನಾನು. ಓವರಾಲ್ ಸಬ್ಮಿಷನ್ ಅದು ಆರ್ಡ್ರಲ್ಲಿ ರಿಫ್ಲೆಕ್ಟ್ ಆಗಿದ್ರೆ ಮಾತ್ರ ಏನಾಗುತ್ತೆ, ಪುಟಪ್ ಮಾಡ್ತಾರೆ. ಓವರಾಲ್ ಆಗಿ ಕೊಟ್ರೆ ಹೆಂಗಪ್ಪ ಬರುತ್ತೆ? ಇವತ್ತೆಲ್ಲ ರೀಚ್ ಆಗ್ತದೆ. ತಗೊಳ್ಳೋದವರು ನೀವು ಸಬ್ಮಿಷನ್ ಮಾಡಿ. ಅದೇ ನನಗ್ ಈಗ ನನ್ ಕೆಲ್ಸ ಏನ್ ಗೊತ್ತಾ, ಸೀರಿಯಲ್ ಕರಿಯಕ್ ಹೇಳಿದಾರೆ, ಕರಿತಾ ಇದೀನಿ. ಅದು ಬಿಟ್ಟು ಬೇಕು ಅಂದ್ರೆ ನೀವು ಸಬ್ಮಿಷನ್ ಮಾಡ್ಬೇಕಷ್ಟೇ. ಮಾಡಿದ್ರಿ ಮಾಡಿದ್ರುನು ಏನ್ ಹೇಳಿದ್ರಿ ಹೇಳಿ? ಏನು ಹೇಳಲಿಲ್ಲ. ತಗೊಳ್ಳೋಣ ಅಂತ ಹೇಳಿದ್ರ ಇಲ್ಲ. ಕಮ್ ಅಂದ್ರೆ ಬರ್ಬೇಕಲ್ವಾ? ಇವತ್ತು ಬಂದ್ಬಿಟ್ಟಿದ್ಯಲ್ಲ ಆಲ್ರೆಡಿ. ನೆಕ್ಸ್ಟ್ ಡೇಟ್ಗೆ ನೀವು ನೆನಪು ಮಾಡಿ, ನನಗೆ ರೀಚ್ ಆಗ್ಲಿಲ್ಲ ಅಂತ ಮಾಡಿ. ನಿಮ್ಮೊಂದು ಮಧ್ಯಾಹ್ನ ಬಂದ ಮೇಲೆ ತಗೋತಾರಪ್ಪ. ಪಾಸ್ಟ್ ಓವರ್ಸ್ ಇದೆ ಸರ್, 7 ಮ್ಯಾಟರ್ ಇದೆ. 8 25 ಹಂಗೆ ಹೇಳಿದ್. ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಅಂತಾನೆ ಹೇಳೋದು. ಈ ಸ್ಟೆನೋಗ್ರಾಫರು ಚೇಂಬರ್ ಅಲ್ಲಿ ಇರ್ತಾರೆ, LN ಅಂತ. ಚೇಂಬರ್ ಅಲ್ಲಿ, ಸಾಹೇಬ್ರ ಚೇಂಬರ್ ಅಲ್ಲಿ LN ಅಂತ ಇರ್ತಾರೆ. ಅವ್ರು ಮಾಡಿರೋದು ಇದು. ಅಲ್ಲಿ ಕೇಳಿ ಅವ್ರು ಕರೆಕ್ಟ್ ಮಾಡಕ್ ಹೇಳಿ, ವೈದ್ಯರು ಮಾಡಕ್ ಹೇಳಿ. ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಬೇರೆ, ಅದು ಬರ್ಲೇಬೇಕು. ಫಸ್ಟ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್, ಆಮೇಲೆ ಪಾಸ್ಟ್ ಓವರ್ಸ್, ಆಮೇಲೆ ಕಂಟಿನ್ಯೂ. ನಿಮ್ದು ಹೇಳಿ ಸರಿ. ಓರಲ್ ಆರ್ಡರ್ ಎಲ್ಲ ಹೆಂಗಾಗುತ್ತೆ? 10th ಸೀರಿಯಲ್ ನಂಬರ್ ಏನು? ಅಲ್ಲ ಸೀರಿಯಲ್ ನಂಬರ್ ಫಸ್ಟ್ ಲಿಸ್ಟ್ 27. ಇಲ್ಲ ಈಗ ಏನ್ ಗೊತ್ತಾ, ಇಲ್ಲ ಆಗೋದನ್ನ ಹೇಳ್ತಿದ್ದಲ್ಲ. ಇವಾಗ ಆರ್ಡರ್ ಆಗಿದ ತಕ್ಷಣ ಒಂದು ಡೇಟ್ ಕೊಡ್ತಾರೆ. ಆ ಡೇಟ್ ಮಾತ್ರ ನಾವ್ ಎಂಟ್ರಿ ಮಾಡೋದು. ಮಿಕ್ಕಿದ್ದೆಲ್ಲ ಯಾರು ಡಿಕ್ಟೇಷನ್ ತಗೊಂತಾರೆ ಅವರೇ ಮಾಡೋದು. ಅವ್ರು ಯಾವಾಗ ಮಾಡೋದು? ಜಡ್ಜ್ ಹತ್ರ ಸೈನ್ ಆದ್ಮೇಲೆ ಮಾಡ್ತಾರೆ. ನೆಕ್ಸ್ಟ್ ಡೇಟ್ is 16/9 ಅಲ್ವಾ? ಅಷ್ಟ್ರಲ್ಲಾಗುತ್ತೆ. ಅಲ್ಲ ಇರ್ಲಿ, ನೀವ್ ಮಾಡ್ರಿ, ಏನಿದೆ ಅದು ಅಪ್ಲೋಡ್ ಆಗ್ಬೇಕು ಅಂದ್ರೆ ಸಾಹೇಬ್ರು ಸೈನ್ ಹಾಕ್ಬೇಕು. ಅಲ್ಲವರೆಗೂ ಆಗಲ್ಲ, ಮೇ ಬಿ ಸೈನ್ ಆಗಿರಲ್ಲ. ಸ್ಟೇಟಸ್ಗೆ ಬರೀ ಡೇಟ್ ಅಷ್ಟೇ ಬರುತ್ತೆ ಸರ್. ಹೋಲ್ ಆರ್ಡರ್ ಅವತ್ತೇನ್ ಡಿಕ್ಟೇಟ್ ಆಯ್ತು ಅದು ಬರಲ್ಲ. ಅದು ಬಂದಿದ್ಯಾ ಅಂದ್ರೆ ಆರ್ಡರ್ ತಪ್ಪಾಗಿದೆ ಅಂತ ಹೇಳ್ತಿದ್ದೀರಾ ನೀವು? ಅಲ್ಲ, ಅವ್ರಿಗೇನ್ ಡಿಕ್ಟೇಟ್ ಆಯ್ತು ಅದ್ ಮಾಡಿರ್ತಾರೆ ಅಲ್ವಾ? ಅವ್ರು ಡಿಕ್ಟೇಷನ್ ಏನೋ ತಗೊಂಡಿರ್ತಾರಲ್ವಾ ಅವತ್ತು, ಅದನ್ನ ಮಾಡಿರ್ತಾರೆ ಅವರು. ಈಗ ನಿಮ್ಗೇನೋ ಆಗ್ಲಿಲ್ಲ ಅಂತ ಹೇಳೋದನ್ನ ಅವ್ರಿಗೆ ಡಿಕ್ಟೇಷನ್ ಆಯ್ತೋ ಇಲ್ವೋ ಗೊತ್ತಿಲ್ವಲ್ಲ, ಮತ್ ಇನ್ನೇನ್ ಬೇಕು ನಿಮ್ಗೆ? PDF ಕ್ಲಿಕ್ ಮಾಡಿ ಅದ್ರ ಮೇಲೆ. ನಾನ್ ನೋಡ್ತೀನಿ ನಂಬರ್ 384 ಒಂದ್ ನಿಮಿಷ ಇಲ್ಲಿ ಮಾಡೇ ಬಿಡ್ತೀನಿ ರೀ. ಯಾಕೆ ಬರಲ್ಲ ನೋಡೋಣ, ವೆಬ್ಸೈಟ್ ಹೋಗಿ. $384 of 24. 2, 2, 3, 4, 6. ಅವರು ಅದನ್ನ PDF ಫಾರ್ಮ್ಯಾಟ್ಗೆ ಮಾಡಿಲ್ಲ, ಡೈರೆಕ್ಟ್ ಆರ್ಡರ್ ಅಪ್ಲೋಡ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಅದಕ್ಕೆ PDF ಫಾರ್ಮ್ಯಾಟ್ ಅಲ್ಲಿ ಮಾಡಿಲ್ಲ. ಡೌನ್ಲೋಡ್ ಏನ್ ಬೇಡ, ಹಂಗೆ ಪ್ರಿಂಟ್ ತಗೊಳ್ಳಿ, Ctrl+P ಕೊಟ್ರೆ ಬಂದ್ಬಿಡುತ್ತೆ. ನಿಮ್ಗೆ ಏನ್ ಬೇಕೋ, ಇಲ್ಲ ಅಂತಂದ್ರೆ ಏನಾಗುತ್ತೆ ಗೊತ್ತ, ಇಲ್ಲಿಂದ ಬಂದ್ಬಿಡುತ್ತೆ ಕೇಸ್ ನಂಬರ್, ಇಲ್ಲಿಂದ ಹಿಂಗ್ 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 ಬಂದ್ಬಿಡುತ್ತೆ ಫುಲ್ಲು. ಇಲ್ಲ ಅಂದ್ರೆ ಕಾಪಿ ಪೇಸ್ಟ್ ಮಾಡ್ಕೊಂಡು ಮಾಡ್ಕೋಬೇಕು. ಅದು ನಡೆಯುತ್ತೆ. ಹೌದು ಹೌದು, ಇಲ್ಲೆಲ್ಲ ಇರುತ್ತೆ ನೋಡಿ, ಇದು ಸಮೇತ ತಗೊಳ್ಳಿ. ಅವಾಗ ಸಾಕಷ್ಟೇ ಸಾಕು. ಇಲ್ಲ, ಮಧ್ಯಾಹ್ನ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಫಸ್ಟ್, ಆಮೇಲೆ ಪಾಸ್ಟ್ ಕಟ್ಟಿ. ವೈಟ್ ಆರ್ ಗ್ರೀನ್? That's
ಅದಕ್ಕೆ ನಾವು ಸುಮ್ಮನೆ ಇದಾದ ಬೇಡ ನಾವು ಸುಮ್ಮನೆ. ಓಕೆ ಗುರು ಆಯ್ತು. ಸರಿ ಸರಿ.
Shivram ji.
ಇಲ್ಲ ಸರ್. ಏನ್ ಗೊತ್ತಾ ಸರ್, ಫಸ್ಟ್ ಈಗ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಫಸ್ಟ್, ಆಮೇಲೆ ಪಾಸ್ಟ್ ಅವರ್ಸ್, ಆಮೇಲೆ ಕಂಟಿನ್ಯೂ ಆಗ್ಬೋದು. ಇವತ್ತು ಕಮ್ಮಿ ಇದೆ, ಆಗುತ್ತೆ. 14th ನೆಕ್ಸ್ಟ್ ಮಂಡೇ ಅಂದ್ರೆ 24. ಅಲ್ಲಿ ಬ್ರಾಂಚ್ ಅಲ್ಲಿ ತಗೊಂಡೋಗಿ ಕೊಟ್ಬಿಡಿ, ಪೆಂಡಿಂಗ್ ಬ್ರಾಂಚ್ ಅಲ್ಲೇ ಕೊಟ್ಬಿಡಿ, ಎಲ್ಲಿದೆ ಫೈಲ್ ಅಲ್ಲಿ ಕೊಟ್ಬಿಡಿ.
ನಂಬರ್ ಬರ್ಕೊಳ್ಳಿ. ಇದು ಸ್ಕ್ಯಾನಿಂಗ್ ಕಳಿಸಿದ್ದಾರೆ, ಆರ್ಡರ್ ಶೀಟ್ ಮಾತ್ರ. ಸ್ಕ್ಯಾನಿಂಗ್ ಅವ್ರು ಏನು ಮಾಡಿದ್ದಾರೆ, ಆರ್ಡರ್ ಶೀಟ್ ಕಳಿಸಿದ್ದಾರೆ, ಆರ್ಡರ್ ಫುಲ್ ಸೆಟ್, ಆರ್ಡರ್ ಶೀಟ್ ಕಳಿಸಿಲ್ಲ, ಮಿಸ್ ಆಗ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಸೊ ಡೇಟ್
ಅಪ್ಲೋಡ್ ಆಗಿರೋದು ಏನಾದ್ರು
ಅಪ್ಲೋಡ್ ಮಾಡಿಲ್ಲ, ಸ್ಕ್ಯಾನ್ ಮಾಡಿಲ್ಲ, ಸ್ಕ್ಯಾನ್ ಮಾಡಿದ್ರೆ ಆಗ್ಬಿಟ್ಟಿರೋದು. ಅದಕ್ಕೆ ಅವರು
ಅಲ್ಲ, ಆ ಸ್ಕ್ಯಾನ್ ಅಲ್ಲ, ಸ್ಟೆನೋಗ್ರಾಫರ್ಸ್ ಅಪ್ಲೋಡ್ ಮಾಡಿ.
ಸ್ಟೆನೋಗ್ರಾಫರ್ ಅಪ್ಲೋಡ್ ಮಾಡಿದ್ದಾರೆ, ಮಾಡಿಲ್ಲ. ಅದಕ್ಕೆ ಇದೊಂದು ಸ್ವಲ್ಪ ನಂಬರ್
ಯಾರ ಹತ್ರ ತೆಗಿಸ್ತೀರಿ?
ಇದು
ಯಾರು ಸ್ಟೆನೋ
ಯಾವತ್ತು ಬಂದಿತ್ತು ಡೇಟ್ ಹೇಳಿ ಅದು.
ಡೇಟ್ 11/8
11/8 ಎರಡು ದಿನಾನು ಬಂದಿತ್ತಾ? ರಿಪೀಟ್ ಆಯ್ತಾ? ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇತ್ತಲ್ಲೇನಪ್ಪ? ಎಜುಕೇಶನ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲೇ ಇರುತ್ತೆ. 11th ಸೀರಿಯಲ್ ನಂಬರ್ ಇಲ್ಲ, ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಮಾಡ್ಬಿಡಿ. ಸೀರಿಯಲ್ ನಮ್ಮ ಲಿಸ್ಟ್ ಏನ್ ಗೊತ್ತಾ, ಗ್ರಂಥ ತರ ಇರುತ್ತೆ. ಎಜುಕೇಶನ್ ಇದು ನಾವೇ ಬರ್ದಿದೀವಿ. 12ಗೆ 11th ಬರ್ದಾಗ 12ಗೆ ನಾವೇ ಬರ್ದಿದೀವಿ. ಅದು ಎಂಡರ್ಸ್ಮೆಂಟ್ ನಾವೇ ಮಾಡಿದೀವಿ. ಆಯ್ತಾ? ನೆಕ್ಸ್ಟ್ 12ಗೆ ಬಂದಾಗ ಏನಾಯ್ತು? ಅಲ್ಲ, ನಾವೇ ಬರ್ದಿರೋದು. 12ಗೆ ಬಂದಾಗ ಏನಾಯ್ತು? ಅದು ನಾವೇ ಬರ್ದಿದೀವಿ. ಇಲ್ಲ, ಅದಕ್ಕೂ ಪ್ರೀವಿಯಸ್ ಆರ್ಡರ್ ನಾನು ಕೋಟ್ ಮಾಡ್ತೀನಿ. ಕೋರ್ಟ್ ಆರ್ಡರ್ ಯಾವ್ದು ಇರುತ್ತೆ ಅದಕ್ಕೆ ಹಿಂದೆ ತಿರ್ಸಿರ್ತೀನಿ. ಆರ್ಡರ್ ಶೀಟ್ ಬರಿತಾ ಬರಿತಾ ಮುಂದಕ್ಕೆ ಹೋಗಿರ್ತೀವಿ. ಹೆಚ್ಚು ಕೊಡುವಾಗ ಏನ್ ಮಾಡ್ತೀವಿ, ಹಿಂದಕ್ಕೆ ತಿರ್ಸಿರ್ತೀವಿ ಅಷ್ಟೇ. ಇನ್ನೇನಿಲ್ಲ ನೋಡಪ್ಪ, ಹಿಂಗೆ ನೋಡಿ, ಹಿಂಗಿರುತ್ತಾ? ಹೆಚ್ಚು ಕೊಡುವಾಗ ಏನ್ ಮಾಡ್ತೀನಿ, ಈ ಪೇಜಿಗೆ ತಿರ್ಗಿಸ್ತೀನಿ. ಇವತ್ತು ಅಡ್ಜನ್ ಆಯ್ತು ಅಂತ ಅನ್ಕೊಳ್ಳಿ ಸಪೋಸ್. ಆದ್ರೆ ನಾನು ಏನ್ ಮಾಡ್ತೀನಿ, ಇದು ತಿರ್ಗಿಸ್ಬಿಟ್ಟು ಈಗ ಬರಿಬೇಕಲ್ವಾ, ತಿರ್ಸಕ್ ಹೋಗಲ್ಲ, ಹಿಂಗೆ ಬರ್ದು ಹಿಂಗೆ ಇಟ್ಟು ನಿಮ್ಗೆ ಈ ಶೀಟ್ ಕಾಣಿಸಿರುತ್ತೆ.
ನೀವು ಈ ಶೀಟ್ ಕಳ್ಸಿದೀರಾ, ಅದಂಗೆ ಇದೆ, ಅದೇನು ಪ್ರಾಬ್ಲಮ್ ಇಲ್ಲ. ಮೇಡಮ್ ಹತ್ರ ಬಂದ್ಬಿಟ್ಟು ಆಗುತ್ತೆ.
ನಾನೇ ಬರ್ದಿರೋದು. 2 ದಿನದ
2 ದಿನ ಅದಕ್ಕೆ ಕಂಪ್ಯೂಟರ್ಸ್ ಎಲ್ಲ ಹೋಗಾಯ್ತು.
ಬರ್ಕೊಡ್ತೀನಿ. ಹೇಳಿ. ಫಸ್ಟ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಸರ್, ಆಮೇಲೆ ಪಾಸ್ಟ್ ಓವರ್ಸ್, ಆಮೇಲೆ ಕಂಟಿನ್ಯೂ. ಫಸ್ಟ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್, ಪಾಸ್ಟ್ ಓವರ್ಸ್, ಆಮೇಲೆ ಕಂಟಿನ್ಯೂ.
ಮೇಡಮ್ ಅವರೇ, ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಫಸ್ಟ್ ಲಿಸ್ಟ್
ಆಮೇಲೆ first.
It's one mention. It's serial number 5 in list 2, my lords. There's some inconvenience for ASG today, my lords.
Serial number 5 in list 2, 5. Yes.
25th will take.
At the request of council for respond number 1, relist on 5th, the 25th.
25th.
April, my lords.
2:30. Taken up at
2:30, it will continue in the same list, 2:30.
230 matters. List number 2, serial number 1. Shrikara PK, connected matters.
ಅಫಿಡವಿಟ್ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದೆ, ನಾನು ಟ್ರಾವೆಲಿಂಗ್ ಅಲ್ಲಿ ಇದ್ದೆ, ಅದಕ್ಕೆ ಮೈರಾಕಾಗಿಲ್ಲ, ಪರವಾಗಿಲ್ಲ ಅಂತ ಕೊಟ್ಟಿದ್ದೀನಿ ಅದಕ್ಕೆ.
ಆಯ್ತಾ ಏನ್?
ಅದೇ ಐ ಹ್ಯಾವ್ ಆಸ್ಕ್ ಫಾರ್ 2 years time, ಮೇಕ್ ಪೇಮೆಂಟ್, ಐ ಲಿವ್ ಇಟ್ ಟು ದ ಕೋರ್ಟ್, ದಸ್ ಇಟ್ಸ್ ಸಬ್ಸ್ಟೆನ್ಷಿಯಲ್ ಅಮೌಂಟ್.
They are acceptable for 5 years, we have nothing to say.
ಅಲ್ಲ, ಐ ಅಗ್ರಿ. ಅಲ್ಲ, ನನ್ಗೂ ಇವನ್ ಐ ಆಮ್ ಹೆಸಿಟೆಂಟ್ ಪರ್ಸನಲಿ ಟು ಆಸ್ಕ್, ಬಟ್ ಫಾರ್ ದೆಮ್ ದೇ ವರ್ ಎಕ್ಸ್ಪ್ಲೈನಿಂಗ್ ಈಚ್ ಆಫ್ ದೆಮ್ ವಿಲ್ ಹ್ಯಾವ್ ಟು ಅಟ್ ಲೀಸ್ಟ್ ಪರ್ ಮಂತ್ ಅಂದ್ರೆ ಔಟ್ಗೂ ಅರೌಂಡ್ 38 to 40, ಒಬ್ರಿಗೆ 70 ವರ್ಗ ಆಗುತ್ತೆ ಅಡ್ಜಸ್ಟ್ ಮಾಡಕ್ ಅವರು. ಅದಕ್ಕೋಸ್ಕರ ದೇ ಹ್ಯಾವ್ ರಿಕ್ವೆಸ್ಟೆಡ್.
What is the
6 matters I have filed affidavit.
in joint?
6 matters separate affidavit. ಒಬ್ರು ಹಾಕಕ್ ಆಗಿಲ್ಲ, ಅದೇಂದ್ರೆ ಸ್ವಲ್ಪ ಏಜ್ ಜಾಸ್ತಿ ಆಗಿದೆ.
Joint andre both of you have affidavit of the petitioner.
He has just served the copy to me, which indicates that he requires 2 years time to pay this. Point 1 is they have not paid the money since 1975, almost about 2 decades in the court. Adrinda
1975.
2 decades, 20 years in
2
the
decades. That's
2008, 2009.
Speaker ಹುಟ್ಟೆ ಇಲ್ಲ ಅಂತ.
ಅದೇ ನಾನು ಇರ್ಲಿಲ್ಲ, ನನಗೆ ನೀವು
2008, 2009 in the 20 years in the.
Yes.
I leave it to my lords. I feel reasonable time would be about 3 to 4 months. Because they have withheld the payment a long time. And ಈಗ ಬಿಟ್ರೆ
ಅಲ್ಲ, they have
4
withheld
times
ಅಲ್ಲ.
the amount of money that they will have to pay is the existing rate ಗೆ 4 times ಆಗುತ್ತೆ.
This amount calculation is acceptable.
Last time I learned it because there was a mistake from our part in the previous hearing. We corrected it and they are agreeable to this because it's a calculation.
So amount is now.
Amount is determined. Only thing is
time. What is
The
determined?
thumb
By elimination first, what is agreed again?
Allah, he is asking for
One
2 years.
submission. No.
I feel in any which way we look at it. Otherwise it's too long, having regard to the long standing possession of the property by them and not paying anything. Literally they are paying about 500 rupees or so.
In what are they doing in this property?
Various kinds
ಎಲ್ಲ
of
ಸಣ್ಣ ಸಣ್ಣ ಅಂಗಡಿಗಳು, ಪೆಟ್ಟಿಗೆ ಅಂಗಡಿಗಳು,
10 by
ಅವರೇ
8,
ಕನ್ಸ್ಟ್ರಕ್ಟ್
10 by 10.
ಇನ್ಫ್ಯಾಕ್ಟ್ ದೇರ್ ಇಸ್ ಅ ರೆಸಲ್ಯೂಷನ್ ಆಫ್ Hassan Municipal Council, I'll produce it, where they say we have permitted them, they can be there till we construct a new building anta. They were at another place. That place was for expansion of road.
And be there for new building, you have to apply tender.
I agree. ಇನ್ನು ಅವರು ಎಲ್ಲ ಏನು ಮಾಡಿಲ್ಲ ಅವರು, ಅದಲ್ಲ. ಆದ್ರೆ ಹಿಯರ್
My lord's judgment.
there is a resolution.
ಒಬ್ರು ಪೊಲಿಟಿಷಿಯನ್ ಬರ್ತಾರೆ, he will give one, ಅದೆಲ್ಲ ಆಗದಿರೋದು. My lords have already decided.
You have to go by that.
I agree. I am not on that. I am saying ಮೊದಲನೇ ವಿಷಯ, ರೆಂಟ್ ನಾಟ್ ಪೇಯ್ಡ್ ಅಂದ್ರೆ ಫ್ರಮ್ ಲಾಸ್ಟ್ 15-16 years rent is not determined at all. I am saying ಅದಕ್ಕೋಸ್ಕರ.
So now this money will be paid in how long a time?
I have said in each case they will pay within 2 years.
So you're doubting your stay with the 2 years.
ಇಲ್ಲ, that I as of right I cannot say that. How can I say that? Well, I don't mince words like that. I don't want
1 year.
ಈ ತರ ಮಾಡ್ಬೋದೇನೋ ಅಂತ ಅಷ್ಟೇ. Requested suggestions to my learned friend. 6 to 7 months ಮಾಡಿ 2 to 3 installments ಅಲ್ಲಿ ಕೊಡ.
What we are thinking of is we'll extend the time to 1 year. Payment to be made within 7 to 8 months before the term expires.
ಅಲ್ಲ, ಏನಂದ್ರೆ ಇನ್ನೊಂದು, my lords may have to determine the correctness or otherwise of the orders that are impugned, because any which way they are squatting on the properties, it's about more than 2 decades. That will also because thumb judgment or circular prakara, if we have to sort it out, they'll have to go for right of first refusal ಎಲ್ಲ ಮಾಡೋದಾದ್ರೆ ಆ ಜಾಗದಲ್ಲಿ we need to develop the property. It's all in a shambles. So ಅದಕ್ಕೊಂದು determination ಆಗ್ಬೋದು, maybe later.
If You are agreeable in principle or as an order of the court. First, if you are agreeable, we'll make it an order of the court.
I just leave to my lords.
It can't be without any basis also. If now 2 years ಕೇಳ್ತಾ ಇದ್ದಾರೆ, ನೀವು 4 months ಅಂತ ಇದ್ದೀರಾ, if 1 year, if they stay there, but the payment to be made in 8 months or 6 months, if they don't pay within that time, then it will end at that time.
And I should not be relegated to again another process of.
They will have to vacate, undertaking will be recorded.
Cannot do that, it's contempt and undertake here.
It will be an order of this court and that would have to be complied with.
One second. All clients here so that I did not want again to see.
ಕೇಳ್ಬಿಡ್ತೀನಿ. Pass over.
ಏನಕ್ಕೆ? ಆಯ್ತು.
Serial number 2 adjourned. Serial number 3. PN Harish.
Pass over.
Serial number 4. Imran Pasha.
Petitioner. He had submitted the report. KDB was directed to give time limit, how long they will.
When the encroachment would be
Yes,
removed.
my lords. Yes.
Where is Pradeep? ಪ್ರದೀಪ್ಗೆ ಸ್ವಲ್ಪ ಕಷ್ಟ ಆಗಿರೋ ಕೇಸೇ ಕೊಡ್ತಾರೆ.
4th or 0.
Paso.
Serial number 5 adjourned. Serial number 6. Yes, Rajshekar.
You got the files?
Yes.
When was the transfer made? What date was it?
This is communication dated 3/1/2024.
3/1/24.
Earlier, my lords, it is 5/9/2023.
How is this file organized, Mr. The documents are not in sequence. 23 ಬರುತ್ತೆ, 24, 25, 26, everything is jumbled up.
Just mark. But in fact, they have even complained against us. But there's one communication from the IOC. The oil, it says the complete prerogative of the consumer to choose his distributor. Now, in this case, my lord, the other contesting respondent, my lord, has gone and given a complaint against the department with the Lokayukta. Lokayukta has issued an order saying that why you are not giving it to the territorial who is nearest to the Anganwadi and the other existing person. And they are issuing notices to us and telling why you are not implementing the order of the Lokayukta. I'll place it before.
Lokayukta has also passed orders.
Order. Lokayukta has
My lord,
directing us
my lord.
to give the nearest distributor.
My lord, but there is a circular as per the administrative decision and the policy decision. He is a petitioner. Petitioner is an distributor of HPCL. Let in the unified guidelines which he has mentioned over his writ petition, it itself mentions his boundary limits and his jurisdiction. And his own agreement, I would like to present my agreement. And
we are not concerned about both of you. We have told you.
My lord, once, just once. My lord, the request to.
You are business people. You will make your business wherever you want to.
My lord, there is.
We are concerned with the customer. The location has to be as close to the customer as possible,
Yes,
whoever
ma'am.
is the dealer. That is why we want to examine that application of mine. So we told you yesterday also, we are going to look at that. So please don't make your submission until we look at that.
Sure.
Sorry. What is the application of mind as regard the choice made as regard which distributor?
Kindly have a look at it. Letter issued by the HPCL to the department. There they have clearly said
It is not reason for including alcohol. Including ಎಲ್ಲಿದೆ ಅಂತ ನಾನು ಇದರಲ್ಲಿ ಕೊಡು.
We are concerned with the order which has been passed, transferring the connections, customers to each of these persons, each of the distributors. Where is the application of mind as regards that? What is the process that has been followed by your authorities? That is, those are the, it is all jumbled up. That is why we need to look at those.
My lord, just one small thing. My lord, there is a circular of the Joint Director Midday Meal Scheme. Based on that circular, my father had represented the CDPO with those circulars and the map and the distance chart. My lord, it mentions with reference to the subject mentioned above, 2016 to 17 educational year classes are going to be started from 27th May. With regards to this, it is suggested that all the schools and the nearby gas cylinders from the nearest agency to decrease the transportation charges to do e-mapping for getting connection. And this was decided in the meeting presided by the Honorable Government Chief Secretary, Food and Civil Supplies Department. In this background, as per notified in the above referred meeting, notified to the head teachers of all schools to get the gas connection from the nearest gas agencies and the district. The expenses incurred in this regard should be borne by as per the rules in district and taluk and school level. In the year 2018, my lord, my father
He
made.
just told you we are looking at it and don't make any submission until we look at it. You don't seem to understand every time. Because you are a party in person, we are not saying anything.
Sorry, my lord.
You don't know the decorum of the court. You think you are in your office. But whenever you want, you will get up and talk. Please take your seat.
Sure.
Please take your seat. What is the application of mind? You have to do one thing. From the time that the proposal was mooted, what is the process that happened? We are concerned with the decision-making process. We are not concerned with the decision. If the decision-making process is concerned, it has taken into consideration all the aspects. And we are also concerned only with the consumers, not with these two.
Yes, please.
And not with you also. Your role was to safeguard the consumer, so that they get the gas connection as early as possible, on time, with as less the cost as possible. If you are going to make it 50 kilometers away, sorry.
Cost part, I think, is a fixed cost because it is fixed by the IOC. There is no
Cost is fixed.
Cost to delivery has to be free. There is no cost for delivery.
To the customer, it should not be.
No.
Timely delivery has to happen.
May I submit this, my lords. The process what they have followed is, so the contesting respondent goes and files a complaint, my lords. He makes a representation to the authority. I'll not on that, my lords. Give me only 1 minute time, my lords. He makes a representation. Then, my lords, he goes and files a complaint before the Lokayukta. And Lokayukta was visited, my lords, the district. He orally instructs, my lords, to transfer the gas connections. In spite of consumers addressing a letter to the authorities, we are happy and we are comfortable with the present distributor. They have ordered to transfer. This is all the process adopted by.
Let us look at the process, not what you are saying. What they have followed is what is looking at. Paso.
Serial number 7. Badrinath.
What is this matter, Naveen?
This is pertains to solid waste management system. They have challenged the authority to levy cess. My objections is on record, my lords.
Special order. Good. Ready?
Seek for a short accommodation, my lords.
Readings are complete?
My pleadings, sir.
I'm for the next point. I need a short date to file my order.
7.2 you are appearing.
I appear in 7.1, my lords.
Why 3 different councils for the corporation? So, who is going to be leading the matter? One of you will address, not all 3.
Definitely.
So you decide among yourself. 7.1
any
IA 1 or
disagreement in
25 is allowed. You have filed, in 7.1 objections have been filed?
Has to be filed. 7.1, I need
Your-
to sheet it short. Got it.
Counsel for respond number 2 in 7.1. Yeah, BBMP, na ido.
For Karthikeyan, for Karthikeyan.
Counsel for the corporation in 7.1 and 7.2 seek fund are granted.
Weeks, 3 days or 1 week? 1 week's time.
A week's time to file the respective statement of objection. Objections, if any, to be filed on or before 28th August. Solid waste cess.
My lords.
You are challenging the virus.
Virus, they have only challenged the circular, my lords. We are able to point out that as under the earlier BBMP Act and also the GBA Act
Is
governance.
virus of the act challenged?
No, my
No.
lords.
Only the
Only the
demand which
circular
been-
is challenged.
So then no. AGA did not need to, you have to justify. All the councils are directed to file their respective synopsis of dates and event list of authorities along with authorities as a synopsis of arguments on or before 4th September 2026 after exchanging the same 4th Rajana, 7th September after exchanging the same with the other councils. Relist on 14th September.
Grateful minutes.
Serial number 8. Chaitanya SC.
Regards to lead writer. Yes. Yes, Jafar.
My lord,
Lead writer.
the draft of the objections has been placed before the IGR, before the Inspector General of Stamps.
Draft of the
Statement of objection, my lord. In this, my lord, we have to file objection, my lord. If I may explain the process, what my lord felt. Their role, my lord, their role. I have discussed this matter. Orally, I will submit for the benefit of this court. My lord, they are the.
You are ready to argue the matter, then you argue.
No, my lord, I have to file objection, my lord.
Then when are you going to file? Last time also you sought
No, my
time
lord,
twice.
what had happened is they have prepared the objections and they have placed it before the Inspector General of Stamps for approval because it's a computerized new thing. It is a paperless registration. It's a pilot
You
basis.
file it by Monday, get ready for argument on Monday.
Monday may not be possible because of the holiday.
Tuesday.
My lord. Tuesday.
Lord AG submit that the objection have been placed before the IGR for approval and would be filed by Tuesday,
My
the
lord.
25th. It's made clear that no further adjournment would be granted. Relist on 25th at 2:30 p.m.
My lord, 25th may not be possible for appearance, my lord. My lord, on 27th or 28th, my lord.
27th. They'll be happy.
Please, my lord.
Blessing in this.
He is happy. He gets 2 more days. 27th. Great.
Please, my lord.
Serial number 9.
For the petitioner in this matter,
Yes.
my lord, this is the bank had indicated they want to file objections in this matter.
Ganesh. Online.
They wanted to file objections, my lords.
They filed their objections?
They have not yet filed, my lords, but they indicated last
My
occasion they
lord,
had.
I need some weeks.
This is also a special order matter.
My lord, the coordinate, this was listed before the coordinate bench. My lordships had been recused from the matter and thereafter it has come before your lords, my lords.
Special orders we have to finish fast. Can I disconnect again?
9th also. 9th. 10th.
Madam, allow ಮಾಡಬೇಕು.
Yes, Vignesh.
My lord, I need a week's time in this matter. My lord, I'll file my statement of objections in the matter. Because I'm not able to secure in this week.
Seeks fund is granted a week's time fine to file a statement of objections. Objections, if any, by 27th, relist on 1st September.
Grateful, my lord.
The IO may kindly be extended, my lords.
Interim order earlier granted is extended till next year.
Grateful,
Please, please.
Non-deleting of R2 and R3, carry out the amendment.
My lords, there are 3 respondents, my lords. I had sought dispensation of notice, my lords. I had not sought deletion of them. Only notice was dispensed against them.
But
my
by
lords.
order dated 1912, R2 and R3 are deleted. 1912 order.
I'm just pulling out the. I'll carry out the amendment, my lords. There's an order.
Deletion of R2 and R3.
I will have.
Counsel for the petitioner is granted a week's time to comply with the order dated 19/12/23, IA 1 of 24 will be considered along with main.
Please.
We list on
My lords, any date commencing 7th, my lords, if I may request. Or
Ninth.
any date convenient to your lordships.
14th September.
Please, my lords.
14th Rajana. 15th September.
Please, my lords.
14th ಕೆಲವು ಮ್ಯಾಟರ್ಸ್ ಇದಾವೆ ಇಲ್ಲಿ 8 ಮ್ಯಾಟರ್ ತೋರಿಸ್ತಾ ಇದೆ. Yes.
Serial number
Yes, Mr.
10.
Bhatt.
On 1/7/2026, my lord, your lordship was pleased to dispose of the matter. Thereafter, my lord, we made an application to the third respondent or respondents seeking to reopen the club, my lord. Now they are not allowing to play the card section, my lord, or open the card section on the ground that in the operative portion of the order, the card section is not mentioned. Therefore, you get a modified order. Orally, the third respondent has instructed the petitioner. Therefore, I have filed this application seeking modification of the order, my lord, to
Card section has to be specifically mentioned.
my lord, it is mentioned, my lord. Your lordship kindly see. Oral order, your lordship kindly see page number 7, my lord, wherein it is mentioned that page number 9, my lord.
Yes.
Last paragraph. Keram, Rummy, etc. But what the third respondent says, my lord, in the operative portion of the order or last page of the order.
Page 9.
ಹೌದು.
ಎಲ್ಲಿದೆ?
7.
7. Page 7 or 9?
9, Swami. Oral order, your lordship kindly see. Last 3 lines from the top, from the bottom.
Para number.
Yes. Modification of the order, my lord. In the modification of the, my lord, in the application which I have
The
filed.
application, you are.
Application, my lord.
Yes.
Page number 9, your lordship kindly see, my lord.
Yes.
3 lines from the bottom, my lord. Keram, Rummy, etc. Now the third respondent says, my lord, play of Rummy is not mentioned in the operative portion of the order. Therefore, we are not allowing you to play open the card section. You get a specific order from the court. That's what the third respondent says. But in the series of orders, my lord, this honorable court has permitted us to play the rummy. It is not a game of chance. It is a game of skill, as held by the Supreme Court as well as by this honorable court in the several writ petitions.
You want all the games to be mentioned in the order?
No, my lord, I'll communicate, my lord. I'll communicate.
Recreation club, whatever recreation club is there. If we mention one, the other one is not there. If we mention that, another one is not there. That will be hyper technical on your part.
Yes, ma'am.
IA 1 of 26 has been moved for modification order date 1/6/26. The submission of Sheikh Shivram Butler and counsel for the petitioner is that respond number
3, my lord. 3.
3.
Yes, please. Deputy Commissioner of Police, Law and Order, DCP.
3.
3, my. Respond number 3.
Has informed the petitioner orally that since the game of rummy has not been specifically mentioned in the operative portion of the order, the petitioner, though has been permitted to run various outdoor and indoor games, the petitioner has not been permitted to conduct and or make available the game of rummy at its recreation club. The apprehension on part of the petitioner is that until, the apprehension, the submission of learned counsel for the petitioner is that the said game may also be included in the operative portion to avoid any miscommunication and misinterpretation by respondent number 3. This court, in several matters, has considered the aspect of running of a recreation club and has adverted to various indoor and outdoor games. in the orders which have been passed, there is no specific mention made of any particular indoor or outdoor game. But the orders which have been passed are general orders permitting the indoor and outdoor games subject to the conditions which have been prescribed in the said orders. Unless any particular game is prohibited under any particular law and or regulated prohibited under any particular law, all indoor and outdoor games ought to be permitted by the respondent to be run and operated in the recreation club. In the event of any particular game being regulated by any statute, it would be the statute or regulation which would be applicable to those games. It is not for the respondents to contend that since the game of rummy is not included in the operative portion, the said game will not be allowed to be played in the recreation club without adverting to any particular prohibition in relation thereto. Learned AGA, in that view of the matter, with the above observation, this court is of the, in view of the above observation, this court is of considered opinion that a modification is not required to be made, but a learned AGA is directed to bring the above to the notice of the Deputy Commissioner so that these kind of issues are not raised in respect of any other recreation club also, requiring that recreation club to unnecessarily approach this court seeking for such modificatory orders. Yes.
Serial number 11.
My lord, apologies for the intervention, my lord. My lord, apologies for intervention, my lord. My lord, item number 8, my lord, may kindly be directed to list at 2:30 p.m., my lord.
It is 2:30 list, so it will come in 2:30.
Please, my lord. Please, my lord.
Yes, Keshav.
And this is the additional government advocate appearing in this matter has sought for a short accommodation.
Well, it's
3 times we are given because the AG was appearing. Not fair to do this. They argued it 3 weeks ago.
And informal.
So. And only issue that you have to explain is how did the land increase in the beyond the 2 notifications?
notification that they place on Reliance also is
Yes,
the
sir.
correct extent of 13 acres and 20 acres.
I will inform.
It may be a little difficult to explain, but can't avoid it.
Yes, sir. We have to.
So.
Great.
Passed over matters. List number 1, serial number 11, Girish Baldare.
To the petition.
Especially the final order has not been passed, my lord, but he is participating in the proceedings.
It's participating.
Yes, my lord. And he has appeared to his advocate, my lord. So orders are not yet passed, my lord.
So you appeared and you're participating.
Please, my lord, I am participating.
They'll pass orders on that.
My lord, it may be disposed, my lord. I'll raise my contention before the appropriate authority, my lord.
Petitioner is before this court seeking for the following leaves. Your first contention was wrong. Please verify with your client because you are the one making submission. It goes with your name.
My apologies, my lord.
In the morning session, a submission had been made that without issuance of any notice, the matter was proceeded with by the respondents. In that background, the learned AGA was asked to obtain instruction, make a submission. Learned AGA submit that the respondent is represented by a counsel in the proceedings and the matter has been taken up by the respondents by adhering to all principles of natural justice. After hearing the petitioner through his counsel, necessary orders would be passed. Placing the said submission on record, reserving liberty to the petitioner to raise all contentions before respondent number. Who is the proceeding before? Respondent number 3.
Respondent number
the
3.
petition stands disposed.
Serial number
Much
60, Sabir Sharma.
Sorry for detaining your lordships. This is slightly different from yesterday's matter. If your lordship please sees over here for a moment. Sale deed is executed. In yesterday's matter, it was not. I just want to bring one thing to your lordship's notice. please see their complaint at page 142. Page 142 relevant portion is at page 145. They have asked for delay period interest. Give direction to the builder to complete and hand over the villa properly with overall livability. It is admittedly a relief insofar as delay period interest is concerned. Now, if a lordship were to please take up the impugned judgment for a moment at page 30.
Yes.
Page 30, first paragraph, relief of direction to so and so, which is extracted from the complaint. Please see, please turn overleaf, page 31, para 4. Again, the RERA says complainant has requested this authority to amend his prayer as refund with interest. Now, my respectful submission is operative portion, if your lordship please sees, of the judgment at page 40.
Yes.
Page 40, para 31. Hence, the complainant is entitled for refund with interest from 7 to 2008 till realization of entire amount. Now, my respectful submission is, if a sale deed is executed, which I have produced before lordships at page 126, refund is not possible. At best, they can seek for delay period interest. It was never their case before the RERA that they sought for refund. Refund
To
would,
execute a sale deed and don't do anything, there's no refund possible.
no, I'm coming to that. My respectful submission is there is something I have to pay. I'm not shying away from it. But they have a fixed liability from 7 to 2008.
What is the status of this villa?
Now, this villa, we have sold it to them. My contention, even before the RERA, was milestone payments.
Where is the photograph of the villa?
Photograph? I'll just.
And where is the OC for the villa?
OC is not obtained. I bow down before your lordships.
Okay.
I will have to pay. There is some liability on me. If your lordships accommodates me till Monday, I will file a memo for calculation.
It is up to them whether they want to accept the money or they want the villa.
Yes.
If
Now,
they don't, villa with delayed payment.
Yes.
Or no villa and entire money.
Yes. Now, insofar
They
as
have
they
chosen entire money.
they have no, in fact, it was not their case at all. In fact, just like yesterday's case, there was no amendment application filed, no order passed. They are only asked for delay period interest.
Have they filed an appeal challenging this?
They have not filed an appeal, which is why what I would respectfully submit is this: to even benefit the allottee a little bit, permit me time till Monday. I will file a memo for calculation, and then with respect to that, I'll make a pay. We'll make a deposit.
And it's granted 2 days time, released on 24th.
Could your lordships have it in the preliminary hearing or fresh matters?
Come in preliminary hearing only.
Please, please.
37. Davina Jia.
Yes. Which is that circular of
2312.
Third December 1986.
They were supposed to.
Yes, Jafar. Who is appearing in this? Ibru Nintidra, who is appearing?
No.
You are
I'm
appearing.
my lord. I'm 27.
37.
My apologies. I thought it's 27, my lord. My apologies.
You don't mind two of you also assisting us, no issue. See, you are referred in the order, Sarkarada Adesha 115 of 86-87, Dinanka 23-12-86. Where is that Adesha? What is it?
This is not
That was given to the district backward commission officer Belagavi. ಸರ್ಕಾರಿ ಸೇವೆಯಲ್ಲಿ ಹಿಂದುಳಿದ ನೌಕರರ ಕುಟುಂಬ ಉತ್ಪನ್ನವನ್ನು
Michael ಮಾತಾಡಿ ಕೇಳಿಸ್ತಾರೆ.
ಸರ್ಕಾರಿ ಆದೇಶ ದಿನಾಂಕ 4-3-1900 ಮೇ ಐ The one what they have submitted, my lord, I apologize, my lord, it is not legible. If I may read it, my lord. ವಿಷಯ ಸರ್ಕಾರಿ ಸೇವೆಯಲ್ಲಿ ಹಿಂದುಳಿದ ವರ್ಗದ ನೌಕರರ ಕುಟುಂಬದ ಉತ್ಪನ್ನವನ್ನು ಲೆಕ್ಕದಾಕುವ ಬಗ್ಗೆ ತಮ್ಮ ಪತ್ರದ ಸಂಖ್ಯೆ ಸೋಯನ್ಸು 8687 ದಿನಾಂಕ 30/9/86 ಸರ್ಕಾರಿ ಆದೇಶ ದಿನಾಂಕ 4/3/1970 ಮತ್ತು ಆನಂತರ ಬಂದ ಆದೇಶಗಳಲ್ಲಿ ಕುಟುಂಬ ಉತ್ಪನ್ನವನ್ನು ಗಣನೆಗೆ ತೆಗೆದುಕೊಳ್ಳುವ ಬಗ್ಗೆ ಸ್ಪಷ್ಟೀಕರಣ ನೀಡಿರುವುದು. That's the only thing. That is not a notification, my lord. So the only notification that is there is, my lord, that is 12/12/1986 notification. Thereafter there are no notification.
That has been set aside.
No, my lord, this is not set aside.
The judgment of, you got that judgment?
Yeah, Lordship, page number 126.
No, no, that's only a reference. Where is the judgment? In Akshata Chaugala. Give Akshata Chaugala judgment.
Lordship, there is only.
That notification is not set aside. December 12.
ಅದರಲ್ಲಿ highlight ಮಾಡಬೇಕು.
Yes. No, 12/12/1986 notification, my lord. In any of these judgments, that has not been challenged at any point in time. My lord. They are still,
Para 12 of Akshata Chaugala. Page 49.
It just says unsustainable, my lord.
By clinging on to the government order dated 12/12/1986.
Yes, my lord.
Which is on the face of it unsustainable.
It just said that's unsustainable, my lord. I don't know, my lord. In any of the orders, my lord, any of the judgments, my lord, they have never set aside the 12/12/1986. In fact, my lord, this own candidate, my lord.
Declaration of law by the apex court and that of this court.
Yes, my lord.
Which are the decisions referred to for this?
And also, my lord, against this judgment, my lord, there was a writ appeal that was filed before the court. In the writ appeal also, my lord, the learned division bench has held that, my lord, the question of whether the parent or the husband's income has been taken into determining whether the candidate belongs to the, has been contentious, my lord. They also do not decide regarding the 12/12 notification. Now, my lord, in this case, my lord, in this, the petitioner has taken the benefit of the 12/12/1986. There, my lord, in his first appointment, my lord, there he declares his income as well as the parent's income. He obtains a job. Maybe at that point in time, my lord, because his income was much lesser, he does not come under the bracket of the creamy layer of the 8 lakh rupees now. Now, my lord, because he's already in government in service and he has an income, if you add on, Now, my lord, he can't deny that. I'll just give that.
So you mean to say that there is no decision?
No
as
decision
regard this
to set
12-12
aside 12/12/1986.
There's no decision.
No decision, my lord.
So then the observation made, in which decision was 12-12/86 set aside?
Sorry, it was not set aside, Lordship. It was observation was made. It's unsustainable.
But it is not
Lordship,
set aside.
If I take your
But
attention,
if so long as it is there, you'll have to challenge it then.
Lordship, the reason.
No candidate
yeah,
so far has challenged 12/12/1986.
I think that's one of the mistakes all the petitioners have done till today, including us. We are not challenging the 1986 order itself, but we are asking for the relief that it is unsustainable. Lordship, if I take with your due permission, with your due permission, Lordship.
My lord, now what has happened is, my lord, they are before this court challenging the order of the deputy commissioner and the tahsildar, where he was required to produce his income and records. My lord, we are challenging that order without challenging the notification. My lord, they come before the court, challenge the order, the request of the documents to be produced, his proof of income and previous certificates, my lord.
Lordship, if I kindly take your attention to page number 6 in the judgment. Surender Singh, I have some observation in the Surender Singh judgment, Lordship. Page number 6, para number 8.
Para number?
8, Lordship.
Yes.
The question which, para number 8, Lordship. With your due permission, I will read. The question which still arises whether it was open to High Court to include the individual's income in determining the eligibility of being declared as backward by reading down the policy instruction on the subject. Insofar as the instant aspect of the matter is concerned, there can be no doubt that the issue is determinable with reference to the decision rendered in Indiraswamy versus Union of India. But for the determination of the present controversy, we need not travel to the decision of Indiraswamy. It will be sufficient to make reference to the decision rendered by this court in Ashok Kumar Thakur versus the state of Bihar. Lordship, one submission is, in Ashok Kumar Thakur case, there were two states involved, Bihar and Uttar Pradesh. Both have formed the guidelines which were contrary to 1993 guidelines. Addition to the 1993 guidelines, they had additional requirements which were struck down by this. Continuing my judgment, Lordship, sorry, continuing the same para, Lordship, they made in the page number 6 only, Lordship, in Surender Singh case.
Yes.
Yeah. In para 10, we have carefully examined the criteria for identifying the creamy layer laid down by the Government of India in schedule quoted above, and we are of the view that the same is in conformity with the law laid down by the court in the Mandal case. We have no hesitation in approving the rule of exclusion framed by the Government of India in para 2C, read with the schedule of office memorandum dated quoted above. Learned counsel for the petitioner have also vehemently condemned that the state government should follow the Government of India and lay down the similar criteria for identifying the creamy layer. And continuing, Lordship, it is apparent from the observation recorded by this court, as have been extracted here in above, the office memorandum dated 8/9/93 have been examined by this court, specifically with reference to the decision rendered in Indiraswamy case supra. Have done so, this court explicitly approved and confirmed the schedule of office memorandum dated 8/9/1993. Then, moving on, Lordship, to para number 9, based on the aforesaid declaration of law, we are of the view it is not open to the High Court to evaluate the office memorandum 8/9/1993 from any other parameters. It also need to be noticed that the issue which came up to be re-examined before the constitutional bench of this court in Ashok Kumar Thakur versus Union of India 2008, wherein on the subject of identification of the creamy layer, the constitutional bench observed the following as under. Income as the criteria for creamy layer exclusion is insufficient and runs afoul of Indiraswamy. Identification of the creamy layer has been and should be left to the government. Agree, Lordship. But they also make subject to the judicial direction. For a valid method of creamy layer exclusion, the government must use its post-Indiraswamy criteria as a template, approved by this court in Ashok Kumar Thakur versus State of Bihar. This schedule is comprehensive attempt to exclude the creamy layer in which the income, government post, occupation, land holdings are taken into the account. Lordship, continuing, here again, the court explicitly approved the office memorandum dated 8/9/1993 in view of the decision rendered by this court in both Ashok Kumar Thakur's case. One was against the State of Bihar and the other was against Union of India, Lordship. We are of the view that the High Court clearly erred in reading down the office memorandum dated 8/9/1993 and to include therein the income of individual concerned while determining whether or not you will fall under the creamy layer. Lordship, subsequent to, like in para number 10, they talk about 2002 clarification is given by the Department of Personnel Training. With your permission, I will read that. Despite the declaration of law in the judgments referred herein above, it is also necessary to take into the consideration the clarification issued by the Government of India, Ministry of Personnel, PG and Pension, Department of Personnel and Training, dated 21/11/2002. The aforesaid clarification was with reference to the office memorandum dated 8/9/1993. Relevant extract of the clarificatory letter dated 21/11/2002 is here being produced. I am being directed to refer to your letter so and so dated 11/10/2002 on the above noted subject and say that the determination of creamy layer for an OBC candidate is done with reference to the income of the parent as per the instruction contained in the DOPT's OM so and so dated 8/9/1993. And continuing, Lordship, there was one more notification, not notification, like office memorandum from the same department. Continuing, Lordship, based on the aforesaid conclusion, there is really no room for any doubt that the exposition with reference to the category 6 in the office memorandum dated 8/9/1993 related only to the income of the parents of the individual concerned, and that the income of the individual concerned was not taken into the consideration. The above said came into the examined yet again by the Government of India, Ministry of Personnel, Public Grievances and Pension Department of Personnel Training through its memorandum dated 14/10/2004, Lordship. This was after 2002 notification of the state government. In the above memorandum, a large number of queries were clarified. Queries at serial number 6 and 7 of para 4 are relevant to the present controversy. Following the questions have been raised from time and time about the application of the above provisions to determine the creamy layer. Lordship, Roman number 6, right? It's very much relevant to the current petitioner, Lordship. Will a candidate who himself is a directly recruited class 1 Group A officer or directly recruited class 2 or Group B officer who got into class 1 or Group A at the age of 40 or earlier be treated to be falling in creamy layer on the basis of his service status? It answered in subsequently. Roman number 7, Lordship, will a candidate who has a gross annual income of 2.5 lakh or above at that point of time, Lordship, or possesses wealth above the exemption limit as prescribed in the Wealth Tax Act for a period of 3 consecutive years be treated to fall in the creamy layer? The aforesaid queries came to be answered in para 8 by observing as under. In regard to clause 6, 7 and 8 of para 4, it is clarified that the creamy layer status of the candidate is determined on the basis of the status of his parents and not on the basis of his own status or income, or on the basis of the status or the income of his or spouse. Therefore, while determining the creamy layer status of a person, the status of or the income of the candidate himself or his or her spouse shall not be taken into account. Action. Shall I continue? In view of the above, there is no room for any further consideration whether or not individual's income is to be taken into consideration while computing the total income relevant to the to determine whether the individual's income belongs to the creamy layer. The above clarification reveals that this is only to the parent income which has to be taken into the consideration.
This was a clarification issued by DOPT for Union of India. So that's a different issue altogether.
Lordship, the last para, like in page number 9, that was the view from the Government of India. Sorry, Honorable Apex Court.
Yes, in view of the clarification.
Yeah, in view of the clarification.
In view of the clarification, DOPT, which will be applicable for Union of India services.
Appointment.
Not for the state of Karnataka.
Lordship, in that context, right?
And it's come to the next para.
Yeah, Lordship. While referring to the clarification or circular dated 14/10/2007 and 14/10/2004 respectively, we have extracted herein above the clear view of the Government of India. It would also be necessary for us to notice that the above determination of Government of India was adopted by State of Punjab, or in as is apparent from the letter issued by the Government of Punjab Welfare Department Reservation Cell dated 14/10/2007, whereby letter dated 17/8/2005 and the memorandum dated 14/10/2004 were circulated by the state government to all its deputy commissioners. It is also not a matter of dispute that the aforesaid circular were explicitly adopted by the Punjab State Electricity Board. Thus viewed, we are satisfied that the individual's income was not required to be clubbed with that of the income of his parents, while addressing whether or not he was eligible to be granted a backward class certificate. The determination to the contrary by the High Court is liable to be set aside. The same is accordingly hereby set aside. The instant appeal is accordingly allowed. While allowing the instant appeal, we restore the appointment of the appellant Surendra Singh to the post of accountant officer.
See, you may have a good case, but if you don't challenge that circular, we can't hold otherwise. What the Honorable Supreme Court did in this matter was DOPT clarification which had been issued was adopted by State of Punjab. This was Surinder Singh versus State of Punjab. Therefore, it was applicable to State of Punjab and held that the interpretation by the authority was not proper. That is correct.
Yes.
Karnataka has not accepted or adopted this circular. They are saying that there this 12-12-86 shows a judgment where 12-12-86 has been set aside.
Lordship.
If you show us that judgment done, it's in your favor.
Lordship, one question is like whether the question of whether it's applied or not, I'm not sure, but by and large, it's not yet applied in the state of Karnataka. But if you observe the the observation which are made in the
We are not cutting you short in argument. There are two things that you have to show us is either whether DOPT has been applied, approved, applied, adopted in Karnataka. One, if it is adopted, also you succeed.
Lordship.
If it is not adopted, if 12-12-86 is set aside, and if there is any finding on 12-12-86, that also you can show. These two you can show. You can't interpret it while 12-12-86 is still there. You can challenge it. You may succeed in the challenge, but without challenging it, you can't make this argument.
Lordship, I completely agree, but my own submission is like the contrary rules which were made against 1993 were set aside in Ashok Thakur's case, Lordship.
Show us the judgment. What is it? Even if that is so, it can 12-12-86 has to be set aside, which cannot be set aside without you. We can't set it aside for you. You have to challenge it. Set aside and get putting side it has to be set aside in law.
Lordship.
Without you challenging it, how do we set it aside?
But Lordship, the very own Honorable High Court has leveraged the Surendra Singh in the other High Court, Lordship. In other cases.
We can only tell you this much. We can't say more. Last time also you argued, we told you this. You still have not challenged it. Yes.
Lordship, in the internal page number 422.
422.
Yeah. So I directly go into the para number 19, Lordship. We allow the writ petition quash except clause 1 of Schedule 3 of BR reservation of vacancies in post and services for scheduled caste, scheduled tribe and other backward class Amendment Act 1995. We also quash Schedule 2 read with Section B of Uttar Pradesh Public Reservation Act of Scheduled Caste and Scheduled Tribes and Other Backward Classes Act 1994. We further direct that the academic year 1995 and 96, the states of Uttar Pradesh and Bihar shall follow the criteria laid down by the Government of India, reproduced above in memorandum dated 8/9/93. It will be open to two states to lay down such fresh criteria for subsequent years in accordance with law.
It was quashed because it was challenged.
Yeah.
You're not challenged.
Notification.
Nor is any decision placed on record indicating that 12-12-86 is quashed. So at least now wake up and challenge it.
Lordship, if we can get that interim relief, we will definitely. If I can get an interim relief for applying.
How do we give interim relief when 12-12-86 is there? They have applied the law as is. Can we give an order contrary to the law?
The same High Court, like the Honorable High Court has told, it's unsustainable.
We'll have it on Monday, at least challenge it on that. At the request of counsel for the petitioner, relist on Monday. If you don't challenge on that day, we'll dismiss it, we are telling you. The third time adjournment we are giving you. For the same reason, you're still coming back and arguing the same thing.
Serial number 41. Kumar NJ, corrected matter.
Two, 5, 6, 9, 7.
Please, my lord. 25697. My lord, the proceeding was I'm sorry. Open ಮಾಡಿರಿ.
Yes, please.
My lord, the respondents 5 and 6 in this writ petition are the contesting respondents. At their instance, an application before the deputy commissioner, the first respondent, sorry, seventh respondent,
Yes.
was filed in terms of Rule 150 of the Petroleum Rules 2002, which empowers the deputy commissioner or the government to withdraw the NOC granted to a distributor.
Yes.
Initially, the petitioner before your lordship was not made a party and she got herself impleaded as respondent number 3
Yes.
on the ground that there is a violation of the injunction order and therefore he has no locus standi. It's at page 119, minute, Annexure G, page 119, the impleading application.
Yes.
My lord, may kindly turn to page 120, unnumbered para 1, immediately after the swearing in of the affidavit. That's unnumbered para 1. The petitioners have filed this. May I read, my lord?
Yes.
The petitioners have filed this petition under Rule 150, read with 152 bar brackets 1 and 2 under the Petroleum Rules 2002 to cancel the license issued to respond number 1 and 2. The petitioners, this is important, the petitioners have no locus standi to file this petition as they are not having any rights over the property in question. And my lord, after narrating the civil court proceedings, the next page 123, sorry, 121.
Yes.
I'm sorry for the interruption. Before that, my lord may kindly note down 3 dates, my lord, which are important in this case. My lord, the suit by the petitioner for partition in OS number 142 of 2020 was filed on 12/3/2020.
12/3?
12/3/2020. On 13/3/2020, an order of temporary injunction was passed, restraining defendants 1 and 2 from alienating the suit schedule property. Item number 3 of the suit schedule property is the property that is subject matter of this writ petition.
Yes.
Then on 5/9/2021, the order was made absolute until further orders, the injunction order.
Yes. When was the sale?
Sale deed was registered on 23/1/2023.
Yes.
In favor of respondents 5 and 6. These are all undisputed facts. No, my lord, may kindly permit me to read from on page 121, from line 3, after the description of the property and its boundaries. The said Bharat and his mother, Krishnaveni, by violating the interim order of temporary injunction have created a sale deed on 23/1/2023 in favor of petitioners Tulsi Devi Parikh and Anita Parikh, who are the petitioners in this case, who have been subsequently implicated in the said suit. The petitioners will not get any right or ownership of to the above said property, as the said document was created during the pendency of the suit and by violating the order of injunction. The petitioners, by not disclosing the real fact regarding pendency of the suit, have filed this petition to revoke the no objection certificate. When the petitioners have not acquired any right.
How do you say petitioner will not get right of ownership when there's a
Please,
sale?
I'll assist your lordship on that. I'll assist your lordship on that. The petitioners have not made when the petitioners have not acquired any right over the property, they are not entitled to seek for any redressal. The petitioners have not made the minor Tanvi as additional respondent, as she is the co-owner of the said property. Now it's very much necessary to implead the applicant as respondent number 3 in this case. No prejudice or hardship will be caused to the defendants 1 and 2 if the annexed application is allowed. If not, the minor will be put to irreparable loss, which cannot be compensated in any manner. This was the basis on which she filed the impleading application. Impleading application was allowed, and she was respondent number 3 in the case. But annexure A is the impugned order. Before that, I may permitted to read one paragraph of the objection filed by the petitioner in the first case, that's BPCL.
Yes.
It's at page 130, annexure J.
130.
Please, Malad.
Filed by BPCL.
Filed by BPCL, the first petitioner in the first state petition.
Yes. They'll be supporting you.
Beg your pardon?
They'll be supporting you. They're not actually supporting you.
No.
They are supporting respondent number 4. And as a default, they have to support you.
Naturally, your lordship rightly said that both of them are trying to shoot from my shoulders, and now
you are being used.
And now I have become more cautious after your lordship's observation that I have to protect the interest of the minor child. Therefore, in law, what I can assist your lordship, I'll be making only that effort to that extent, not beyond that. Neither speaking for either BPCL or
you and your husband are fighting.
Yes.
Somebody else is taking the advantage.
Yes.
That is why we said we have to protect your minor's interest.
Yes.
How well can we protect it when you are fighting like this will be difficult. So where is the proceedings between you and your husband? If there's any mediation possible there, that is what will resolve these issues. Otherwise,
in fact,
you will not get anything.
I had a discussion with the advocate
You will not get anything.
I had a discussion with the advocate for BPCL yesterday evening when the matters could not reach. Your lordship was pleased to suggest that if all of you can sit together and thrash it out. I told him that he said that he had to contact his senior officers so far as this is concerned. It may require some time.
BPCL is a third party.
No, BPCL is the lessee. The lease deed is in favor of the BPCL and the dealership license.
That lease is expired.
That lease is expired.
He has to give it. They are also not bothered. It's only respondent number 4 who is bothered.
No, because if the lease goes, maybe I do not actually know. Please, page 130, annexure J. I'll read only one first paragraph. At the very outset, it's respectfully submitted that the petitioners have absolutely no right, title, interest, much less possession in the petition scheduled property, and they are strangers to the petition scheduled property, and they have absolutely no right to file the above petition, as they have no locus standi to file the above petition, and hence the petition has no legs to stand, and the same has to be dismissed in limine at the very outset. As observed rightly by your lordship, they have to support me, and they have supported me in this case, like the implementing application amendments.
You are thinking they are supporting you. They are not supporting you. They are supporting respondent number 4.
Exactly. Annexure A is the impugned order that is passed by the Deputy Commissioner.
Yes.
Acceding to the request of respondents 5 and 6.
Yes.
It starts from pages 18 to 24. On page 22, the Deputy Commissioner refers to the orders passed by the city civil court, wherein the order and the first at the top, the defendants are hereby temporarily restrained from alienating the suit properties in any manner till the next date of hearing. ಆನಂತರದ ದಿನಾಂಕ 5/8/2021ರಲ್ಲಿ ಮಧ್ಯಂತರ ತಡೆಯಾಜ್ಞೆ ಆದೇಶವನ್ನು ಮುಂದಿನ ಆದೇಶದವರೆಗೆ ವಿಸ್ತರಿಸಿ ಆದೇಶಿಸಲಾಗಿದೆ. ಪ್ರಕರಣವು ಮುಂದುವರೆದಂತೆ ಅರ್ಜಿದಾರರು ಸಹ ಸದರಿ ದಾವೆಯಲ್ಲಿ ಸೇರ್ಪಡೆ ಹೊಂದಿದ್ದು ದಿನಾಂಕ 21/4/23ರಲ್ಲಿ ದಾವಾದಾರರು ಸಲ್ಲಿಸಿದ ಮಧ್ಯಂತರ ಅರ್ಜಿಯ ಮೇಲೆ ಕೆಳಗಿನಂತೆ ಆದೇಶವಾಗಿರುತ್ತದೆ. IA filed by the plaintiff under section 151 of CPC is hereby allowed. Accordingly, the defendant number 1 and 2 are hereby directed to deposit sale proceeds of rupees 10 crore 50 lakhs, which was received by them under registered sale deed dated 23/1/2023 within 1 month from the date of this order, by excluding civil vacation so and so, which is not important.
What is this IA under section 151 that you had filed?
Since the sale deed was contrary or in violation of the injunction order.
The IA as to what your contentions are. Because the fact that 10 crore 50 lakhs of the sale consideration has been deposited.
No, it is not yet. It's not yet. That
directed to be deposited.
Directed to be deposited.
At the most, it would be that is for your husband and mother-in-law to deposit.
Yes, madam.
Not for 5 and 6. They have paid to your husband and mother-in-law.
Yes. Yes.
So it is for them to deposit.
Correct.
So if the fact that this order has been passed would indicate that the court is only going to decide your claim as regards the money component, not the property component.
Yes, my lord. It is only
after having got this order of deposit of 10 crore, you have to pursue that. You cannot still hang on to
order
the
39,
property.
order 39 rule 2A petition is filed and this order to be separately, and that is in process, my lord.
Show us this 151 application, what you have said.
I'm sorry, my lord, right now I don't have.
You can show it. Anyway, the HPCL wants time. We'll have it on Monday. You can show it on that. You can complete your app.
Please, my lord.
No, my lord, I appear for petitioner in this case, my lord.
Yes, madam.
I seek for the accommodation, my lord.
Once arguments complete, then we'll accommodate. Yes. Yes.
My humble endeavor before your lordship would be to assist this honorable court as to what is the legal status of the sale deed in law.
Yes.
And what would the contesting response 5 and 6 get under that sale deed? I'll limit my submissions only to that aspect. And insofar as the consideration by the deputy commissioner, though these civil court's orders are narrated only as matter of the submissions made by the parties, there is no consideration by the deputy commissioner of the pendency of the case or the injunction order passed in that case or the order to deposit. There is absolutely no, that is there, at page 23.
Yes.
It starts from on the left hand side 150 refers to the provision of law. After this provision of law, where the application of mind or the consideration of the request of response 5 and 6 is in the last unnumbered last para. ಮೇಲ್ಕಂಡ 150. May I read that, madam?
Yes.
ಮೇಲ್ಕಂಡ 151 ಎದುರುದಾರರಿಗೆ ಸಾಕಷ್ಟು ಕಾಲಾವಕಾಶ ನೀಡಿ ಪ್ರಕರಣದ ವಿಚಾರಣೆ ನಡೆಸಲಾಗಿದ್ದು ಎದುರುದಾರರು ತಮ್ಮ ಲಿಖಿತ ತಕರಾರು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಎದುರುದಾರರ ಲೀಸ್ ಅವಧಿ ದಿನಾಂಕ 31/8/2023 ಮುಗಿದಿದ್ದು ಅದನ್ನ ವಿಸ್ತರಣೆ ಮಾಡಿಸಿಕೊಂಡಿರುವ ಬಗ್ಗೆ ಎದುರುದಾರರು ಯಾವುದೇ ದಾಖಲೆಗಳನ್ನು ಹಾಜರುಪಡಿಸಿರುವುದಿಲ್ಲ. ವಿವಾದಿತ ಸ್ವತ್ತು ಅರ್ಜಿದಾರರಿಗೆ ಕ್ರಯವಾಗಿದ್ದು ಸದರಿ ಕ್ರಯದಂತೆ ಅರ್ಜಿದಾರರಿಗೆ ಹಕ್ಕು ವರ್ಗಾವಣೆಯಾಗಿರುವುದು ದಾಖಲೆಗಳಿಂದ ಕಂಡುಬಂದಿದೆ. ಅರ್ಜಿದಾರರು ಮತ್ತು ಹಿಂದಿನ ಮಾಲೀಕರು ಎದುರುದಾರರಿಗೆ ಸ್ವತ್ತು ವರ್ಗಾವಣೆಯಾಗಿರುವ ಕುರಿತು ಮತ್ತು ಲೀಸ್ ಅವಧಿ ಪೂರ್ಣಗೊಳ್ಳುತ್ತಿದ್ದು ಸ್ವಾಧೀನವನ್ನು ಬಿಟ್ಟುಕೊಡುವಂತೆ ಅನೇಕ ಕಾನೂನು ತಿಳುವಳಿಕೆ ಪತ್ರಗಳನ್ನು ನೀಡಿದರೂ ಸಹ ಅದಕ್ಕೆ ಎದುರುದಾರರು ತೆಗೆದುಕೊಂಡಿರುವ ಕಾನೂನು ಕ್ರಮದ ಬಗ್ಗೆ ಯಾವುದೇ ದಾಖಲೆಗಳನ್ನು ಸಲ್ಲಿಸಿರುವುದಿಲ್ಲ. ಸ್ವತ್ತಿನ ಮಾಲೀಕರಿಂದ ಲೀಸ್ ಅವಧಿ ವಿಸ್ತರಿಸಿಕೊಂಡು ಬಂದಲ್ಲಿ ನಿರಾಪೇಕ್ಷಣ ಪತ್ರಕ್ಕೆ ಅರ್ಜಿ ಸಲ್ಲಿಸಲು 4ನೇ ಎದುರುದಾರರು ಸ್ವತಂತ್ರರಾಗಿರುತ್ತಾರೆ. ಪ್ರಸ್ತುತ ಸ್ವತ್ತಿನ ಮಾಲೀಕರು ಎದುರುದಾರರ ಸ್ವಾಧೀನವನ್ನು ತಕರಾರು ಮಾಡಿ ನಿರಾಪೇಕ್ಷಣ ಪತ್ರ ರದ್ದುಪಡಿಸುವಂತೆ ಕೋರಿದ್ದು ಎದುರುದಾರರ ಲೀಸ್ ಅವಧಿ ಮುಗಿದಿರುವುದರಿಂದ ಮತ್ತು ಲೀಸ್ ಮುಂದುವರಿಸಿರುವ ಬಗ್ಗೆ ಯಾವುದೇ ದಾಖಲೆಗಳು ಸಲ್ಲಿಸದೇ ಇರುವುದರಿಂದ ಎದುರುದಾರರಿಗೆ ನೀಡಿರುವ ನಿರಾಪೇಕ್ಷಣ ಪತ್ರವನ್ನು ಈ ಹಂತದಲ್ಲಿ ರದ್ದುಪಡಿಸುವ ಸೂಕ್ತವೆಂದು ಮನಗಂಡು ಈ ಕೆಳಗಿನಂತೆ ಆದೇಶಿಸಿದೆ. Then order is passed against in favor of respondents 5 and 6. In this case, like the notices, it may not carry much force now at this stage. The notices which were sent by the response 5 and 6, even during the pendency of this writ petition also, a fresh legal notice I am told is issued to the fourth respondent to hand over the possession, and during the currency of the interim order passed by this honorable court. But I leave it to your lordship and Malad Day.
That's a civil dispute that they can always go ahead. Here we are concerned only with this.
Only with the legality of the order. Yes.
That is why we are saying even in the suit, whatever the suit has been filed, you have to do it there.
Yes.
If they have to recover possession, they have to do separately. We are only concerned with whether Rule 150 has been complied with or not.
Or not. That is, Malad, honestly speaking, that is more for either the fourth respondent or Malad, the petitioner in both the other cases. It may not lie in my mouth to say that, except that I have had the benefit of an injunction order. Contrary to that order, the sale deed is executed. What is the legal effect of that sale deed? Would it any out of my benefit or not? Will be my submission.
Whatever submission you want to make, that is why they have pushed you forward first.
That's right. No, actually, Madam wanted to argue since your lordship said you are the person to whose instance the injunction order was passed.
Yeah.
You argue it. I may be permitted to produce a copy of the order of the Supreme Court.
Yes, please.
The facts start from paragraphs 1 and 2. I'll read only that portion of the order which is relevant for deciding the case. It is at page 690. It starts from the name of His Lordship Justice G.S. Singhvi J. This is an appeal for setting aside order dated 16/5/2007 passed by the learned single judge of the Patna High Court, whereby she dismissed the second appeal filed by the appellants and upheld the decree passed by the first additional district judge Jamui so-and-so in title number so-and-so. The second paragraph. The respondents filed suit for grant of a declaration that by virtue of the sale deed executed in their favor by Bhuvaneshwar Tanti, son of Dukan Tanti, they have become owner of the suit property, but a cloud has been created on the rights by the judgment and decree passed in title suit number so-and-so, filed by Srimati Pariya Devi. Then paragraph 3. Srimati Pariya Devi contested the suit on several grounds, including the one that the sale deed was illegal and was not binding on her because the same had been executed in violation of the order of temporary injunction passed on so-and-so in OS number so-and-so. On the pleadings in paragraph 4, only clause 5 may be seen, which is relevant for the purpose of this case. Whether the plaintiff has acquired title on the basis of sale deed dated 9/11/1973.
Yes.
In para 10, it's a case, briefly to pause here for a moment. It was a case where the suit was filed and after 10 years, injunction order was granted, and after 10 years, the High Court found that the court which passed the order of injunction had no jurisdiction. Then the High Court relied upon that order and said the suit has to be decreed. That was decreed. And the Supreme Court, while reversing that order, relied upon a previous judgment of the Supreme Court that my lord will get in at paragraph 10.
Yes.
Page 692. The nature and effect of an alienation made in violation of an order of injunction was considered in so-and-so case. The following propositions were laid down. According to this section, if an objection is raised to the jurisdiction, well, that's too long, I may be permitted to read from line number 5 from below. It starts from the words, can it be said that?
Yes.
Can it be said that the orders passed by the civil court and the high court during this period of 6 years were all honest, and that it's open to the defendants to flout them merrily without fear of any consequence? Admittedly, this could not be done until the High Court's decision on the question of jurisdiction. The question is, whether the said decision of the High Court means that no person can be punished for flouting or disobeying the interim stroke interlocutory orders while they were in force, that is, for violations and disobedience committed prior to the decision of the High Court on the question of jurisdiction, holding that by virtue of the said decision, the High Court, into the brackets, on the question of jurisdiction, close the bracket, no one can be punished thereafter for disobedience or violation of the interim orders committed prior to the said decision of the High Court would indeed be subversive of the rule of law and would seriously erode the dignity and the authority of the courts. We must repeat that this is not even a case where a suit was filed in the wrong court knowingly or only with a view to snatch an interim order. As pointed out here and above, the suit was filed in the civil court bona fide. We are of the opinion that in such a case, the defendants cannot escape the consequences of their disobedience and violation of the interim injunction committed by them prior to the High Court's decision on the question of jurisdiction. It's a bit long, but my lord may kindly permit me to read it. The Learned Counsel for Defendants 1 and 2 submitted that this is not a proceeding for contempt, but a proceeding under Rule 2A Order 39 of the Civil Procedure Code. The Learned Counsel submitted that proceedings under 39 Rule 2A are a part of the coercive process to secure obedience to its injunction, and that once it's found that the court has no jurisdiction, question of securing obedience to its orders any further does not arise. The Learned Counsel also submitted that enforcing the interim order after it is found that the court had no jurisdiction to try the said suit would not only be unjust and illegal, but would also reflect adversely upon the dignity and authority of the court. It's also suggested that the plaintiff had instituted the present suit in the civil court knowing fully well that it had no jurisdiction to try it. The finding is, it is not possible to agree with any of these submissions, not only on principle, but also in the light of specific provisions. But this is not relevant because there's only Bombay Act. Then, my lord, in paragraph 12, another judgment of the Supreme Court is referred to and followed. Paragraph 11, sorry, paragraph 11.
Yes.
Without impacts. At the cost of repetition, we consider it necessary to mention that respondent number 1 had filed a suit for specific performance of agreement dated 39/88, executed by respondent number 2. The appellants and Bhagavati developers are total strangers to that agreement. They came into picture only when respondent number 2 entered into a clandestine transaction with the appellants for the sale of the suit property and executed the agreements for sale, which were followed by registered sale deeds, and appellants executed agreement for sale in favor of Bhagavati developers. This is important. These transactions were in clear violation of the order of injunction passed by the Delhi High Court, which had restrained respondent number 2 from alienating the suit property or creating third-party interest. To put it differently, the agreements for sale and the sale deeds executed by respondent number 2 in favor of appellants did not have any legal sanctity. In view of the above said judgment, ultimately the matter was remanded to the High Court to treat it as a substantial question of law under section 100. But the law laid down is any order passed, any document executed in contravention of the order of injunction.
But these are all in proceedings which are on appeal in a civil proceedings.
Yes, yes.
This judgment was
yes,
after
yes,
RSA.
Yes.
Regular second appeal, which was
Please,
taken up before the Supreme Court.
Please.
We are not in those proceedings. You can always raise this.
Correct.
Those are in the suit.
Please, please.
Suit is still pending.
Suit is still pending. And respondents 5 and 6 are also the respondents in that who were subsequently brought on record. But my humble submission to your lordship,
even if we accept your entire contention,
yes,
even if we have to accept your contention, you only have a portion of a part right in the property.
True.
That's all.
This is only one of the items, and my 1/12 share may include this entire property. In the event of the court deciding,
the most it could also be, if you are aware of all these things,
yes,
it could also be that if the sale has happened, you will get a share in the amount, and you could get another property in lieu of this property. There's nothing which has happened.
Nothing has happened.
And
ultimately it depends, as your lordship rightly put it, on the outcome of the suit pending before the court. But now
we have to only decide in this matter is
whether the DC was right in entertaining a petition under 150 at the instance of respondents 5 and 6 who are here, since they did not derive any right, title or interest.
No. Under 150, what we have to only decide is whether there is any subsisting right of respondent number 4 to continue to be in possession of the property.
Yes, ma'am.
Requiring the no objection to be extended or not cancelled.
No,
Either of these two. It is not, we are not determining their rights, nor we are.
Correct.
We are only determining the person who is running the petrol pump, whether he has a right to continue or not.
Any interest. The words used are any interest.
That's all.
And I made that submission, I repeated the cost of repetition, that is for Sushila Madam to convince your lordship as to whether she has any subsisting right in the property.
23 lease is expired, thereafter there is no document which is there.
I do consider that. I do consider that.
So
Then
that
what
is what
would be
we
the
have to
position of a person who is in possession? Is for Madam to convince your lordship. And I only request, sorry.
Is there any specific performance suit filed for extension of lease?
No,
No. Nothing is pending.
nothing.
Lease has come to an end.
Lease has come, admittedly.
HPCL has not filed anything. So how can it continue in possession?
The legal position is as a matter of
Your
legal
rights
position.
will be decided there.
Yes.
What we are not considering your rights. They are putting you forward. We are not worried about that. You will record your submissions. What we are actually considering is HPCL's right.
HPCL right. Yes, HPCL, my lord, has a right, if not as a tenant holding over, but at least as a tenant at sufferance. That's the legal position.
Then let them make their
Yeah,
submission.
please,
Rather
please.
than Indian
No, it's only as a matter of my lord, passing reference about the legal position. My lord, I assisted your lordship. Yes.
Now that they're firing from your shoulder, so let them fire by themselves. Yes, madam.
My lord, I'm sorry. My lord, may kindly permit me to read one more judgment to rely upon, which is the latest judgment. It was decided on 13/1/2025 by the High Court of Delhi. I'm sorry, Delhi. But in that, please, madam.
Copy ಕೊಡಿ.
Copy ಕೊಡಿ.
Judgment copy.
You should give copies
My humble
to-
apologies. Excuse me, please. madam.
ನಿಮ್ ರಿಪ್ಲೈ ಹೆಂಗು ಮಂಡೇ ತಾನೆ.
Monday ಇದೆ.
ಇರ್ಲಿ ಸ್ವಾಮಿ, ಅಲ್ಲ ಹೇಳಿದ್ದು. It's a matter of courtesy, one
ಇಲ್ಲ,
copy.
ಕೊಡ್ಬೇಕಿತ್ತು. Courtesy ಅಲ್ಲ, it's a duty. not
Courtesy ಅಲ್ಲ,
courtesy.
duty.
It's a duty.
Absolute.
I do concede, my lord. I do concede. Only now I found out that, my lord, only 2 judgments are there.
Yes, please.
My lord, the appellants have filed the present appeal, impugning an order dated 16/12/2004, passed by the learned single judge in so and so case, whereby the learned single judge had found that respondent number 2 had executed the sale deeds in respect of the property bearing number so and so, Delhi, or part thereof, in willful defiance of the judicial orders. Accordingly, the learned single judge declared the sale deeds executed in favor of the appellants as void ab initio. It is material to note that the impugned order was passed at an interim stage, and the learned single judge expressly clarified that the submissions regarding sale consideration paid by the appellants, respondent number 4 and 5 so and so, would be examined on the next date of hearing. Now, my lord, in this case, paragraph 8 may kindly be seen, my lord. It was contended by the purchasers. It's at page, my lord, 4.
Yes.
Paragraph 8. Thereafter, on 9/8/2019, respondent number 2 executed another sale deed for 50 square yards of the property bearing number so and so in favor of the appellants for a sum of rupees 20 lakhs. The said sale deed was also registered before the concerned sub-registrar. The appellants claim, this is a very important contention, admittedly, these persons who were purchased were not parties at the time when the sale deed took place in that suit. The appellants claim that they had no knowledge of any dispute or litigation in respect of the property purchased by them and are bona fide purchasers of the same. They also claim that possession of the property sold to them was handed over to them simultaneously with the execution of sale deeds. But the next contention is on the next page in paragraph 9, third line from above. He contended that declaring the sale deed to be void would in fact inure to the benefit of respondent number 2 who had violated the orders passed by the court. Then, my lord, paragraph 12. there is no cavil, this is a finding of Delhi High Court, there is no cavil that respondent number 2 had executed the sale deeds in violation of an express order passed by this court to maintain status quo. In this case, it's an order of injunction as to the possession and title of the property in question. Thus, the key question to be addressed is whether sale of immovable property in violation of the orders passed by the court is void. This is precisely my submission, madam. In our view, the said issue is no longer res integra and is covered by various decisions rendered by the courts, including the apex court. This is the first judgment, madam. There are 4 judgments. I will not read the entire thing, madam. In Surjit Singh and others, so and so, the Supreme Court had considered, I'm sorry, madam, the question whether a deed of assignment is required to be treated as non-est because it was in clear violation of the order passed by the trial court restraining the parties from alienating or transferring the property involved in the suit. The Supreme Court had concluded that the transaction in violation of a restraint order is required to be presumed to not exist at all. Thus, the Supreme Court had also set aside the order impleading the purchasers who are similarly placed as appellants in the present case to the suit. On the next page, at the bottom, there is similar number 3. The questions are, that's the questions that were framed by the Bombay High Court, which is not relevant, but it's relates.
We are not deciding this issue here.
No, but no, what is my humble submission to Lordship's kind consideration is, if respondents 5 and 6 had not presented that petition to cancel the to withdraw the NOC and restore the possession to them in view of the sale deed, this question of the deputy commissioner passing an order would not have arisen at all. Therefore, it is the locus of the response number 5 and 6 to approach the deputy commissioner. The deputy commissioner, if had
even a third party can approach under 150.
No, minute.
Not only a person. It is only to be brought to the notice of the deputy commissioner that this person does not.
No,
have
if
right
a third party had brought to the notice of the deputy commissioner, that would have been on a completely different pedestal. Here,
both under the Cinema Act and under this, it is the same problem which has been held by the division bench of this court.
Yes.
Anybody can bring to the notice.
Yes. Now, if the deputy commissioner, in spite of bringing to the notice about the pendency of the case, and in spite of the deputy commissioner, the impugned order referring to those orders, has not applied the mind to that whether it could have been done if they were treated as strangers, not as the persons who get right title or interest under the sale deeds. It's completely on a different footing.
We said even if it is presumed, he was no authority to decide you are right. You want a deputy commissioner to decide you are right.
Not that.
Then
the matter is pending in the courts. That is sub judice. And therefore, I cannot entertain a petition under Rule 150. Ought to have been the stand of the deputy commissioner is my humble submission, and therefore I pray my lord to set aside that order on that sole ground that the deputy commissioner did not have the jurisdiction to entertain a petition under Rule 150 at the instance of a person whose sale deed is void ab initio.
Yes.
It is in that context, madam. If it were strangers, I would have been unsuited. The questions are, is the transfer of an immovable property in contravention of a prohibitory or injunction order of a court illegal or void? Then, on page 11 of 25, I'll read only one paragraph, which is, it's paragraph 24. We cannot be unmindful. We cannot be unmindful and ignorant of the importance of this aspect which has been repeatedly emphasized by the Supreme Court. We would be failing in our duty if we do not abide by the ratio laid down in the aforesaid decisions. That apart, in the case of so-and-so 1994 Supreme Court, it is observed as under Mr. Justice Arthur V. So-and-so in his Change of Law Reforms 1955 at pages 4 and 5 has stated that it is the courts and not in the legislature that our citizens primarily feel the cutting edge of the law. If they have respect for the work of their courts, their respect for law would survive the shortcomings of every other branch of the government. But if they lost their respect for the work of the courts, their respect for the law and order would vanish with it to the great detriment of this society. Respect for law is one of the cardinal principles for an effective operation of the Constitution, law, and the popular government. The faith of the people is the source and succor to invigorate justice intertwined with the efficacy of law. The principle of justice is ingrained in our conscience, and though ours is a nascent democracy which has now taken deep roots in our ethos of adjudication, be it judicial, quasi-judicial, and or administrative, as hallmark, the faith of the people in the efficacy of judicial process would be disillusioned if the parties are permitted to abuse its process and allowed to go scot-free. It is, with emphasis, I read this. It is but the primary duty and the highest responsibility of the court to correct such orders at the earliest and restore the confidence of the litigant public in the purity of fountain of justice, remove stains on the efficacy of judicial adjudication, and respect for rule of law, lest people would lose faith in the courts and take recourse to extra constitutional remedies, which is a death knell to the rule of law. But there is another reference to the judgment. I will not repeat it and burden my Lord Millard. And on page 17, Millard, just above paragraph 7, the first 4 lines. In the light of the aforesaid discussion. May I read, Millard? I'll read only those, Millard, marked portion by the court itself.
Page 17.
No, page 17 of page 25. It's
Page
at the bottom, Millard, right hand side.
Yes.
The first
topmost.
at the topmost. In the light of the aforesaid discussion, the answer to question number 1 is that the transfer is illegal and cannot be recognized. Consequently, the transferee gets no valid title, nor does he acquire any right or interest in the immovable property. If they had only stated that withdraw NOC because there is no lease which is extended lawfully and therefore they are in illegal possession. Fine. Now, it is not granted, that's a different thing. But I'll read to your lordship the prayer in the petition filed by respondents 4 and 5. They seek for restoration of possession. But what is stated in the previous paras that he has resorted to extrajudicial method instead of.
Would have been right if that was granted. That's not been granted.
That's not granted.
The NOC has been.
Yes, my lord. My humble submission at the cost of repeating myself is, if it were only by some other party, I would have been non-suited. But it is only because it is at the instance of response 5 and 6 under the sale deed, and that should have been taken note of by the deputy commissioner is my submission. At page 17, there is another judgment of the Supreme Court. I will not read the entire thing, and at page 14, fourth judgment of the Supreme Court.
What do you want to refer to? Please tell us.
No.
We'll deal with it. So,
on page 23 of page 25, Millard. Just above paragraph 20, there is an extract of the previous judgment at para 89. It's numbered as 89. Last but 2 pages, Millard. At the bottom,
yes,
it's page 23.
Yes.
89 paragraph. Only I'll read that paragraph, Millard. The High Court declared all the sale deeds executed by the contemnants in favor of the purchasers as non-est. The High Court ordered that the sale deeds stand cancelled and set aside. The contemnants were directed to restore the position which was prevailing at the time. Well, this in the contempt proceedings, I cannot pray my lord to do that in this case. Except
this decision was also in a contempt proceeding.
Yes, it was also in a contempt proceeding. And Millard, the last paragraph in paragraph 21, Millard. That's the crux of Millard, the entire consideration of all the cases.
Yes.
Paragraph 21. May I read, Millard?
24 and
Millard, the numbers are confusing because the paragraphs of the previous judgments are Millard, referred to like that. This Millard, this judgment has only 22 paragraphs, Millard.
Oh, these are all
They are all of the previous judgments of the Supreme Court on which my lord, the Delhi High Court was pleased to rely upon. And my lord, the reliance was by quoting all those by reproducing all those judgments.
This is a extract of Keshirmal Jivji Shah.
No, Vidur implex, my lord.
Viduralla.
Vidur 86. That my lord will get it in.
Starts at para 12 at page 7.
Yes, my lord.
12, 13, 14, 24.
Almost about five pages, my lord.
So that is all. Then para 17, Krishna Kumar Kemka.
Please, my lord.
Vidur implex illa. Now this para 89.
In para 18,
is
my
the
Savitri Devi is
extract
referred.
Of Balwant by
Balwant
Sonabai.
Bai. That is the important judgment which was, my lord, was followed by the Bombay High Court and also the Delhi High Court. That's how the Supreme Court. Paragraph 18. In paragraph 19, that judgment is referred, my lord. The issue involved is squarely covered by the authoritative decision of the Supreme Court in Balwant Bai also. That's paragraph 19.
This is para 19. Yes.
But until this paragraph 21,
Is from Balwant Rai.
please, my lord. And
No, until that para 89 is Balwant Rai. 20 is this judgment.
Yes,
You are
ma'am.
referring now to 21 of this judgment.
yes, my lord. No, the 21 of the. My lord, this is the summing up of the consideration of all those judgments. The substratal principle which supports the view that such transactions are required to be treated as non-est and void is that the court must presume the transactions that have been consummated in violation of its order as non-existent. This is the principle on the basis of which the Supreme Court had in Surjit Singh, etc., so and so, rejected the plea of the assignees of a property assigned in violation of the orders to be implemented in the proceedings. The Supreme Court had declined to recognize the said transaction as it was in violation of the orders of the court. It would be debilitating to the judicial proceedings and the rule of law if any sanctity is accorded to any transaction which was interdicted by the court. The efficacy of orders passed by the courts would be seriously diluted if the transfer of property or action in defiance of the court orders are recognized to accrue any rights in favor of the transferees. In view of that, the learned single judge's order was upheld. Therefore, to conclude, my humble submission to your lordship's kind consideration is, if respondents 5 and 6 had not relied upon the sale deed to have given them the right to file a petition under 150, the case would have been completely different.
Yes.
Now that response 5 and 6 have relied upon completely the sale deed, that's contained in Mullard Annexure A, all the content, I will not read them and trouble your lordship. All the contentions of the response 5 and 6 as petitioners relying upon the sale deed and issuing the notice to the respondent number 4 to vacate the premises, they are all contained there. And I'll read only prayer portion, but though your lordship was pleased to observe that that prayer is not granted, but it shows the conduct of the person who does not have right, title and interest to approach an authority to claim right and title and interest under that very void document and seek some prayer. Whether the prayer is not granted fully or partially is a separate question. Your lordship will be pleased to get that at page 118, 118. That's the petition which was based on which the impugned order was passed by the Deputy Commissioner. Page 118.
118 is a prayer. Petition is at 113.
Please, it starts from 113. 118 is the prayer. I'll read only that prayer portion.
Yes.
Wherefore, it is respectfully prayed that the Honorable Authority may kindly be pleased to cancel the no objection certificate and the license issued in favor of Bharat Petroleum Corporation Limited, into the brackets, Government of India Enterprise, close the bracket, through its office respondent number 1 to 3 granted in favor of the said corporation immediately and report the same to the chief controller of explosives and thereby direct the respondents to hand over the possession of the petition scheduled premises by allowing this petition in the above case in the interest of justice. My lord,
Yes.
he wants to enforce his civil right through the deputy commissioner on the strength of a void document. Is my lord not permitted or is untenable under the law. And if my lord were to accept my contention, and if not, and my lord, maybe please to remit the matter back to the deputy commissioner, not at the instant, a similar case, either suo moto or on the strength of any stranger, with at present no stranger is there, but the deputy commissioner can redecide the issue without reference to the response 4 and 5. That would be my concluding submission. God bless you.
Yes, madam. You are appearing for the
Dealer.
dealer. Your role is for the HPCL. Yes.
Petroleum Rules 2002, Millers. For your lordship's ready reference, I'll give this later.
I'll book it. Yes, please.
150 may kindly be seen, Millers.
Yes.
Cancellation of no objection certificate, 150 surplus 1. A no objection certificate granted under Rule 144 shall be liable to be cancelled by the district authority or state government if the district authority or the state government is satisfied that the licensee has ceased to have any right to use the site for storing petroleum. Whether we have, this is one thing, Millers. This is what is important, because on the basis of this, the impugned order is passed. So whether I have any right to use the site for storing petroleum is the question. Kindly come to 152, Millers. 151 is before refusing grant, what they have to do is there.
Yes.
Kindly come to 152. Rule 152 says suspension and cancellation of license. Every license granted under these rules shall stand cancelled if the licensee ceases to have any right to the site for storing petroleum. So again, I fall under 152 only. Then Miller, second one, your lordship may kindly say. The second one is stand cancelled if the no objection certificate is cancelled by district authority. So these two go together in a way, 2 and 1.
Yes.
Now in the backdrop of this, Mellors, I would like to take your lordship through a judgment of the Supreme Court, Mellors. It's in Nandaram's case. Before that, may I request your lordship to kindly see the order sheet of this honorable court, Mellors. In this case, order sheet detail.
In which case, madam?
Ida case, Swami, 23, sorry, it is 25/5/25 of 2025. First day's order sheet, Millers. Howdo. 21/8/25, Millers.
Lordship Justice Shyam Prasad order.
21/8/25.
ಅದರಲ್ಲಿ ಸೆಕೆಂಡ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಕೊಟ್ಟೋಗ್ಬಿಡ್ಬೋದು ಸರ್. ದಯವಿಟ್ಟು.
Yes.
My legal argument is based more or less on this. This court must observe that it emerges rather eminently that the petitioner is running a petrol bank claiming dealership arrangement with tenant BPCL. And it could also be that lease has expired, but then the first respondent ought to have examined the rights of a tenant to continue in possession even after the expire of the lease period. The tenant, even after the expiry of the lease period, can be tenant holding over or a tenant at sufferance. Sufferance ಬರಬೇಕಾಯ್ತು ಇಲ್ಲಿ, depending on whether there is express or implied consent or the continuation is without consent. That's one point of it, Millers. I stop it there. That was what was considered at the point of time of admission of this writ petition. Now I would like to rely upon a judgment of the Honorable Supreme Court in Nandaram's case, Millers. Sir,
Yes.
Your lordship may kindly go to para 38 minutes, page 421.
38. Yes.
421, top, on the top of the paper it is there. 38 has reference to another case and paragraph 45 of that is there. That your lordship may, because I don't want to take your. Section 108Q thus ensures that a lessee continues to be liable to the lessor till possession has been actually restored to the lessor and a semblance of relationship subsists till that contingency takes place. His continuing in possession is expressive of his continuing stand that the tenancy in whatever form continues. It is said that he does not hold it adversely to the landlord, only till he has unequivocally renounced his status as a tenant and asserted hostile title, but even that appears to be doubtful, for in law his possession remains permissive till it has been actually restored to the landlord. Kindly come to next page, my lords. 48, para 48. Fourth line from top, my lords, in para 48. A tenant remaining in possession of the property after determination of the lease does not become a trespasser, but continues as a tenant at sufferance till possession is restored to the landlord. The possession of an erstwhile tenant is juridical and he is protected from dispossession otherwise than in due course of law. Although he is a tenant, but being one at sufferance as aforesaid, no rent can be paid, since if rent is accepted by the landlord, he will be deemed to have consented and a tenancy from month to month will come into existence. Instead of rent the tenant at sufferance, and by his mere continuance in possession, is deemed to acknowledge both the landlord's title and his liability to pay mean profits for the use and occupation of the property.
Yes.
Now, my lords, in this background, again, I request your lordship to kindly see annexure A, my lords. Annexure A, page 25, my lords, in my writ petition, page 25. It is at the instance of the purchasers. That's one point. Kindly come to para.
Your
29.
arguments are at the instance of HPCL.
In a way, we are
That's
both together. We are. I am not hiding any of these things. We are together. 29 may
No,
kindly
but
be
you don't have a separate argument like this to be addressed because you have no lease transaction or anything. So this argument is essentially supporting the case of HPCL.
that could be taken, but all that could be taken here is, my lords, I would rather, with due utmost humbleness and humility, I would like to submit this. We are all working for a cause, and we are just seeing whether what is there, whether that by whom it is agitated is not the question, but what could have been done, what could not have been done. It is
Because the question of locus was raised for them. The locus would also equally apply to all of you when we deal with each of your submissions. Because in this matter, when you are raising a locus issue on, it will be equally applicable to everybody.
Please, Manas. Then I would rather answer that question in this line, Manas. If BPCL is an agency, Manas, that's one thing. And through him, I have come here. And whatever holds good for him, it also holds good for me. So there cannot be anything that I cannot be thrown out just because I have come through him. Because ultimately,
That's why we asked you. This is the argument you are advancing on behalf of BPCL.
On behalf of dealer is because the BPCL has given me that dealership.
Okay.
That's
Yes.
my submission. Now, my lords, this
We'll deal it. We wanted to be clear as to how to deal with it. That's all.
fair enough. Para 29, my lords, last paragraph it says, lease avadi mugda hodmelu saha
Yavadu
nimitra
para?
madadu."
Page?
Page 29, my lords.
29.
Improved order, last paragraph.
29.
Page 29 of my writ petition, my lords.
Oh, sorry. We are having their writ petition.
I'm sorry.
Yes.
It's an impugned order, my lords, in any one of the writ petition. Last paragraph is the reasons assigned, because in 150 what they say is they have to assign reason. This is the reason assigned. ಲೀಸ್ ಅವಧಿ ಪೂರ್ಣಗೊಳ್ಳುತ್ತಿದೆ, ಸ್ವಾಧೀನ ಬಿಟ್ಟುಕೊಡುವಂತೆ ತಿಳುವಳಿಕೆ ಪತ್ರ ಕೊಟ್ಟಿದ್ರು ಸಹ ನೀವೇನು ಮಾಡಿಲ್ಲ. ಆದ್ರಿಂದ ನಿಮಗೆ I put this question to myself, whether lease ಅವಧಿ ಗೊಂಡಿದೆ, ಆಮೇಲೆ what should have been done, what should not have been done. Could DC have gone into those aspects is one thing that I put that question to myself. Another question here is, your lordship asked one question to my learned senior friend, that whether a specific performance case is filed by you seeking continuation.
Is there a, first of all, right of renewal? And if there's a right of renewal, whether there's a specific performance suit filed?
Till 2023, we had the right to continue in, I mean, there was, nobody could have questioned us. 2020 itself, they filed a suit. And then we were asked to, the BPCL was asked to deposit the rent in the court. That has been continuously being done. So that's where, my lords, even assuming for a while today we have to hand over possession, the application, very application,
You don't know who to hand over to.
that's also there, number one. Number two is that, my lords, the subsequent purchasers kindly see their application, my lords. Their application, their petition before the DC is not just to cancel NOC. They also seek namak possession kodi anta kelidare, whatever it is. Now, to whom we have to hand over, we don't know. Till then, at least my right should be protected is one aspect. Third is, my lords, had this subsequent purchaser not approached DC at all, probably this wouldn't have arisen. And then
Already that has been argued. Yes.
Pardon me.
That submission was made.
That's where made. Supporting those submissions, my lords, I have
Normally, in all matters, each party argues for himself.
That's all, my
In
lords.
this matter,
I will
everybody
just-
is arguing for HPCL.
Now, my lords, one
Same set of arguments will come.
Surjit Singh's case judgment, my lords, I'll just mark the paragraph and give it to your lordship.
Yes.
That is Kodi Surjit Singh's case.
Surjit Singh already NIM ಯಾವ್ದು ಹೇಳಿ?
ಹೌದಾ,
That is the
ಮಾಡಿದ್ರೆ ಸರಿ
extract,
ಬಿಡಿ.
sorry.
ಹಾ.
Ella, you,
ಸರಿ, ಹಾಗಾದ್ರೆ
madam
ಅದು
is
ಬೇರೆ.
giving Surjit Singh only, you are refer to the
ಹೌದಾ.
extract. Yes, madam. Surjit Singh, what do you want to refer to?
To paragraph 4, my lords, page 52.
Para 4.
Para 4, page 52 of Surjit Singh's judgment. 12th line approximately. Treat alienation as having not taken place at all. If it is in violation of the court order.
Yes.
And Ramdas case one put. Brother.
ಒಟ್ಟಿಗೆ ಕೊಟ್ಬಿಡಿ ಎಷ್ಟು ಸರಿ ಗೊತ್ತಿರಿ.
My lords, co-sharers right, my lords. Assuming for a while he has purchased co-sharers right. Then para 17, my lords.
Yes.
A co-sharer cannot put the vendee in possession. Why I am referring to this is, they have transferred, notwithstanding there being a court order, and they cannot allow them to initiate action against whoever is in possession, because all of them should join, and then his right is only to seek a
Partition.
general partition. There is one judgment of a coordinate bench of this honorable court, which I would like to place before your lordship, my lords.
Yes.
My lords, this is para 30 to 36, your lordship may take. This was in a way in a different context. Here the para 18, if your lordship so to see page 13, internal page 13, para 18. This was a case where he was ordered to shift the petrol bunk. I wanted to be clear with regard to the facts of this case. It is different, but I am para 18. Could your lordship lay hand, my lords? It was
Yes.
This was in that context this came out.
Para 18
Para 18 is this petitioner, the petitioner is thus
to
before the,
shift the,
to
yes.
shift the petrol. That was the context, because tomorrow the context is different is what I am bringing. Para 30 is one thing, Millers. NOC is issued under the rules. Could your lordship may have it?
Yes.
Page para 30. Only for establishing an outlet for the first time, and there is no concept of seeking for an NOC periodically. The rules of 76 to 2000 and 2002 no doubt provide for withdrawal or cancellation of the NOC, but that can be done only if the licensee has lost the legal right to utilize the land. Who has to determine this is the question that I put. DC cannot do this is my humble submission, Mellors.
Yes.
And para 32 and 33, that's in continuation of that. Why NOCs? That's all, Mellors. That's all. That's all. Grateful.
Yes, madam. When will Mr. Kumar be here? Hello.
My lord, I appear for petitioners in 41, my lord.
It's Monday.
Much obliged, my lord.
The Senior Counsel for the Petitioner in WP 25697 of 2025. And Senior Counsel for the Petitioner in WP 25525 of 2025. For argument of the Counsel for the Petitioner in WP 23178 of 26 and the reply arguments of the contesting respondents. Pre-list on 24th at 2:30 p.m.
Much obliged, my lord.
Serial number 42. Nitin DM.
Before my learned frontier.
RTI for
She is the wife, my lord. Look,
husband is expired.
I know, my lord.
Specific
Our
performance
people-
suit is pending.
I personally, even I feel it is unsustainable, my lord. Ashimay can direct, not record my submission.
We thought you will be reasonable enough to come forward and say we'll give it
No, we'll give it, my lord, but at least there will be.
with an order of the court.
In fact, they've already given in the year 2023. It's already annexed.
Petitioner is before this court seeking for the following relief. The petitioner is the legally wife of deceased D.K. Kemparna, who was a Group D employee employed with the state government of Karnataka and expired after his superannuation. On 15/2/2020, leaving behind the petitioner and his other children. A suit in, what is the suit number?
I have not mentioned the OS number.
No,
Madam.
they have not mentioned.
Suit idu bekala, prayer.
468 of.
Idiya kodi, plaint kodi.
Illa, I don't have a copy of it, my lord.
We need the plaint to substantiate the reasoning.
Sorry, I don't have the plaint at present, my lord.
Plaint and exactly what reason you will need this pay slips for. We need to give that reason, alva, as an exception. Monday kodtira?
Monday.
The counsel for the petition seeks for 2 days time to place on record the plaint in the pending suit as also written statement filed in the said suit.
27th is my suit. Maybe on Monday, and the priority it would be because 27th is the suit.
At 2:30 p.m.
Yes, ma'am. Deeply obliged.
4:30.
Number 3.
Yes, Mr. Surana. Password. List two password.
Past door matters. List number 2. Serial number 1. Srikara PK.
We need 2 weeks time. My senior is just outside.
2 weeks time.
At least 1 week time to confer with them.
Both the councils submit that the amounts which are due have been determined and agreed upon between both the parties. However, the time for payment as also time for vacating of the premises by the petitioner has not been agreed upon. Released on 27th August.
Interim order may be next.
Interim order earlier granted is extended till next date.
Much obliged.
Serial number 3.
I appear for the respondent. 35,467. Normally, I am filing the objections.
35,467, you are filing your objections now.
Objections hakila. Renuka was appearing. Only last time we took the copy.
Council for respondent one
One more aspect
objections
is
in WP number 35467 of 25. Yes, sir.
one more aspect is my friend has not filed the complete agreement. I am passing on the complete agreement.
Has not filed complete.
Complete agreement is like that.
The
ಕೆಲವು
PDF
page
Purana has
missing
also
ಇದೆ.
filed a complete agreement entered into with the primary lessee.
First agreement.
I only placed an article and said it so in my writ petition. The relevant portion is only produced. My writ petition, I said that it is relevant portion only I produced.
Our full code paper ಜಾಸ್ತಿ ಇದೆ ಅವರದ್ದು. The said lease agreement. There is a sample lease agreement for each of them.
No.
Format.
I have filed full, my lord. ನಂದರಲ್ಲಿ ಅವ್ರದ್ದು full ಇದೆ.
The lease agreement is what?
Online. I could get, now I could connected. ಆಗಲಿಲ್ಲ connection.
Just a moment, Mr. Sharma, one ನಿಮಿಷ.
ಸರಿ ಸರಿ.
The deed of license which was entered in the first instance will govern the rights of the parties because the extension is only granted on that terms only.
There are different licenses entered into with each of them.
No, yours ಬೇರೆ ಇದು. ಇದು single agency. There is no concession was given earlier also for single agencies.
Ian, what is it that you are producing?
Single agency is the entire complex is given to them for management. So therefore, the agreements were entered with such licenses are different. My lord may kindly look to page 40 and 41. ಅದಕ್ಕೆ ಮುಂದಕ್ಕೆ pages ಇಲ್ಲ. Agreement ಇದು ನಮ್ಮ ಸ್ನೇಹಿತರು ಹಾಕಿರೋ ರಿಟ್ಮಿಷನ್ ಅಲ್ಲಿ.
This aspect we will deal with because you give one license with somebody, within 15 days he does everything with everybody else.
ಅದಲ್ಲ. See, license is given to a place or a shop. There are different terms. In the entire bus stand complex, nobody, entire bus stand complex, wherever the TMC buildings are constructed, that is transit management buildings, all such buildings are given on a license basis to single agency. So they are permitted to sublicense the premises.
Correct.
That is the term of the agreement between us.
So this is the license agreement you are producing?
Yes.
For what purpose?
To show that they cannot claim any concession in the COVID period unless they work out the remedies available under the agreement.
With the licensee?
License.
No privity of contract with you?
No. The petitioner who is a licensee, if you want to invoke the force majeure event, he has to comply with certain conditions. If he has not complied with the condition, he can't.
You bari agreement kotre agala. You will have to tell us what clause
yes.
you want to refer to.
Yes. Kindly go to page number 47 of the agreement.
Notes.
Bottom of the page.
Notes. 40?
47.
Number 38 in my report.
See, the first is they must as soon as practicable, and in any case within 7 days from the date of the occurrence of force majeure event or the date of the knowledge of thereof, the affected party shall notify the other party of the force majeure event, setting out inter alia the following in the reasonable time. So if the notice is given, other procedure can be followed. And then kindly go to the last 8.5.
8.3.1.
Last two lines in 8.5. At page 42, 50. At page 50. last two lines, four lines, three lines. Except as specifically stated to the contrary, no party shall be relieved of its obligation under the agreement by reason of impossibility of performance or any other circumstances whatsoever. So unless he has sought for any relief under the agreement, he can't seek it under now. Now, if the force majeure event continues beyond 30 days, then the parties are at liberty to terminate the agreement. 9.4 at page 54. So,
Yes.
in the event force majeure continues to impede or prevents a party performance for longer than 30 days from the commencement of such force event, notwithstanding suspension of the obligation parties, they shall decide by mutual consent through consultation either the term upon which they continue the performance of the agreement or to terminate the agreement. If the parties are unable to agree on such terms or terminate the agreement by mutual consent within 120 days from the date of the commencement of such forceful agreement, either party may issue a notice of the intention to terminate. Once the intention to terminate is issued, the agreement can be terminated. Therefore, nothing has happened in this case. Therefore, he has not invoked the force majeure clause under the agreement, and under the agreement, he has to work out his rights.
Yes.
Therefore, he can't seek any concession, even under the agreement. That's my submission.
ಏನಾದ್ರು ಇದೆಯಾ? Reply arguments of Shri P.D. Surana reserved.
One submission I want to make, my lord.
Yes, Ms. Sharma.
One submission I want to make is regarding the citations he referred to. Last time I took time. Your lordship may kindly see. I have stated that he is stopped from withdrawing the concession which is already given after we have acted upon that. The regular business was not going on, so a question of notice and other things did not come. Then they offered, and the very same authority who signed the agreement is the person who has offered. And after that, we continued. And in January, I said I will not be able to continue. 4 months notice is given, and 30th June I vacated. This is the fact. So this withdrawal of concession given is not available to him. They are stopped under 115 of the Evidence Act. And this is supported by judgments. I am saying this is one thing. Another is he has referred to some of the judgments which I will reply. My colleague had sent some judgments, my lord. They only to show that. I could not get connected. Sorry, I'm.
ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ ಸುರಾನ ಅವ್ರಿಗೆ?
ಅಲ್ಲ, ಇವಾಗ ಇಸ್ಕೊಂತೀನಿ.
ಅವರ ಕೊಡ್ತಾ ಇದ್ದೀನಿ, ನಾನು ಕಳಿಸ್ಕೊಡ್ತಾ ಇದ್ದೀನಿ.
ನಾನು ಅವ್ರು ಕಳಿಸ್ಕೊಟ್ಟೆ ಇಮಿಡಿಯೇಟ್ಲಿ.
ಅಲ್ಲ, ನಾನು ಹೇಳ್ತೀನಿ ಅದ್ರಲ್ಲಿ ಏನಂತ ಹೇಳಿದ್ರೆ
ಅಷ್ಟೇ.
ಇಲ್ಲ, my only submission is, your lordship, I don't want to take your lordship's time on that. I am only saying that there is an estoppel in this case where we worked or continued the canteen after the concession was given at a lower rate. Otherwise, he would not have continued. So after acting upon the representation made and concession given, if I have acted, then they cannot withdraw the concession. This is the point I want to make. Your lordship may kindly go through the judgment. This is what I want to make.
These judgments will not be applicable.
You don't know.
I have looked at it. It is a general submission made by a friend. These judgments will not be applicable because the authority, the person who it is the intra-department communication.
One nimisha, I may complete.
On the ground of intra-department communication.
Mr. Surana, I will complete. Nodi, what I am submitting is that whether it is general or in this case it is not general, it is a specific case where they have given concession and I have acted upon that. So they are stopped from withdrawing the concession. That is estoppel 115 Evidence Act. That is one thing. For that judgment. Now, my lord, he has given certain judgments. For that, I want to reply. Last time I could not reply. Your lordship may kindly see these judgments of my learned friend, what he has produced, they are not applicable to the facts of these cases. This case, because the reason is simple. What he says is it is an administrative order. It could not be acted upon, etc. What he says, it is not so. It is not administrative or circular. It is a definite offer made by the divisional controller, who is the authority. Divisional controller is the authority who signed the agreement. He offered the concession. So he cannot say that it is a administrative order or a circular on which I will not be able to get the concession. Number one. Number two, that was not offered with the condition that it has to be approved by the government or somebody else. That was not the offer. His judgments are the government is not accepting it, so we want to withdraw. That cannot lie. That one thing. Next, my lord, all the judgments which he has referred to will not be applicable to this case because it is not, this concession given is not against any law. If it is against law, estoppel will not be applicable. Your lordship knows, no estoppel against law. There is no law prohibiting the KSRTC giving concessions because the vis major or whatever the word used, a calamity which was never thought of, which is admitted, accepted by everybody in the universe. Such a concession given is not to be withdrawn. That is my submission. And those judgments are not applicable to such a case because it was an offer made after by an authority and we have acted upon that. That is why his judgments are not applicable to the present case. That's what I said. Individual time waste. I don't want to waste. Your lordship, this is the gist of my reply to all his judgments. Your lordship, there is no law which prohibits the very same authority who has signed the document agreement to give concessions, and it is not a authority person unauthorized. That is why his argument is not applicable.
He was held out to be authorized.
Yes, my lord. He is the person who signed the agreement in my case. Yes. That is why it is an authority given and it is a proper one we have acted upon. This is all my submission, my lord. And other things, calculation, one calculation mistake they have done, my lord. They have deducted not only the concession withdrawn, they have added interest at 2% and odd. That amount is also added and deducted.
What was your submission there? Calculation, what is your submission regarding calculation?
Calculation is like this, my lord. Initially, one nimisha. Initially when they offered or sent a letter saying that we want to withdraw the concession so much, that letter I have produced. That amount is not the one they have deducted. April 25, I have filed a memo along with the check. Your lordship, last time I pointed out, it is noted in the order sheet. There they have deducted more. Whatever may be the amount through the check, the amount security deposit they have to deduct. They have deducted more. Whatever it is, the balance they have to refund with interest. They are calculating interest at 2% per annum, and they have delayed after June 22. I have vacated, and a new person from July operating already, and up to June, from June up to December when they offer that 6 months they have to pay interest. They have not done that. Amount, even admitted amount, they should have paid interest or kotila. That is the calculation I am referring to.
Mr. Surana, what do you have to say about this calculation?
So far as 4 months license fee is concerned, it is deducted and thereafter the amount is paid. Last time my friend made a submission that we have paid the amount up to June 2021. If any amount is paid while deducting 4 months rent, we will give the concession to them and refund it. They will produce the document.
Do a reconciliation of accounts.
Reconciliation account, and my client may also give a representation that he has paid so and so amount under so and so voucher.
Heard. Reply argument, further reply arguments of Shri P.D. Surana and the rejoinder arguments of Shri Vaiken Narayan Sharma, Senate Counsel, on behalf of the petitioners. Reserved.
I'm sorry, I could not get connected earlier when it is passed over. Some mistake, I do not know.
Yeah, no problem. Allah, Surana or Idlila anta pass over agide.
The
last ballot.
Nimmindal. Allah, aurilla anta pass over aitu anru illa.
At the last it reached. At the last it is
over finally.
It has heard before many benches.
Serial number 4. Imran Pasha.
Alternative land we have identified.
You get all the difficult matters.
My lord, now they have expressed their inability to remove the encroachment. They are offering me an alternative plot, but subject to confirmation.
You have seen the plot?
No, my lord, I will ask in party. Today only they have said the copy. Now they have said the copy, my lord.
Read counsel for respond 2 to 4. Submit that an alternative plot has been
Nearest industrial area. Agadiyat Kaval industrial area.
An alternative plot has been identified. And in that regard, a memo has been filed placing on record the sketch,
And
the
also plot number.
sketch and the details, sketch identifying the location as also the plot numbers. ಇದೆಲ್ಲ correct ಆಗಿದೆಯಾ?
ಬರ್ದಿದ್ದಾರೆ unlitigated ನೋಡಿ.
ಹೇಳಿದೀರಾ?
We can verify. then.
The counsel for the petitioner seeks for a week's time to visit the said plot where identify the location and the suitability thereof and his agreeability thereof to take the alternate plot. Relist on 27th.
Obliged.
Lord, it is 1 acre, my lord. We allotted 38 guntas. Now it is more than what?
ಎರಡು ಗುಂಟ ಜಾಸ್ತಿ.
Difference.
Will go in Karab also. my lord, sir.
ಎರಡು ಗುಂಟ ಜಾಸ್ತಿ ಕೊಟ್ಟು.
Differential allotment.
ಆಯ್ತು.
Serial number 6. Yes, Rajshekhar.
You arranged everything properly?
My lord, I've arranged, my lord, but there is no order or a policy that these people have followed, the government, my lord. What has happened is, my lord, I'll fairly submit instead of going on. It's only, what has happened is this petitioner was supplying, and it is a commercial gas cylinder that they purchased, my lord. Now, and it is purchased by the Women and Child Development Authority for the benefit of the Anganwadis. The other respondent, the contesting respondent here is a late entrant. Subsequently, he is allotted a gas agency. my lord. Now, in between, they have a policy which says they have territorial jurisdiction. my lord. Now, for us, my lord, it's only cost. My lord, whoever gives us without the transportation, both of them are giving without transportation. But that they will have to convince to the court, depending upon the rules between themselves, my lord. As far as the government is concerned, my lord, we have transferred those based upon his request, saying that I am the agency holder.
Can you be doing like that? Tomorrow somebody else will come and say, they'll transfer this.
Migration is not allowed. Whatever the petitioner is also referring to order, there they said the bulk migration cannot happen by an order. Now here, my lord, the letter issued by the IOC also says that it is the prerogative of the customer. Now, if the state is the customer, my lord, for us.
Therefore, please get instruction, file an affidavit of the concerned person. Because if you are going to say that somebody comes and makes a request and you will accept it,
No, my lord, not
that will
only
be
request, my lord,
complete
what-
discretionary power.
No, my lord, what
You
has
don't have.
happened is, it is not just mere application, my lord. What has happened is, the contesting respondent has gone and given complaint against the officer saying that they are favoring but that does not.
So tomorrow another complaint will be
Yes, ma'am.
filed.
No,
You will
but-
get scared of a
but-
complaint
but
and
not-
do something.
But then as per the discretion, my lord, the customer is free to buy from whichever agency, my lord.
You are not. You are the state.
No, we are a customer.
You are not a mere customer.
No, consumer, I am a consumer.
You are not a mere consumer. As Mr. Jaffer, you are a
Yes,
pure
madam.
simple consumer. You can do
No,
what
in
you
that, but in that case,
The
my lord,
state.
in that case, my lord, the petitioner has given the letters of the Anganwadi workers, my lord. They do not have no authority. In fact, my lord, we have to initiate action against those
take
people.
action. We are not coming in the way of that.
And
When you are making a decision to transfer something, out of which there is a financial benefit which could accrue. If you are,
as of now, my lord,
if there is no
since-
financial benefit, that is different. There is a financial benefit which accrues on the basis of a decision made by your officer. It has to be supported by
now, my lord,
reasons.
now, my lord, there is no financial benefit from either of them. No financial benefit to the state.
To the officer, we don't know. Why
That-
should he
that, my
choose
lord,
this particular person?
None of
The
them. my lord.
presumption would be that.
Yes, my lord, that is the
Unless you
presumption.
are able to.
After
show
seeing the
from
file, I
the
also presume that that is
records.
this one. What has happened is, my lord, those Anganwadi workers have given letter to both the people. One is recommending them and the other is they both are satisfied with this one. Now, as far as what my lord has expressed and what fell from this court, my lord, I don't find anything of that sort in the file because they have not taken a policy decision. There is no order. What has happened is he was the distributor. Initially, we had connections with him. We are the consumer. I mean, the state is a consumer with him for the benefit of the Anganwadis. Now, my lord, the Anganwadi workers have no say, or even they have no powers to give the recommendation letters. Whatever they have produced, the recommendation. Of course, we have to initiate action against them. They have no authority to do so. Now, the other option is, my lord, now there is no financial benefit from either of them. Whatever is the prevailing market. At best, what is happening is the contesting respondent is telling before the court that I enjoy the benefit of being the closest to these Anganwadis. one thing. He is the one who initiated all this letters, requests, because we did not want to
On
disturb.
record, the total number of Anganwadis, how much of the gas cylinders are used and how many,
Four gas cylinders per Anganwadi is the consumption for the entire
and
year.
how is it distributed amongst the suppliers?
There are about 373 in the entire district, 373 Anganwadis in the district. There are several other things. Apart from these 16, the contesting respondent also has some supply orders from the state.
So is it equally distributed?
It
If
may
that
not,
is
it may
also
not
there?
be equally distributed. There is one more distributor from the file which I saw, there's some Mahalinga distributor, he's not before the
So you
court.
get those details.
That details I
Because
can place before the court, my lord. The only thing is, the my lord,
First aspect, you say there's no application. of
no,
mine.
no.
That is, we'll.
My lord,
hear
what they have
them
done
on
is
that.
territorially, whoever is available, my lord, what happened? The distributors, my lord, this is a dispute between the distributors where we are being
There is no.
getting involved.
I'm
My
sorry.
lord, what has happened is, my learned friend, he was the first distributor as per my instructions. We were purchasing from him. Subsequently, this distributor has come. He says territorially, I'm closer to you, I will supply. Now, my lord, ultimately, they both are supplying at the same price because it's a commercial cylinder. My lord, then he has agreed that free of cost, he will transport. We have no issues. As far as the supply does not, each of the consumption is about 4 to 5, maximum 5, not beyond 5, each of the Anganwadis. So now there are 16 Anganwadis. Now, if lordship, whatever is to be placed before the court, I can place the number of Anganwadis and total number of connections with each of the suppliers, not also on those distributors who are not before the court also. All the detail I can place before the court. Then it's up to the court.
Then we'll know, at least from that, if you are.
Now, my lord, on a later vein, my lord, now that they both are before the court, we will buy from who will give the lowest price.
My lord,
My lord, one
may.
small submission, my lord.
You don't issue tenders for this or?
No, there is no tender. That's what I was about to tell, my lord. We have
Let's,
to.
may I make one request?
My lord, the petitioner's agency was established 42 years old agency in the year 1982, my lord. My agency was allotted to my father based on the ex-military category, my lord, and he was allotted just 5 to 6 years before, my lord. And our trading area jurisdiction, as per our agreement, as per the Ministry of Petroleum, is Upinangadi, which is very closer to this connections, my lord. And petitioner has already transferred. He has no legitimate expectations on the consumer. The consumers, as per the agreement, is belonging to the OMC, oil marketing company. It is their wish and will to select whichever distributor they want. And my lord, I have the RTI reply where they're charging the transportation charges of 160 Anganwadi connections, which the petitioner is supplying. And my demand is just mere 16 Anganwadi connections.
You place it on record, whatever
It
you
is on
want.
record, my lord. It is
You
on
placed
impleading
it, then
application
fine.
and statement of objection. My request is just 16 Anganwadi connections in my trading area where he's supplying 170 Anganwadis. I'm not interested in those 170 Anganwadis.
We'll have a look at how many Anganwadis and how many cylinders are being supplied. Is it rationalized across all of them? And in what manner they are doing it? We'll look into all of it. Because we are not impressed by this way of filing a letter request and you doing these things.
Yes.
And if there's any particular
I'll
policy
place
that
it
you
on
want to
record.
come up
Total-
with how to handle this,
Yes, sir.
so that in future there are no issues on this.
With the,
You can get from the principal secretary what he wants to do and file that affidavit also.
very well.
So that how a policy which is transparent for everybody.
My lord, one small submission. Just few days back, my lord, 7 days back, Allahabad High Court has passed a decision, my lord. Same way the petitioner has said, Nanna Seva Tripti Purvakavagide. All the agencies, petitioner, similar way, all the other agencies have used those same term and line. My customer service is satisfactory, but the Allahabad High Court and the other division benches of Madras High Court, Patna High Court.
You have placed those judgments
Yes,
on
my
them?
all have held that.
When will you file this, Mr. Jaffer?
2 weeks, my lord. 2 weeks.
2 weeks.
But the principal secretary, my lord, if I have to file. Affidavit with regard to the, number of connections and how we have, number of people we have distributed.
We
That
prefer
we will
that
file it within
let the
4
principal secretary take a decision as to how he wants to.
Yes, sir. And then
run
I
his
have to place,
department.
yeah, then I'll have to place it before the
You'll
principal
have to
secretary.
place it. So let him apply his mind.
Fine, and then
Since earlier there is no application of mind.
application of mine.
Let him do it. And he
My
can
lord,
issue
one more
the
small
instruction.
thing, my lord. My lord, based on the joint director's midday meal scheme, who's the head for this midday meal, based on his representation, my father had represented this 7 years back, my lord, in the year 2018. Based on that, they were consulted. They didn't agree to supply free of cost, which is there in the RTI reply. And on that, the CDPO after 4 months passed an order stating that this is the nearest gas agency. You have to
This is
supply.
a problem which will keep happening.
And my lord, based on the
If you
CDPO,
want to do a tendering system, do a tendering system.
Tendering system.
Yes, my lords.
So that everybody is there for each district, or however, like how you are doing the food grains.
Yes, ma'am. Yes, ma'am.
This could be another part of it. Without
What ran into my
KTP
mind
being
also, my
followed,
lord.
you can't be doing this.
Yes, ma'am. For a limited period, because the prices are governed by the IOC.
Yes.
So that there cannot be anything. Only thing is, when a territorial jurisdiction, free of cost, without charging any transportation to the government, they have to supply to all the.
my lord, there is one more thing, my lord.
That
In
was,
the-
My lord,
that
that was
notification
prior
there
to
is
the
a
circular.
policy decision where he's
My lords,
on that basis he's allotted a gas agency himself, where there is a ceiling limit for a gas agency, whereas he's having 40,000 consumers, my lord. Now if he's
He
given a
cannot have
tender,
say in
he will have
that
more
matter.
consumers, then there will be only one agency in the entire district that is him, my
IOCL is
lord.
a party to these proceedings?
IOCL is
IOC
not a
is not
party.
there.
my lords.
IOC may also may
It's
be.
a-
a
My
necessary
lord,
party.
40,000
my
limit,
lords,
his
sir.
own writ petition states that
opinion
his
that-
limit is
But, sir,
10,000.
may I make one request, my lords? All these submissions, my lords, I can understand if government makes, my lords. As a rival, my lords, business entity, he cannot make such a contentions. That too, my lords, I'll
All lawyers will make whatever submission, we'll deal with all the
please,
submissions.
my lords. Now, my respectful submission is, my lords, even according to private contesting respondent, my agency is, my lords, 42-year-old agency, my lords. I've been supplying with to various consumers. Just because, my lords, now about 4-5 years back, my lords, he was granted or allotted with agency. That does not mean that, my lords, he can go and approach any government agencies, authorities, requesting them to hand over, my lords, the gas consumers. And pursuant to that, my lords, he goes to Lokayukta and files a complaint. Lokayukta, my lords, even the order itself says, my lords, Maukika Adesha. On that basis,
That is why we are asking the.
yes,
principals to
even, my
look
lords,
at
I have verified the records, my lords. There, my lords, except his complaints. Nothing else is there on records except, my lords. His
My lord, I have submitted.
One second.
I have submitted before the court.
Then, my lords, my respectful submission is, my lords, kindly see the impugned order for a
it.
moment.
Not looking at anything right now, let it come.
Let them come file.
Being of the considered opinion that Indian Oil Corporation Limited,
My lords, in this case, my lords,
who is a
HPC.
HPC,
IOCL, HPCL.
HPC. Hindustan Petroleum.
HPCL, my lords.
HPCL is required to be brought on record. HPCL being the, you are only buying from HPCL, not from others.
No, because the HPCL distributors are there.
Nobody else supplies gas.
My lord, there is no other agency nearby. Based on the unified
No other
guidelines,
agencies, my lord.
there were
The agencies
5
have
agencies
territorial
allotted.
jurisdiction. my lord.
Agencies are there, my
As far
lords.
as my, every taluka now they are giving agencies, my lord. There's something from rural things. What they have done is there's a ceiling limit. This is out of the, not with to our cases, my lord. Every rural areas, my lord, they have this new agencies that have been taluka.
You
level.
are getting supply only from HPCL.
HPC is available to us. It is.
HPCL is required to be brought on record since it is the ಏನಂತಾರೆ ಅದು OMM.
Oil,
ONG, Oil Corporation,
Oil market.
OMC, oil market.
Oil
OMC.
Marketing Company,
Committee.
of which the petitioner and respond number 4 are dealers. Said HPCL is brought on record as respond number 6, counsel for the petitioner to carry out necessary amendment and file amended cost title. HPCL Garo?
Sharat Gowda.
Shri G. Sharat Gowda is directed to accept notice for respond number 6, counsel for the petitioner to furnish.
AG ಆಗಿದ್ದಾರೆ ಅವರು. ಶರತ್ ಗೌಡ, if I'm not wrong, he is AG ಆಗಿದ್ದಾರೆ ಅವರು. Yes.
Is directed to furnish 2 sets of the petition along with annexure on said counsel. The HPCL is direct placed on record the policy applicable to each of the dealers. If there is a upper limit of the number of connections that a particular dealer can serve, and if there is a territorial jurisdiction and or limitation for such service. Lord AGA is directed to bring the above matter to the notice of the principal secretary, cooperatives,
The food and civil.
Food and civil
supplies, who is requested to look into the matter and file an affidavit indicating the policy of the state as regards availing of gas connection for his Anganwadi
kendras.
centers and or any other centers where gas connections are availed. whether there's any change in the said policy proposed. If so, what is the change? As also placed on record, the total number of Anganwadis in the state of Karnataka, the dealers from whom the gas connections are obtained for each Anganwadi, the total number of Anganwadis which are attached to or avail gas connection services from any particular dealer, and such other details as may be relevant thereto.
For this taluk, my lord, for this taluk.
Let it be for the entire state, my lords.
Agle sari hoga. Agle 42,000 gottagadu.
Adalla.
Bari talukal 42,000 iralla. That will be again a misconstruction of that.
42
Consumers, total consumers.
Entire domestic consumers.
Entire domestic consumers.
Released on, by when will you file this?
2 weeks, my lord.
2 weeks, Andre? 15th September? 15th September.
Till then, interim order.
My lord, one small submission, my lord.
Yes.
There is already a circular of Food and Civil Supplies DD, my lord, telling that whichever connections are there, whichever are within after 15 kilometers has to be transferred to the nearest gas agency. I've submitted that also, my lord. Already the Food DD's circular is there.
Yes. And how that has been implemented also is. Yes.
Not at the cost of asking, my lords. If I'm supplying, somebody else comes and requests transfer this, that should not be the policy of the
There's
state.
some identification which is there,
Yes.
and that is available. That whole area within that radius or diameter would have to be.
See, to the entire area, they should transfer, not pick and choose, my lords.
Correct. If that is a taluka which is assigned to a particular this one, that
particular
taluka.
place, then that
Some
taluka or
policy
some-
would have to be there.
Yes.
Not
I got it.
discretionary chancellor's foot cannot happen.
My lord, petitioner actually comes from 35 kilometers to supply gas, my lord.
And I
I'm
don't
based
have
at
any
just 8
problem to
kilometers,
supply.
5 kilometers, my lord.
We are looking at seeing what is it. Yes,
Right.
next.
Interim order to continue.
Interim order.
Serial number 11.
Thank you, my lord.
Yes, Mr. Pujari, how long will you take?
I request on Tuesday. I'll find that. I'll do on Tuesday.
Madam.
Do it.
The request of the learned additional advocate general released on 25th at 2:30 PM for further hearing. So it will
Great.
come up earlier and we can close it.
Let's interim order.
Interim order earlier granted is extended till next date of hearing.
430 matter.
Yaru,
The district protection officer,
which matter?
this gas matter,
Huh?
that has to be recorded.
She,
We'll give that.
presence of she in so and so is recorded. How long will you take, Mr. Ajesh?
So we take 15 minutes, man.
Hmm?
15 minutes.
Finish it off.
I'll finish.
Then we'll come back to you after that.
For the seal number 43, morning I mentioned.
Before that, like, last matter further hearing, let us finish this.
The other side is present for the program. Given the representation as per direction. COVID death compensation. 43. This number 1.
If we take up your matter, somebody else will also ask. Sir. We can't make that exception like that.
My lord, I've put together a convenience compilation of the main legal.
You're given a copy to Mr. Wu?
Yes.
Yes, I received.
Yes.
My lord, on page 1, I've just put out the legislative framework up to page 3, my lord, which I've already touched upon the last date. And then on page 3, I've brought out the rules of lease of land. And page 4, my lord, I've referred to the various lease agreements executed in my favor. Page
Yes.
5, I've brought out the mutations. Now, at page 6, my lord, I briefly touched on the directions of the division bench, where there were two aspects, my lord. Point 13.1,
Yes.
where the two questions was as to whether the land in question is a reserve forest and whether it's lost its character and has to be considered as a non-reserve forest. Point 13.2, as per the order, proceedings were not by the conservator of forests, but by the chief conservator of forest. The next aspect, my lord, 13.3, as per the order sheet maintained by the authority restricted the proceedings to examine only the issue of reserve forest and ignoring the second aspect as to if the land has lost its character and has to be considered as a non-reserve forest. In 13.4, that as per the order sheet maintained on 5/6/2013, the authority sought for documents from the Deputy Commissioner and without waiting for the documents proceeded to pass the impugned order. Therefore, my lord, my submission is there was non-compliance with the directions of the division bench in answering.
Regard the loss of character.
Yes.
Yes.
Then, my lord, apparent bias I have already addressed on the last date. My lord, point 15, what I'm placing for my lords is the evidence which was available for the second aspect, whether it has lost its character. If my lord is pleased to see the first lease, scheduled to the lease deed is specifically permitted for rubber plantation by payment of upset price. And also there was never a notice for breach of the lease in terms of the payment of rent. The second aspect, this is for around 500 acres. Then the second item, my lord, lease deed dated 24/10/1929 for 108 acres. There is no mention that the scheduled property is reserve forest and the timber value of 1,487 was paid for. Then the following page, my lord, one is the tax paid receipts. Then is the village map showing that it is a plantation. Then the rubber board certificate. Then the working plan as per section 35 of the Forest Code. Then my lord is pleased to see this letter, which is at page 139, my lord.
You could give the page number for the document number also here in this. You have given the page number, annexure number and page number of the original set.
Yes.
You could give the page number for.
Here, I'll just add. Page 139. This is in 1932. This is from the Commissioner of Coorg to the Secretary to the Chief Commissioner of Coorg. Land revenue and assessment of for 1931-32 of Sampangi Rubber, Koinad Village, remission of assessment. I have the honor to report the following for order so-and-so. The so-and-so company have applied for remission of their lands in so-and-so village. The estate superintendent represents that owing to the slump in price of rubber, they have discontinued tapping. The total area held by this company under the demise is 616 acres. And then the extent is given. And then paragraph 4, the last sentence, I would therefore recommend a remission of 50% of the assessment until the conditions improve and tapping is commenced. Then the following page, my lord, this is the reply by the commissioner. I am directed to refer to your letter dated so-and-so to say that in the circumstances stated, the chief commissioner has been pleased to sanction a remission of 50% of the assessment due by Sampangi Rubber, the enclosures of your letter. And my lord, insofar as denotification, that's at the next page, with reference to paragraph so-and-so of your endorsement number 7, dated 7th, number 7 dated 13 January 1911, regarding grant of land for tea or rubber cultivation, I have the honor to state that the Deputy Conservator of Forests, who has been consulted on the subject, is of the opinion that there is no need to deforest the land in question at present. He states that the land is thrown out of reserve forest now and is subsequently abandoned by the lessees, it will have to be reserved again. And that we may have to wait for a few years and then disforest it if it appears that the cultivation is likely to be permanent. The leasing of reserve, I'm to add, reserve forest is by section 22 of the Forest Act. So by this, my lord, they had an intention to issue the denotification but they were waiting for some time, which they have not done at the moment.
On the premise that it will be abandoned by the lessees.
Yes. That is the only reason.
What is the date of this?
This is, my lord, this letter of 1911.
9 February 1911.
1917.
17 or 11?
Yes.
17.
Yes.
Where do we? If you see on the left-hand side, from 33611 to 1911.
That's my lease. No? Yeah. This is a general letter, my lord.
The general letter, but when was the? We'll have to see it in
It's not
conjunction with your
specifically
lease.
to me. Not specific.
In the lease, leases were executed on which date?
1913. 1930.
30. So 17 or 11 was prior.
My lord, if we go back to page number.
But how do we get that this is for this particular land?
It's not, my lord. It's for, it's regarding Coorg.
Only rubber cultivation.
Tea or rubber.
Tea or rubber.
Tea or rubber. Therefore, they were waiting for these persons to, I'm just showing to my lord the thinking of the authorities, why they did not immediately issue the denotification and they deferred it. This appears to be the reason.
Yes.
My lord is pleased to see page 9. Page 9. At 15.1, I have referred to the revenue records from inception as per section 20, rule 29 of the regulations, showing it as redeemed sagu. And this is as per after the payment of the timber value. So this is what I brought out. So my lord, the next page, my lord, which is important, that is point number 16. My lord, losing the nature or character of the property as reserve forest, and also as to only if this notification itself is valid. As per the lease deed dated 12/9/2018, it is mentioned that the land is reserve forest. The extent is 116 acres. As to this lease, an exchange deed was executed on 24/6/1946, whereby the respondent authority gave the petitioner an extent of 56 acres of land in survey number 34/2 of so-and-so village in exchange for land in survey number 68. This was necessitated because the respondent had encroached in the land in survey number 68/so-and-so, which was demised under the lease deed dated 12/9/2018. This is referred to in the exchange deed dated 24/6/1946. Subsequently, a notification was issued on 5/5/1947, in which the land in survey number 68 sub numbers was described as private land in good condition. There is a reference to the effect that timber value has been paid by the petitioner for the land in survey number 34/2, land given in exchange by the respondent state in the exchange deed dated 24/6/46. On 5/5/1947, the respondent issued a notification proposing to declare land in survey number 68 and other numbers to reserve forest under section 4 of the Forest Act of 27. Therefore, land in survey number 68 were proposed to be notified as a reserve forest only on 5/5/1947. The foregoing itself evidences that the land in 68, which was the subject matter of the lease deed dated 12/9/1918, was not a reserve forest as on the date of the lease. Therefore, the nomenclature of reserve forest in the lease deed is not sacrosanct and cannot be the sole basis for determining the land to be reserve forest. Then 16.12, as per the lease deed dated 24/10/1929, it is not mentioned that the land is a reserve forest land. It is described as land. The extent is 108.05 acres in survey number 68/1. As to this lease, recitals of the said lease references that timber value has been paid. In spite of the foregoing, the impugned report at para 9 ignores the description of the lease deed and proceeds to hold that the land is reserve forest. Then 16.3, the land in survey number 8/28 and sub-numbers which were purchased, this is referenced in the mutation, which I've given the numbers, show that the land was purchased by the petitioner. As to this land, in spite of the foregoing, the impugned report ignores the fact of acquisition and proceeds to hold that the land is reserve forest. Therefore,
What acquisition is this?
sorry, it should be purchased, madam. I purchased it from the government. I purchased it from the government in auction.
Purchase under what document?
My lord, I have only the reference in the mutation where it says that it's purchased. The mutation, reference mutation at page 258, 263, 268 to my IA shows that it is purchased by me.
From whom?
From the government in an auction.
These are not subject matter of these.
So
These are also
this
subject.
also was held to be reserve forest.
So you'll have to give us the document under which you're claiming.
We don't have the document. I'll just say. These aspects, my lord, insofar as 16.2 or 16.3, where it shows that the land is land which has I paid timber value, which is therefore no longer reserve forest, etc. That also is included in the impugned order. Therefore, my lord, my submission is that the second direction by the division bench was not looked into by the authority. And my lord, the judgments, my lord, I'm not going to read it out, my lord. I just
You are not going to read it out. We'll have to read it.
I have put down the propositions, my lord.
Yes.
Yes, my lord. The first one is that the impugned order is a quasi-judicial order as it affects the rights of the petitioner. Then, my lord, it is one of the fundamental, the second judgment, one of the fundamental principles of judicial procedure that a person or persons who are entrusted with the duty of hearing a case should not be one to have a personal bias in the matter. Therefore, it is of fundamental importance that a person interested in one party, even formally, would not take part in the proceedings. The third, my lord, national agriculture, cooperative marketing. The adjudicating authority cannot defend its own decision because the objections filed before this honorable court, the order is nothing but a reconfirmation of the statement of objections without dehors considering any of the evidence given by me. The next submission, my lord, is that there are no reasons, that is Assistant Commissioner Commercial Tax versus Shukla Brothers. Absence of reasons in an order would render the order liable for being set aside. Then Parthasarthi, my lord, real and likelihood bias. The next judgment is also on the same. And then, my lord, the Narendra Singh, subsequent to the lease deed, there is no record maintained by the Forest Department to show that the land is forest land. And then, my lord, this is the last one is a judgment by my lord. There has to be an inquiry to be conducted under Section 2 of the Forest Conservation Act to decide whether the land is forest land or not. In the present case, there was no such inquiry conducted.
Yes.
And my lord, the second judgment, my lord, is the second judgment is most important. State of Karnataka versus Khadar. Revision of record of rights should be made only by way of notification in accordance with the procedure prescribed in law. Otherwise, prejudice will be caused to the person in possession. And then S.C. Gupta, the principles of constructive res judicata are applicable in writ proceedings. So whatever findings were in my favor in the previous proceedings, insofar as,
It was deemed to have been set aside by the DB once the remand was made.
yes, my lord, but insofar as the mutation is concerned, the order under regulation 29 saying that this is a redeemed Sagu land.
Yes, but the entire single judge's judgment was set
Yes.
aside and matter was remanded for fresh consideration.
Only with regarding the character, but not the mutation by that order. The 1913 order was never set aside by them. They unilaterally, my lord, decided in 2006 or so to say now this land is reserve forest. Till that time, it never showed that it was a reserve forest. Till 2006 or 2005, the revenue records always showed that it was redeemed Sagu land. It is only in 2005 or 2006
Paisari.
they decided. But they never sought to set aside the mutation of 1913. Because like I read, my lord, regulation 29, it is a little different from the current procedure under section 128 of the Land Revenue Act, where there's a change in title or reporting. And whether they have commenced proceedings under 136(1) or 136(2), unilaterally for the authority to say, now I decide that this is no longer redeemed Sagu land. I now decide that this is reserve forest. That's all, man. Grateful.
How much time will you take?
45 minutes
45.
to take through the case clause.
Where do we get you 45 minutes? Everything that you appear is important only.
All blood there, right from Aranasumurti, 27th actually,